talking about timing for briefing scheduled, corrections to the transcripts, those kinds of issues, and perhaps an agreement. He didn't volunteer this, but would be something that Anna would propose a page limit on the briefs so that we're not inundated with a couple of 300-page briefs from the joint applicants. Not saying they would do that, but I have seen that in other cases involving some of the state's larger utilities. But anyway, so we've been on the phone. We haven't reached any agreement, but I will be handling that procedural issue of the briefing schedule for Inamaria, and then Mr. Yar will go on to be listening to the witnesses in the cross, if that's acceptable.
Okay, thank you, sir. Okay, we are being live streamed.
Madam Hearing Examiner.
Mr. Dome.
Good morning, Madam Hearing
Good
Examiner.
morning.
Was just wondering procedurally what the order of witnesses you're contemplating today is. I know we start and then we get into staff, and I'm just wondering what order you're thinking about for the staff witnesses.
Well, I think that pursuant to the proposed order, it was going to be Mr. Zigich, Mr. Tupler, Dr. Blank, Ms. Velasquez, and Ms. Pohola is, I believe, what I had indicated, but Mr. Rossi can correct me if I'm wrong.
You are correct, Madam Hearing Examiner, and good morning.
Good morning.
Thank you, ma'am.
You're welcome, sir. Okay, we've got about 8 minutes. So if parties just want to talk about, you're being live streamed, but you're not on the record. So if parties would want to talk with each other about potential post-hearing writing filing dates, that would be fine. Or if you want to go get that last cup of tea, that would be fine.
Mr. Friedman, this is Peter Gould. You had indicated in the email stream that you agreed with some of our proposals. Do you want to talk about what staff would be willing or wants with respect to a briefing schedule in terms of your schedule? I know you probably have more cases on your particular schedule than I might, given the fact that you have a statewide responsibility.
Yeah, I mean, your proposals seem to be most reasonable to us. I have not had the opportunity to sit down and look at calendars and count days and such, which of course is helpful when you're talking about due dates. obviously we're going to be juggling holidays and things like that. So it's just going to be, I don't think there's going to be a win for anyone on figuring out this briefing
Yeah.
schedule.
Yeah, do you have a big hearing coming up, if you know, that might be occurring in the first part of December timeframe for your folks?
I'm not aware of, at least my immediate team for this case, of any conflicts. Not to say there isn't one, but I think this was our big fall case. So I'm sure there'll be other stuff that's coming up, but I don't think anything that would um, not allow us to be able, or prevent us from working on a brief. So
Hmm. Sydney or Kara, do you or anyone else, does anybody else have any input on what we might, so we can come up with a consensual agreed to briefing schedule and save that headache from the hearing examiner?
Um, I just want to chime in and say that I prefer Friday deadlines. Otherwise, I'm going to work all weekend.
Okay. Do you have any, Sydney, good morning. How you doing?
Good morning.
We've been having fun. I mean, this has been a fun event, hasn't
I just described it as torture to someone on the phone this morning.
it? Do you have any preferred dates for the beginning of the briefing and how much time for the response?
Um, I think we need at least 10 days for the response, at least. And the deadline, um, I was thinking December 12th, but it depends. I just prefer Fridays. I'm happy with a December deadline.
So it just occurred to me as Cindy was speaking that staff has 3 mandatory days of training in December. So that's minus 3 days that we can work on this as well.
What days are those, Mr. Friedman?
I believe they're December 1st, 2nd, and the 19th.
Okay. And is this the usual annual PRC CLE event?
I believe that's 2 of the days, and then we have a internal training end of the year thing that Chief of Staff likes to conduct on the 19th. So um, I would imagine that some of you actually would probably go to the CLE event on the 1st and 2nd. So I remember seeing some of you all there last year.
Okay, thanks. And Madam Hearing Examiner, I just note, and we can go for this on the record, but in the rule, the time for briefing, post-hearing briefing is after the completion of the finalization of the transcript. And I didn't know if you had a specific process and procedure for that to occur. So that's something that we need to consider as well.
Last transcript will be out tomorrow and should be uploaded for the rest of you. If that's what they do, I would imagine on Monday.
Yeah, thank you, Mr. Lee. But there's a procedure where parties can propose corrections. So just so we cover
On my
that.
transcript, how rude.
I know. I would be deeply offended if I was you.
You mean when people go IIF slash dash 2.4 blah blah blah, and you might have written like 2.3, like something like that?
Well, yeah, if it's substantive, I mean, you have a chance to, if the transcript shows a wrong number, if your witness said 50 million and it's recorded at 15 or something like that. So, or, anyway.
I am ready when you go on the record, Judge.
Good morning, Mr. Lee.
Good morning, Judge.
How are you?
I'm good.
Good.
I would rather be here with you people than with the finest people on earth.
How did we do, Mr. Lee, with getting our exhibits to you that we needed for yesterday's transcript?
100%.
How did we do getting you the exhibits that we needed for the day before's transcripts?
What had happened with that, Judge, is you admitted attachments separately from the actual exhibit, which got admitted yesterday. So everything's there. In other words,
Very-
do you understand what I mean?
Yes.
All right, so it's all there. I explained it to Anna earlier, so I think we're good to go.
Okay. Are there any exhibits for the prior day's testimonies?
None
Then-
that I'm
Okay. And so you have the exhibits that were actually admitted into the
Yes, Judge.
record.
Yes, Judge.
Okay. Very well. I appreciate that immensely. And with that, I believe, Mr. Lee, we can go on the record.
Yes,
Good
ma'am.
morning. We have returned from our evening recess in case number 24-00266 UT. This is in the matter of the joint application for approval to acquire New Mexico Gas Company Incorporated by Saturn Utilities Holdco LLC. My name is Elizabeth Hurst. I am one of the designated hearing examiners in this case. Along with me is Patrick Schaefer. He is the other designated hearing examiner in this matter. Along with both of us and all of us on the Zoom call is Mr. Lee, our court reporter. Should anyone need anything to do with the transcript, they will need to contact Mr. Lee directly. Pursuant to request, I would like to get the parties' appearance on the record, beginning with the joint applicants. Mr. Dubois?
Good morning. Will Dubois, Rick Elvidrez, and Dana Hardy on behalf of the BCP applicants.
Good morning. Ms. Hopper?
Good morning, Madam Hearing Examiner. Tom Dome, Brian Haverly, Juliana Hopper on behalf of Amera and NMGC, and also appearing with us is Nicole Strauser, the General Counsel of NMGC. Thank you.
Thank you. Ms. Nanasi?
Good morning, everyone. Mary Lanassi on behalf of New Energy Economy.
Good morning. Mr. Gould?
Good morning, Madam Hearing Examiner and Hearing Examiner Schaefer and colleagues. Peter Gould on behalf of NM Area. I will be handling the procedural issues this morning. My colleague, Joe Yar, will be handling the substantive part of the cross-examination. And Madam Hearing Examiner, if I could request, I'm going to be trying to format the offers of proof. So if I could go dark on my video after we do the preliminaries. Thank you.
Very well, sir. Mr. Harris?
Brian Harris on behalf of the New Mexico Department of Justice, and good morning, everybody.
Thank you. Mr. DeSalen?
Good morning, Madam Hearing Examiner Schaefer, colleagues, and witnesses. This is Charles DeSalen representing Coalition for Clean Affordable Energy. And also here is Carol Lynch representing Coalition for Clean Affordable Energy and Prosperity Works. And Ms. Lynch will be presenting our third and final witness today.
Very well. Thank you. Ms. Beatles?
Sydney Beatles for Western Resource Advocates. Good morning.
Good morning. Mr. Freeman?
Good morning, Jelani Freeman on behalf of the federal executive agencies.
Good morning. And I believe Mr. Rossi?
Good morning, Nicholas Rossi, Ryan Friedman, and Katie Lang for PRC staff. Thank you.
Thank you. I believe that concludes our appearances. We had brief discussion before we went on the record about any outstanding procedural issues. It does not appear that anything needs to be mentioned at this point in time. The parties are still discussing potential briefing deadline dates that they might want to propose. So with that, I think we can go ahead and for agreement, the next witness in this matter will be CCAE's witness. And Ms. Lynch, you have a witness.
Thank you. CCAE calls Dr. Penn.
Good morning, Dr. Penn. Welcome.
Good morning, Madam Hearing Examiner.
Mr. Lee, would you please swear the witness?
Dr. Penn, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am.
Thank you, Mr. Lee. Ms. Lynch, go ahead, please.
Thank you. Good morning, Dr. Penn.
Good morning. How are you?
Good. How are you?
Good.
Thanks for joining us. Could you please state your name and spell it for the record?
Yeah, my name is Stephanie, Stefani, Penn, Penn, and my legal last name is Harvey, Harvey, but I go by Stephanie Penn in my professional experience.
Thank you. What is your business address?
It's 2067 Massachusetts Avenue, Suite 4, Cambridge, Massachusetts, 02140.
Where are you employed?
I'm employed by Industrial Economics Incorporated.
And what are your responsibilities there?
I am a principal and partner, so I'm responsible for conducting my own business as a public health professional, as well as managing other firm activities.
And on whose behalf are you testifying today?
I'm testifying on behalf of CCAE.
Have you prepared written testimony for this proceeding?
Yes.
I refer you to the document marked as CCAE exhibit. Please let me know when you have it before you.
What exhibit number?
Exhibit 2.
Yes, I've got it.
Can you identify it, please?
It is the revised testimony of Stephanie L. Penn on behalf of CCAE dated September 26th, 2025.
Did you prepare it?
I did.
Is it true and accurate to your knowledge?
It is.
Are there any changes you would make to it?
No, I've got no changes.
Do you adopt it as your direct testimony today?
Yes.
If you were asked the same questions today, would your answers remain the same?
They would.
Are exhibits attached to your testimony?
Yes, there are 4 exhibits.
Can you please identify Exhibit SP1?
Exhibit SP1. Please excuse me, I'm not in my office, so I only have one screen. SP1 is my resume.
Okay. And is it accurate and up to date?
It is.
Can you please identify SP2?
It's the joint applicant's response to interrogatory of CCAE 1-1.
Did you rely on it in preparing your testimony?
Yes, I did.
Please identify Exhibit SP3.
It's the conventional air pollutant health damages analysis. It's an Excel file.
Did you prepare it?
I did.
And did you rely on it in your preparation for testimony?
Yes.
Thank you. And lastly, please identify SP4.
It is also an Excel spreadsheet, data center analysis.
Can you describe it for us?
It's the model that I use to understand the different health-related impacts of potential data center energy supply.
And did you prepare it?
I did.
Did you rely on this exhibit for your testimony?
Yes.
And is it accurate to the best of your knowledge?
Yes.
Thank you, Madam Hearing Examiner. With that, I would request to move for admission of CCAE Exhibit 2, including the labeled attachments.
Miss Lynch,
Yes.
did you put any other version in the Dropbox other than the version that you put in on 10/29?
Why are you asking? As far as I know, we put this very same document into the Dropbox.
Well, I'm asking because it only has 2 exhibits.
That is maybe because we included CCAE 1-1 in Jason Price's testimony.
3 and 4 are missing.
I do not know why those would be missing. They were attached and they're attached in the version I have.
Well, I'm telling you that I'm looking at the Dropbox dated 10/29 for CCAE Exhibit 2.
What would you recommend as the remedy?
Well, I would say resubmit it if that is the version of the testimony that you actually want to be admitted, which you've just indicated that you do, because the one in the Dropbox only has attachments 1 and 2. It has 2, which is the interrogatory, and then it has 1, which is her CV.
Your Honor, when would you like me to upload those again?
Immediately.
Okay.
The version that I show in the Dropbox was submitted on 10/29 at 11:38.
The version I have does include those Excel spreadsheets.
Ms.
that
Lynch,
you- Yes.
I'm looking at the same document that hearing examiner Hurst is looking at, and it also is missing exhibits 3 and 4, or the attachments 3 and 4.
Can
two
you,
analyses.
and that's in, can you click on the paper clip like icon in the PDF where the two attachments appear in the same Dropbox version that I have?
I don't see a paperclip icon. I'm not sure. I'm just telling you that the document that I opened does not contain the two analyses.
I can upload again this document from the exhibit list that was uploaded, and hopefully it will contain the two attachments because that's the version that I have access to. And I'll do that now. Do we want to take a break while I do this, or how do you want to handle this time?
I'll go to InfoShare. So did you refile the corrected version of this testimony, Ms. Lynch?
Yes, we did. And I'm confused because the version that we filed is the version I have, and it contains the attachments. So, and it's titled Revised Direct Testimony of Stephanie L. Penn on behalf of Coalition for Clean Affordable Energy. And it contains,
when did you file it?
We filed it on the deadline. This is dated September 26, 2025.
Yes, Ms. Lynch, I can confirm that neither the exhibit in eDocket or the one uploaded to the Dropbox has the analyses 3 and 4.
I'm not sure. It's that strange because I'm looking at the very same version from the Dropbox exhibits link, and it contains the exhibits.
Well, I'm not going to argue with you, Ms. Lynch.
No,
I'm telling
I
you
know
that we don't have it. And if you want it to be considered, you're going to have to provide it because we've looked at both sources of the document, the one that actually got filed with the commission. And as hearing examiner Schaefer's indicated, that attachment is not there.
Okay, and I am working on it. I wouldn't, yeah. I'm pulling up the Dropbox link that you sent for this hearing. And I will upload the version I have, which contains the version that I downloaded, which contains the exhibits.
You might email it to hearing examiner Schaefer and myself also.
Okay.
But the version that you want admitted has to be in the Dropbox so that the so that the court reporter has access to it.
Okay. And I'm trying to pull up that link for the Dropbox upload.
Do you want us to go on to our next witness and come back to you, Ms. Lynch?
Yeah, that may be most judicious.
Dr. Penn, I apologize for any delay. But until we can get the correct version of your testimony, we can't hear from you. So if you would mind exiting the Dropbox, and I'll let you back in when your attorney lets you know and lets us know that we have that correct version.
Yeah,
Okay.
apologies. Thank
Thank
you.
you.
Madam Hearing Examiner, this is Brian Haberly.
Mr. Haverly.
We might have figured out what might have been happening. If you download the PDF from the Dropbox and open it up separately, I think in the left-hand column, after you've downloaded it, open it up separately in Acrobat, it looks like there's the ability to see attachments. And I think that might be where these all are at. I think it's not sequentially like you normally see it, and I think you have to actually download the document. I don't know if that fixes the issue or not for the hearing examiners and how you want to do it. But I think to CCA's credit, I think they everything is there, but not the way that we normally see it.
Mr. Haverly, I just downloaded it as well to another PDF reader and still do not see it. So
Let's
Okay,
go
yeah.
ahead with our next witness,
Okay,
please.
that's fine. It worked for me, but I don't know. I have no idea.
Thank you, Mr. Haverly.
Just trying to help.
I appreciate that. Let's go ahead with our staff witness. And I believe we're going to hear from Mr. Zegich.
That is correct, Madam Hearing Examiner. He should be logging in.
I'm gonna do this here, so, but don't worry, it's not gonna be long.
Okay, I don't know who I'm hearing from, but you might want to mute yourself unless you want whatever you're saying to be in the transcript and on the YouTube.
Madam, that was me. I apologize for that.
Okay. Mr. Rossi, you have a witness, sir.
Yes, ma'am. Staff will call Darren Zigich.
Good morning, Mr. Zigich.
Good morning, Hearing Examiner Hurst and Hearing Examiner Schaefer.
good morning.
Mr. Lee, would you please swear the witness?
Mr. Zigich, you solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Rossi.
Thank you. Good morning, Mr. Zigich. Can you please state your name for the record?
Yeah, Darren K. Zigich.
How are you employed?
I'm an engineer with the New Mexico Public Regulation Commission.
Did you prepare testimony for this proceeding?
Yes, I did.
Do you have a copy of the exhibit, Staff Exhibit 1, the prepared direct testimony of Darren Zigich?
I do, yes.
Is there an attachment, DKZ1?
Yes, there is.
We'll get to that attachment in a moment. So for now, let's talk about the testimony. Is this your sworn testimony in this matter?
Yes, it is.
Is the testimony in Staff Exhibit 1 prepared by you?
Yes, it is.
If I asked you the same questions today, would your answers be the same?
Yes.
Are your answers true and accurate to the best of your knowledge?
Yes.
So let's talk about the attachment DKZ1. Is this the joint applicant's response to staff's third set of interrogatories, specifically 3-4?
Yes, it is.
Does it contain the full interrogatory and the affirmations of the two witnesses, Jeffrey Baudier as well as Ryan Schell?
Yes.
And was this relied on by you when you were preparing your testimony?
Yes, it was.
And was it quoted on page 12?
Sorry. Yes, it is.
At this time, staff moves to admit the staff exhibit 1 prepared direct testimony of Darren Zigich as well as.
I'm sorry, Mr. Rossi, you broke up on my side. At this time, I would like to move
to admit staff exhibit 1, the prepared direct testimony of Darren Zigich and the attachment DKZ1.
Any objection to what's been identified as staff exhibit 1, the prepared direct testimony of Mr. Zigich as affirmed by him here today? Hearing no objection, staff exhibit 1 is admitted. Mr. Rossi?
I have no further questions for this witness. He is available for cross-examination. Thank you.
Thank you, sir. It appears that Emera Gas Company has 5 minutes of its reserved time remaining.
Madam Hearing Examiner, I will be representing Emera and NMGC with this witness.
Go ahead, sir.
Madam, we have no questions for this witness.
All right. I believe that BCP applicants reserve 10 minutes for cross-examination of Mr. Zigich.
Yes, Madam Examiner, Dana Hardy for the BCP applicants, and I have a couple of questions.
Please go ahead.
Thank you. Good morning, Mr. Zigich.
Good morning, Ms. Hardy.
I just have a few questions for you. Your direct testimony addresses 3 factors of the 6-factor test that applies in evaluating acquisitions or mergers, correct?
Yeah, partial. I wouldn't say I cover all 3 of those in totality. I'm more in the operations engineering sides, leaving the financial piece to others. But yeah, I cover 3 of those areas.
And those are preservation of jurisdiction, service quality, and customer benefits, right?
Correct.
Okay. And you agree that the commission will continue to have jurisdiction over New Mexico Gas Company should this acquisition proceed, correct?
Yes, all the evidence points to that, yes.
With respect to service quality, you recommend that staffing levels be maintained for 60 months, correct?
Yes,
And the joint applicants have agreed to that proposal, right?
that's my understanding, yeah.
Regarding capital expenditures, you recommend that the joint applicants maintain spending consistent with New Mexico Gas Company's current 5-year capital plan, correct?
Correct, yeah.
And the joint applicants have agreed to that proposal also, correct?
Yes, that's my understanding, yeah.
And in your testimony, you agree that from a gas operations perspective, Emera does not provide benefits over BCP, correct?
Yes.
And you recognize that in your testimony that neither Emera nor BCP would control the day-to-day operations of New Mexico Gas Company, right?
Correct.
You can look at page 14 of your testimony, lines 7 through 9.
Sorry. Okay, I'm there.
And there you state that the transaction, and this is a quote, may be susceptible to early shared service integration issues that may have a limited negative impact on
Sorry,
NMGC.
can you start again? May be susceptible.
Sure. May be susceptible to early shared service integration issues that may have a limited negative impact on NMGC customers, end quote.
I'm sorry, Miss Hardy, what page? I think I got on the wrong page. What page was that again?
Page 14, lines 7 through 9.
Okay, I'm sorry. Yeah, I got it.
It's okay. Did I read that correctly?
Can you read it again? I'm sorry.
Sure, no problem. You state that the transaction may be susceptible to early shared service integration issues that may have a limited negative impact on NMGC customers. Did I read that correctly?
Yeah. Yes, you did.
And you're aware that this potential integration of New Mexico Gas Company's shared services with Delta services would be the third shared services integration for Delta?
Yeah, that's what we've learned, yes.
Okay. And you haven't identified any negative customer impacts from the prior two integrations, which involved Entergy and Magnolia Gas, have you?
No, we haven't.
Okay.
We, that hopefully they've learned from any hiccups in those areas, and this will be much smoother, as I think Mr. Tuminello testified to.
And you haven't identified any hiccups, have you?
No, but they do talk about lessons learned and stuff, so it kind of implies that there's been some. I mean, you can't expect perfection, and I wouldn't expect it here, but hopefully it is well mitigated.
Thank you, Mr. Zagich. Those are all of my questions.
All right.
Thank you, Ms. Hardy. I do not believe that any other party has reserved any time that currently exists for cross-examination of Mr. Zigich. But I have a few questions for you, sir. And I wish I could spend the time questioning you about your aerospace background and employment. However, since that's not the scope of today's hearing, I will regretfully refrain from doing that. I believe that I understand from your testimony, since you are introducing the other witnesses, is it fair to say that you're the case coordinator or
Yes,
of this case for staff?
Yes, I drew the short straw. Yeah.
So your testimony, I think you 3 and 4, you do that. And then on page 5 of your testimony, you begin with a summary of what staff's position is, correct?
Yes.
And your table 1, PRC advocacy staff findings and positions on the 6 primary factors. You basically, in your table, you have boxes for each one of the factors, right?
Yes, I do.
Okay. So in the first factor where you're summarizing whether the transaction provides benefits to utility customers, basically staff has a no on that one, right?
Yeah. Yeah, I mean, we recognize that there are, rate credits and other things that have been proposed here. But I think where we're trying to go, that, well, if you allow me, where I'm saying the middle factors, I think, are fairly clear cut in some
Well,
ways. None of
and
them
I
are,
kind of just want to
but
generally to get an
yeah,
overview from staff's perspective is to
sure,
go through each one of them.
sure.
And you start off by saying staff find that as proposed, the acquisition provides no long-term tangible benefits to gas companies. That's what you say, right?
Yes.
Okay. And then you go on to say what staff's position about changes that could be made to the proposed acquisition, right?
Correct.
Okay. Then the next factor, whether the commission's jurisdiction will be preserved, which is one of your factors, right?
Yeah, that along with Ms. Velasquez, yes.
Okay. And in that you say staff marginally supports this factor, right?
Yeah, and that was partially due to Ms. Velasquez with the concerns of the whole corporate structure.
Okay.
May not give full visibility, but it overall, I think, as far as the gas company is concerned, the commission preserves jurisdiction over that. It's more the visibility moving up the chain.
Okay. The third one, whether the quality of service will be diminished, you say applicant will maintain local control, which staff believe is meant to assure quality of service. However, staff can support the acquisition if further commitments are made. That's your testimony there, right?
Yes.
Okay. So then on the next factor on page 6, whether the transaction will result in the improper subsidization of non-utility activities, you say staff confirms the applicant's commitment to this factor and that staff supports the acquisition on that factor, correct?
Yes, and that's largely the ring fencing discussion that others in the party and on staff are reviewing, but yes.
Okay. Then the fifth factor, careful verification of the qualifications and financial health of the new owner. And you have in this block, based on staff's review, the qualifications and financial health of the proposed new owner is reasonable and that staff supports the acquisition on that factor, correct?
Correct, yeah.
And then the last factor, adequacy of protections against harm to customers, you testify commitments to seek the recovery of the acquisition premium and transaction costs with condition to include, and you cite another case, and then you say down here at the bottom, staff support the acquisition with the specific cost allocations in place to mitigate rate increases. So that's also a yes, but with condition, correct?
Correct, yeah.
Okay. So then when you get to page 16 of your testimony, The question posed at line 4, what is staff's final position to the acquisition transaction proposed in this case? And your answer beginning at line 5 says, after completing a thorough review of the case record, PRC staff have developed the combined staff position presented in the above table 1, which is what we just went through, right?
Correct.
Regarding the 6 factors recognized by the commission, based on those positions, comma, which assume that joint applicants substantially accept staff's recommended additional commitments in table 2, staff recommends approval of the transaction. Is that correct?
Correct.
That's your testimony.
Yes.
And then if we look at page 8 of your testimony, table 2,
Yes.
this is line 5, PRC advocacy staff recommended additional commitments. And with regard to factor 1, in that box, you say commit to establishing severe weather fund with initial and recurring funding, creating a regulatory liability per the testimony of Dr. Blank, and maintaining and tracking overall staffing levels for 5 years. That's your testimony, sir?
Yes.
Okay. And then the next block is factor 3, commit to maintaining pipeline operations and safety staffing for the level 5 years, maintain capital investment consistent with gas company 5-year plan, maintain projects on digitization of infrastructure records. That's your testimony?
Yes.
Okay. And then regarding factor 6, commit to remove the proposed regulatory asset to capture capital expenditures made in the course of completing the transition of shared service functions from Emerita Gas Company and Delta Utilities from its rate case filing commitment. That's your testimony, sir?
Yes.
With regard to factor 1, did gas company commit to that staff recommendation?
No.
With regard to factor 3, did BCP or Saturn Utility or any of the joint applicants commit to staff's recommendation on factor 3?
That is my understanding now from rebuttal and through the bench requests that has been accepted.
And sir, with regard to factor 6, did joint applicants agree to staff's recommendation on factor 6?
Yeah, as far as the regulatory asset is concerned, I believe so. Again, I may have to defer to Ms. Velasquez on the details of that, but that's my understanding is they've substantially approved that, but I'm not sure if that is fully, acceptable. This, unfortunately, this table, to mitigate its size, I summarize some of these, and some of the details may not be fully recognized in here.
So my question to you, sir, is since based on your testimony, it appears that joint applicants have agreed to 2 of the 3 recommendations in staff's table 2. Is that enough for staff to conclude that joint applicants have substantially accepted the additional commitments so that staff is recommending approval of this transaction?
Yeah, that's a tough situation because I am, I'm trying to speak for all of staff, but also not speak for all of staff. Though the number one is a fairly important aspect. I see 1 in 6 as very much tied because there's always risk with a change, and it's how you mitigate that risk. And if a benefit mitigates the risk, kind of like an insurance plan, you hope you never have to use it, but it's there if you do. And there's a cost to that. And if the benefit outweighs the risk, 1 outweighs 6, then there's potential for approval, that it's an okay project. And so it's kind of hard to say exactly what that balance is, I guess, between 1 and 6. And we recommended, just in testimony here, a lot of the interveners have discussed not specifically immediate risk, but long-term decay of the gas company or emissions concerns, and a lot of long-term risks that potentially could come out of this acquisition. We see the severe weather fund as a hedge against any long-term impacts that'll outlive BCP or a lot of entities, interest in the gas company long into the future. And that's why we still stick to that as being a very important part of the puzzle.
Well, sir, as the case coordinator, do you speak for the staff position in this case?
That's a very good question. Not to all the details, of course. I think generally as a policy, but that word that I used in there, I didn't want to say that we absolutely must have everything for us to be supportive, because I know we are going into new territory on some of our proposals, but a substantial acceptance of our position is necessary to gain our full approval. And I can't speak for everybody on the staff as to what their definition of substantial is, because it's going to be different for the entire package versus an individual item.
All right. Well, let me break it down then, Mr. Ziggett.
Okay.
As the case coordinator, do you have a final position on whether the acquisition transaction should be approved?
I don't, because it's a balance. Right now that we're missing that big piece of the severe weather fund, and I know staff has been discussing that for many months. And I know it's kind of a cornerstone issue. And so without any severe weather fund, it's very hard for me to say that they've substantially met our threshold.
So then are you recommending to the commission that the acquisition be denied?
I mean, if you read it verbatim and, as, black and white as far as my testimony goes, yeah, I believe missing number 1 is not substantially accommodating our request.
Okay. Thank you, Mr. Ziggett. That's all the questions that I had for you. Mr. Rossi or Hearing Examiner Schaefer, did you have questions for Mr. Ziggett?
No, thank you. Not at this time.
Very well. Mr. Rossi, any redirect from Mr. Ziggett?
I do not have any redirect. Thank you.
Very well. Any questions from gas company based on my questions? or Ms. Hardy's questions? Hello, gas company.
Sorry, ma'am, we have a microphone problem. It's me. No, we don't have any questions.
Very well. Ms. Hardy, any questions based on mine?
Just a couple, Madam Examiner.
Go ahead, please.
Mr. Zigich, regarding the second factor, which is referenced on page 5 of your testimony, whether the commission's jurisdiction will be preserved. I think you mentioned in response to hearing examiner Hurst's questions that Ms. Velasquez had expressed concerns about the corporate structure. Was that your testimony?
Yes, it kind of highlights it there, the complex layering of ownership. For a visibility perspective, I don't believe there's any issue between the commission and NMGC per se from a regulatory perspective, but it changes the visibility. And to the extent of that, I think you'd have to discuss that with Ms. Velasquez a little further.
Okay, and Mr. Zigich, the reason I'm asking is that in Ms. Velasquez's testimony at page 21, she states that staff believes the requirements of Rule 450 will be satisfied by the joint applicants. And so I'm just not seeing in her testimony that was submitted in April, her April testimony, where she expresses concerns about any complex layering or visibility. And do you know if that's an item that she changed in comparison to her original direct testimony?
Objection beyond the scope of both Mr. Zigich's testimony and of the cross.
May I respond, Madam Examiner?
Yes, please.
Mr. Zigich has in his written testimony and in response to your questions, Madam Examiner, that Ms. Velasquez expresses concerns about corporate layering or visibility. And I think it's appropriate for me to ask him where he obtained that information.
Mr. Rossi?
Going back to testimony filed in April by a different witness is definitely beyond the scope. Thank you.
I think that's fair. I think I'm going to overrule the objection. Mr. Zigich refers to Ms. Velasquez, Dr. Blank, Ms. Hoholas, and Mr. Tupler's testimony as part of his testimony. So answer if you know, sir. Whoa.
I'm sorry, should I answer or you?
Yes.
Oh, okay.
Answer if you know, sir.
Yes. That may be a carryover. I would have to go back and look at that. The table was being done contemporaneously with all of the new testimony, and so that may have carried over. I don't know. It's not really in our table 2 to change anything, so that may have modified over time, and I apologize for that.
Okay, thank you. And I guess just to be clear, I think I had the wrong dates. I meant to ask about her September testimony, which is the current version, not including that information. But I think sounds like your answer would be the same. I just had the wrong date.
Oh, okay. Yeah.
So, thank you. I don't have any other questions.
Thank you, Ms. Hardy. Mr. Zigich? Appreciate your time, sir. You are excused.
All right, thank you.
Ms. Lynch?
Yes, ma'am.
We received the emails. I had trouble opening 3, but I finally got 3 open. So I can see the Excel files. Can you let Dr. Penn know we're ready for her?
Yes, she should be watching as well.
Okay.
Madam Hearing Examiner, if I may, I just forwarded the email that Ms. Lynch sent to you and Hearing Examiner Schaefer to all of the attorneys who were present here. We'll eventually get it to all the service list, but I wanted to get it quickly to all the attorneys for now, so they should all have that.
Okay. Thank you, Mr. DeSalem. Thank you,
I'd
Ms.
also like
Lynch.
to, this is Hearing Examiner Schaefer. I'd also like to take a moment to explain what happened. The Excel files that constitute SPP 3 and 4 were embedded in the PDF document as separate files, not included in the body of the PDF. So in some ways they were hidden or not easily visible. So this is what happened. So thank you for sending them separately, Ms. Lynch.
Yes, thank you for your grace in handling the situation. Apologies, and if there's something I can do in the future to avoid it, I will.
Very well, Ms. Lynch. I think Dr. Penn, you're back with us.
I am.
Can you tell me approximately how many pages that your exhibit 3 and 4 contain?
That's hard to say. The Excel spreadsheets, exhibit 3 has maybe 8 or so tabs. And exhibit 4 has 4 tabs worth of data. I'm not sure if you were to copy and paste it into a Word document, how long they would end up being.
Okay. All right. Thank you for that information. Go ahead now that we is any party not able to see the documents? Yeah. We're gonna have to figure out, Miss Lynch. They're not opening up the separate ones that you sent. There's an explanation of the document. Hearing Examiner Schaefer, can you open that?
Yes, I've opened and reviewed both Excel files.
Okay. So the court reporter will be able to attach those then if they're admitted. Is that correct?
I believe so.
Okay, because all I see is 2 sentences on the SP3. I don't see any of the Excel, the rest of the Excel.
They're in tabs at the bottom of the file, but
Okay.
I think the document is
Complete.
Yeah, complete.
Okay, great. Why don't you offer it again now that we have the complete version? Ms. Lynch.
You're on mute, Miss Lynch.
Do you want me to identify them or?
No,
or
I
what
just
do you
want
mean?
you to, now that I think
Okay.
the testimony and the exhibits, now that we have them, are there. So I just want you to offer your
Okay.
exhibit again
Thank you.
into evidence.
Okay, I appreciate it. Thank you so much, everyone, for your patience. CCAE moves for admission of CCAE Exhibit 2, including the labeled attachments, which are the 2 Excel exhibits, SP3 and SP4, that have been uploaded and presented here.
Very well. Any objection to what's been identified as CCAE Exhibit 2? Dr. Penn's revised direct testimony as affirmed by her here today. Hearing no objection, CCAE Exhibit 2 is admitted.
Thank you.
Ms.
CCAE
Lynch.
now passes the witness.
Thank you. I believe that gas company has reserved 10 minutes of questions for Dr. Lynch.
Yes, Madam Hearing Examiner, we have no questions for Dr. Penn.
Thank you, Ms. Hopper. And I believe that BCP applicants have reserved 10 minutes for Dr. Penn. Ms. Hardy, you're on mute.
Can you hear me?
I can.
Okay, thank you. Thank you. I do have a few questions.
Please go ahead.
Thank you. Good morning, Dr. Penn.
Good morning.
I'm Dana Hardy, and I represent the BCP applicants. I just have a few questions for you. You could look at your direct testimony at page 2, lines 15 through 17. Let me know when you're there.
Yes.
You state, and this is a quote, BCP has not committed to the decarbonization goals to which Emera had previously committed. Thus, I assume BCP will expand the NMGC distribution network beyond what Emera would do, since it is unencumbered by goals to decrease emissions, thus increasing emissions of conventional air pollutants. Is that your testimony?
Yes, it is.
Okay. And did you hear Mr. Baudier's testimony during this hearing?
Unfortunately, I did not.
Okay. So you don't know whether he discussed decarbonization goals of BCP, correct?
Correct.
Your analysis relies on the joint applicant's response to CCAE interrogatory number 1-1, which is attached to your testimony as exhibit SP2, correct?
Correct.
Okay. And can you turn to that response, please?
Okay.
Okay. And that response includes the growth forecast from NMGC, correct?
It includes the growth forecast from joint applicants.
And the response is verified by Mr. Ryan Shell, correct?
Correct.
And Mr. Shell is the president of New Mexico Gas Company, right?
I understand that to be true, yes.
And there's only one forecast provided in that response, correct?
Correct.
Okay. And then if you can go back to page 8 of your direct testimony, please.
Yes.
And in the graph on that page, you've provided different growth forecast for New Mexico Gas Company under BCP ownership versus Emera ownership, correct?
That's correct.
And you didn't actually perform any analysis yourself to determine those projections, is that correct?
The projections were created along with my colleague Angela Vituli, who shared her testimony yesterday.
Right. So you didn't prepare them yourself, correct?
We prepared them together.
Okay. And so in your graph, then, you are assuming a growth forecast for New Mexico Gas Company that's different under BCP ownership versus Emera, right?
That's correct.
But New Mexico Gas Company and BCP have only provided one forecast in this case, correct?
That is correct.
Then beginning on page 28 of your direct testimony, you discuss data centers, correct?
That's correct.
You acknowledge the exact future of data center expansion in New Mexico is uncertain, right?
I do.
So data centers may or may not locate in New Mexico Gas Company's service area, right?
That's correct. This analysis performs illustrative analyses for 3 different scenarios around what may be likely data center expansion.
And data centers, whether a data center locates in New Mexico Gas Company's service area, it may do so regardless of who owns New Mexico Gas Company, right?
That's correct. It just because of the goals that Emera has committed to in terms of reducing greenhouse gases and their decarbonization efforts, that is why I assume that there may be differences in what Emera would pursue versus what BCP would pursue in its ownership.
And do you have any information to indicate that Emera would instruct New Mexico Gas Company not to connect a data center?
Not beyond its need to achieve the decarbonization goals that it has laid out in its public reporting.
And if Emera sells New Mexico Gas Company, that would that allow it to reduce its emissions or meet its targets?
Can you clarify who the actors are in that sentence?
Or sorry, that was a confusing question. So you know, don't you, that Emera primarily owns electric utilities, right?
Yes.
Okay. And if Emera divests New Mexico Gas Company, would that further its goal of decarbonization?
It would. It would take emitting a polluting utility off of its books and get it closer to its decarbonization goals, yes.
And New Mexico Gas Company is a regulated natural gas utility regardless of who owns it, right?
That's true, but the ownership and the parent company's commitments would differ or appear to differ given what each has publicly stated.
And you're assuming that makes a difference in the load in the growth forecast, right?
Yes.
Okay. And as a regulated gas utility, New Mexico Gas Company is obligated to provide safe and reliable natural gas service to customers, right?
Yes.
And that obligation applies regardless of who owns New Mexico Gas Company, doesn't it?
Yes.
Okay. Those are all of my questions. Thank you.
Thank you.
Thank you, Ms. Hardy. Dr. Penn, I have a few questions for you.
Sure.
And I am told I'm flickering.
You are flickering.
And IT is trying to look into that for me. So, could you just define for the record, you're answering the question posed on line 2 or page 2 at line 10, what's the purpose of your testimony? And on page 3, the answer continues from page 2. At line 1, at the end, you say scientists have identified a causal relationship between exposure to capital P, capital M, 2.5 and adverse health effects, as well as exposure to ozone and adverse health effects. Would you identify for the record what a causal relationship is?
Yes, a causal relationship in this case is an epidemiological determination of a cause between exposure, in this case, to fine particulate matter and or ozone with health impacts. So it indicates that there's not just a correlation between these exposures and health impacts, but a causal relationship indicating that the pollutants are cause of certain health effects.
Well, you use the word correlation. Is that a lower standard, or is what does that mean?
A correlation would be a lower standard. There could be correlations between many different things, but that's not what is at play here. Here is a cause and effect relationship between exposure to these pollutants and human health impacts.
Okay, thank you. And then you go on line 6 on page 3, and the question posed, what analyses did you perform? You begin your answer at line 7, and you say that you performed 2 separate analyses, right?
Correct.
And the first one estimates monetized health impacts from residential natural gas combustion associated with expansion of gas company customer base. Correct?
Correct.
And then the second analysis at line 11, you testified estimates the monetized health impacts from natural gas combustion associated with gas company providing energy to 3 types of hypothetical data centers, correct?
That's correct.
So both of the analyses that you performed were based on your presumption that if the commission were to approve BCP's purchase of gas company, they were going to try to increase the customer base, including provision of service to data centers.
That's correct.
And I believe in response, well, I just want to make sure, so I'm going to go ahead and ask the question. Do you believe that your analyses would be any different if it was any other company trying to acquire gas company?
I do think it would be different. Regarding the first analysis, looking at the expansion of customers, as I had previously testified, there's a difference in the restrictions and limitations that the different owners of the gas company have in taking on new customers and relevant to adhering to stated greenhouse gas emissions goals. And then separately for the data centers, the BCP has publicly indicated its interest in supporting data center expansion through news articles and acknowledgments on LinkedIn that it would be interested in expanding data centers. And this is not something that Emera has stated publicly. So those are some of the reasons that underlie the projections that I am using to perform these analyses.
And you conclude in the question posed still on page 3, at line 17 is PRC approval of the proposed transaction in the public interest. And then your answer says that it's not, correct?
That's correct. I believe it is not in the public interest because the increased emissions can lead to additional harm to customers and New Mexicans.
And I asked this of one of the other witnesses. You're familiar with the attempt to whether it's aligned with AI or not, the increase in wanting to build and place data centers across the US, aren't you?
Yes.
So if having such projects, they could be considered by a state as economic opportunity for that state, couldn't they?
Perhaps for some, but data centers tend to not have a need for many local jobs. They tend to just be large facilities that use a lot of energy that can impact the availability of those resources for other things that are going on in the state. And they don't tend to bring a lot of opportunity for those who live nearby.
Well, would you be surprised if I told you that that's not the way that data centers are portrayed in the press or by some of the locations, business people? They're portrayed as providing some jobs, maybe not many permanent jobs, but they're also portrayed as being able to, at least during construction, provide jobs, and as well as putting money in the coffers of the tax base.
I would imagine that some press outlets present data centers that way, but others do not. I think it's also highly dependent on the location and what else is going on in that area. There's data centers that are popping up in areas that are typically resided in by people who are experiencing lower incomes and are otherwise implicated by other environmental pollutants who are much less positive about the data center proliferation in their area.
I wanted to ask you about your testimony on page 4. And this continues your answer about whether the proposed transaction is in the public interest. And on lines 3 and 4, you actually start stating some monetized health impacts. Is that correct?
Yes.
Did you use specific New Mexico data to monetize? Or did you use some average US data?
I use New Mexico specific data. The tool that I used is the US EPA's COBRA tool. And I apologize, I can't remember exactly what the acronym stands for. But it is used in federal regulatory impact analyses and rulemakings and is generally viewed as scientifically sound. The data that went into this analysis in looking at the potential increased emissions from expansion of the gas system are analyzed at the local county level using county specific population within the state and the baseline health considerations at the county level as well. So it's accounting, so the analysis accounts for the fact that New Mexico is a more sparsely populated area than much of the rest of the United States. It also accounts for the prevailing wind direction and other meteorology that will impact how air pollutants will accrue in the atmosphere compared to how it would in other places.
And I guess I would refer you to your testimony on page 12 at lines 8 and 9, where you refer to the US EPA's co-benefits risk assessment health impacts screening and mapping tool. And then in parenthetical, COBRA. Is that what you're referring to?
Yes, it is.
Okay. So now I guess I want to go back to the money here. I just wondered if you used information that was New Mexico specific about what it would cost somebody in Bernalillo to go see their primary care doctor, or what it would cost somebody in Socorro to go see a lung specialist. Did you include those kind of numbers?
Yeah, thanks for acknowledging that distinction. The cost numbers are based on cost of illness values that underlie, again, US EPA's highly resolved analyses of air quality impacts on human health, as well as willingness to pay values associated with premature mortality. So those cost of illness and willingness to pay values are not county specific within New Mexico. There's a value with confidence intervals on either, well, there are two separate values that we present at the low end and at the high end based on the underlying epidemiological analyses, but the cost values themselves are constant across the US.
And I saw your testimony on page 6 where you're talking about the different costs and the economist willing to pay metrics, et cetera. I also wondered whether or not your modeling considers the availability or lack of availability, for example, in a place like New Mexico that might not have the numbers of medical personnel or specialty medical personnel being available as opposed to someplace like Boston.
Yeah, to answer your question specifically, no, it does not incorporate that, but I do acknowledge that that is a limitation of the tool and also of the US healthcare system in general.
Okay, I didn't know if that might, have a more weighted factor in the analysis or not.
No, it does not.
I also wanted to ask you about your testimony on page 11. You're answering the question from page 10 at line 4. Describe the logic employed by the analysis and the data sources. And I'd like to know about your testimony on page 11, beginning at line 16. As such, this analysis is conservative because it examines health impacts from one exposure pathway only, even though multiple exposure pathways are affected when gas use is increased. That's your testimony?
That is correct.
What would be the other pathways?
This analysis only considers the changes to outdoor or ambient air quality associated with natural gas combustion. It does not consider exposures that people are facing in the home that would be differential dependent on the efficiency of their appliances, like the hot water heater, or dryer, or stove, or things like that. And it also doesn't consider those types of things in the workplace. In addition, this analysis only looks at changes in residential heating, and it does not consider any changes in commercial or otherwise. So it's only looking at one of the many exposures that people have to air pollution.
Okay. I also wanted to ask you, I think the question begins on page 11. At line 21, identify important assumptions and parameters that underlay the analysis. For each assumption, why is it needed and why is it reasonable? So your testimony goes on. I'm looking at page 15. And specifically in beginning on that page from lines 1 to 8, you're talking about the New Mexico Gas Company service territory, correct?
Correct.
And then you're saying in that service territory, you considered the number of gas company customers based on the relative population in that county, correct?
That's right. We had asked for more specific information, but we're not able to get that.
Okay.
So we had to make assumptions based on the service territory map that was available on their website.
Okay. Did you consider that in the sparsely populated nature of New Mexico, that the impact that has on the actual areas of the county that that gas company provides service?
Yes, we did. We accounted for the differential population density at the county level.
Okay. And then at line 6 and 7, you say Bernalillo County was home to 33.5% of the population of counties in which gas company is present. Therefore, we assign Bernalillo County 33.5% of households in each year's analytic scenario. That's your testimony?
Correct.
So Bernalillo County was the most populous county in gas company service territory.
Off the top of my head, I believe so, but I am not 100% sure. I believe it's the most populous county in New Mexico.
Is the 33.5% the highest percentage that you allocated?
I believe so, but again, I would need to look back at my analysis to confirm.
Okay. And then I also wanted to ask you, Dr. Penn, about your testimony on page 26.
Okay.
And the questions posed another one of those long way between the question and the answer. I think the question was posed on line 19 or page 19 at lines 4 and 5. How are different communities, and then in paren, those that are marginalized or otherwise overburdened in paren, impacted by conventional air pollutant related health impacts? And I'd like to ask you about your testimony on page 26. At line 4, you say, unfortunately, I was not able to assess the direct impacts from the purchase of gas company by BCP on underserved communities, as the gas company service area includes only a small fraction of some of the designated underserved counties. Further, because New Mexico is a sparsely populated state and changes in air pollutants are available only at the county level, the analysis is unable to discern specific impacts to disadvantaged or low income communities.
Available at the county level.
The analysis is unable to discern specific impacts to disadvantaged or low income communities or household. That's your testimony, Dr. Penn?
It is.
Do you not include either data or assumptions about the location of underserved or low income communities when you're putting this analysis together? So for example, I know that I've heard over the years, and I can especially recall in a when we first started doing the transportation electrification plans, I seem to recall, hearing about certain locations where low income or underserved communities were located. Now this, this information had to do with, well, are you going to put, charging stations or going to require, or electric buses or whatever, to try to benefit the community. And I'm just wondering if, like you say, there aren't certain widely accepted, I don't want to call it a fact, but widely accepted assumptions that could have assisted you in your analysis?
Yeah, there are the state of New Mexico has, as I had indicated previously in my written testimony, designated certain areas as disadvantaged communities. But because the air quality model that I had access to for this analysis is only resolved at the county level, I didn't feel that the certainty that would need to underlie an analysis to really understand the impacts on those communities would be up to my values as an objective analyst. So broadly, there are many peer-reviewed analyses that indicate that exposure to air pollutants has a larger impact, a more deleterious health impact on people who are impoverished or have other vulnerabilities or chronic health conditions. But aside from that, I couldn't go further with this particular analysis without more highly resolved air quality information.
Very well. Dr. Finn, I believe that's all the questions I have for you. Thank you. Ms.
Thank you.
Lynch, any redirect for your witness?
Not at this time, hearing examiner.
Very well. Any recross questions, Ms. Hardy?
Yes, Madam Examiner, I have a couple.
Okay, very well.
Thank you. Dr. Penn, at page 28, line 3 of your testimony, let me just get there, and it's in your discussion of the data centers. You state, and this is a quote starting at line 3, we have constructed 3 scenarios that are plausible, correct?
That's correct.
And you only modeled health impacts of the plausible scenarios, right?
Correct.
Okay. If a data center doesn't locate in New Mexico Gas Company's service area, it could just locate somewhere else, correct?
Aligned with whatever the regulations in other places are, correct.
Right, and that could be inside of New Mexico or outside of New Mexico, right?
Correct.
Regarding your growth forecast discussion on page 8, where you have your graph, you don't address whether your assumed forecast is consistent with New Mexico Gas Company's customer growth from 2020 to 2024, do you?
The information, we did not begin with analysis prior to 2025. We began the analysis at 2025.
And I know that you relied or you worked with Ms. Vituli, and are you aware that she testified or her testimony states that the projected growth included in the discovery response that you've attached is consistent with New Mexico Gas Company's growth from 2020 to 2024?
Okay.
Are you aware of that?
I was not.
Okay. Thank you. Those are all my questions.
Thank you, Ms. Harding. I believe, Dr. Penn, that concludes your cross-examination. Thank you for your time. You are excused.
Thank you.
Thank you. Mr. Lee, are we ready for our morning break?
Yes, Your Honor.
Very well. I'm showing 10:40. Let's come back at 10:50 and we'll resume with the presentation of our staff witnesses. Remember, please, the YouTube is on.
Hey, are we on break? Ryan?
Yes, we are.
Miss Beatles. Mr. Rossi, are you handling all of the staff witnesses?
That is correct, Mr. Lee. Thank you.
You bet. Thank you.
And I will be emailing you all of the exhibits since there were some correcteds, just to make your life easy.
Thank you, sir. I'm ready when you are, Judge.
All right, let's go back from our morning recess. I believe my video problems have been resolved. Mr. Rossi, you have another witness.
Yes, Madam Hearing Examiner. Staff will call Mark Tupler.
Very well. Good morning, Mr. Tupler.
Good morning, Madam Hearing Examiner Hurst and Mr. Schaefer.
Mr. Lee, would you please swear the witness?
Hello, good morning, Madam Hearing Examiner Hurst and Mr. Examiner Schaefer and colleagues.
I believe someone's bringing in YouTube, or is that new?
That could have been a remnant on my machine. It's not open anymore.
Mr. Tepler, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter how penny, should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Go ahead, Mr. Rossi.
Thank you, Hearing Examiner. Good morning, sir. Can you please state your name for the record?
Yes, my name is Mark A. Tupler.
How are you employed?
I am part of senior staff with the New Mexico PRC's Utility Division Economics Bureau.
Did you prepare testimony for this proceeding?
I did.
Do you have a copy of Staff Exhibit 2, corrected prepared direct testimony of Mark Tupler?
Yes, sir. It's in front of me.
Are there attachments MAT 1, 2, and 3?
Yes, sir.
We'll get to those in a minute. Right now, we want to talk about the testimony. Is this your sworn testimony in this matter?
Yes, sir, it is.
Is the testimony in Staff Exhibit 2, the corrected, prepared by you?
It was prepared by me, yes.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
Are the answers true and accurate to the best of your knowledge?
Yes, sir.
The corrections, did it affect the testimony, or is your testimony identical to what was pre-filed September 26th?
The testimony is identical. The attachments have been repaginated for compliance.
So let's talk about those attachments. MAT1, was that the previously admitted diagram created by or admitted by Jeff Baudier in JMB1?
Yes, it was.
Okay. And now MAT2 and 3, that's where the corrections lie. Is that correct?
Yes, sir.
And those corrections, they were adding the full interrogatory and the affirmations of witness Ryan Shell. Is that correct?
Scrolling through it now, and yes, that is the case.
And both MAT2 and 3 are joint applicants' response to NMDOJ first set of interrogatories 1-1. Is that
Yes,
also
sir.
correct? Okay. At
Yes,
this
sir.
time, staff, or did you rely on these when preparing your testimony?
I did.
Staff moves to admit Staff Exhibit 2.
Any objection to what's been identified as staff exhibit 2, Mr. Tupler's prepared direct testimony as corrected and affirmed by him here today? Hearing no objection, staff exhibit 2 is admitted.
I have no further questions for this witness. He is available for cross-examination.
Thank you, Mr. Rossi. I believe once the time was adjusted, gas company has 5 minutes of cross-examination time reserved for Mr. Tupler.
Madam Hearing Examiner, that would be me, and we have no questions of this witness.
All right, Mr. Domi, thank you. I believe that BCP applicants reserve 10 minutes for cross-examination of Mr. Tupler.
Your Honor, this is Will Dubois, and I would actually like to transfer all 10 minutes to Dr. Blank, please.
Very well. And just as a time check, Mr. Dubois, it looks like to me that you have previously moved 2 10-minute intervals.
That's what I have as well, Your Honor.
So you have a total of 75 minutes now reserved for Dr. Blank.
Yes, thank you.
Staff agrees with the math.
I do not see that any other party has reserved any time for cross-examination of Mr. Tupler. Hearing Examiner Schaefer, you have questions for Mr. Tupler?
Yes, thank you, Madam Hearing Examiner. Good morning, Mark. Mr.
Good
Tupler,
morning.
excuse me.
Yes, sir. Good morning, Hearing Examiner Schaefer.
Yes. Can you just summarize what your conclusions are, what you were asked to determine, and what that determination is?
Yes, certainly. What I would do in this instance is go back to my table of contents in the testimony, and you'll see all 10 of the items, I guess is what it is, although not all, a lot of it is outlined. But I was tasked with reviewing the financial health, the capital structure limits, the debt load is what I would call it, credit metrics, board of director composition, dividend payment restrictions.
District Board of Director.
Composition.
Slow down a little bit, please.
Yes, sir. And dividend payment restrictions.
And what were your determinations in a summary manner with respect to the financial health and capital structure limits?
Both of them, in my review, in my experience, were adequate for this transaction.
And whose financial health did you analyze?
So I reviewed the New Mexico Gas Company, as well as the next level company up. I believe it was the Tico Holdings. Based on the financial statements that were submitted in my exhibits.
And what is the financial status of Tico Holdings?
Well, a review of the balance sheet as well as the income statement are included in my testimony. And my perception and my review was that they were both adequately capitalized and adequately structured, if I can call it that, to meet minimum financial conditions.
Mr. Tupler, you just said both. Who is both?
The balance sheet of the company or the holding company, as well as the income statement.
And did you make any determinations regarding you said the debt load? Whose debt load?
So what I was looking at in this instance was the debt load of the operating company, New Mexico Gas Company.
Did you conduct any analysis of the proposed debt load of the holdco?
Other than reviewing the balance sheet of the holding company, I didn't go much deeper into that. I didn't feel there was much reason for it.
Why?
In my experience, when any investor contributes, I think it's approximately $700 million to a transaction, there's not a big concern of where that money came from, other than protective inquiry.
Whose concern?
I'm sorry, let me understand that question better, please.
You just answered, in my experience, when an investor contributes, I think it's approximately 700 million to a transaction. There is not a big concern of where that money came from, other than, protective inquiries. Whose concern?
Okay, certainly. What I tried to do was focus on the entities that the PRC has jurisdiction over, because the capital structure at that point, the debt and the equity combination, those are the only two choices you really have to fund an investment, debt or equity. I focused on the entities that were within the PRC's jurisdiction. Anything further from that, I don't believe is within our jurisdiction, and maybe more importantly, I don't really have an issue with the sources of those funds as long as they meet all traditional banking, investing, and corporate structure contributions.
What is the what company will own TICO under the proposed transaction?
Well, I'd have to go back and look at my hierarchy that was included as one of my exhibits. I believe it to be the Saturn entity.
Which one?
Let me get there so that I can give a good answer here. Here we go. So under the post-closing structure is what I've titled this. It looks like it would be the Saturn Utilities Holdco LLC.
Is it your understanding that that holdco will be within the jurisdiction of the PRC?
As the owner, I would say that is accurate, yes.
So then it would be a concern of the PRC to inquire into the financial status of the holdco. Is that correct?
Well, I'm under the impression that that hasn't been funded yet. So as what I would consider a pass-through entity or a special purpose entity formed specifically for this transaction, and I believe according to testimony, these intermediary companies have not been funded yet.
Are you saying that Saturn Utilities Holdco is a pass-through entity?
Looking at the hierarchy included in my testimony, I would say that is the case, yes.
What is a pass-through entity?
So a pass-through entity, and I think it's been explained in testimony, is a legal corporate entity that is structured simply for a particular transaction. There's no operations in it. It is meant to capture whatever legal or tax or operational advantages that it has in order to put a transaction like this together. So it has no employees typically. It has no operations. It is intended to capture specific financial transactions, I guess I could call it, to receive, in this case, I believe it to be dividends, and then pass it further up the corporate hierarchy or the corporate structure.
What is the relationship of Saturn Utilities LLC to Saturn Utilities Holdco?
So I believe the Holdco entity may hold affiliate companies comparable to the Saturn LLC that we were discussing, which would then hold other operating companies, is my impression at this point.
What is the role of an aggregator in this transaction?
Yes, sir. I would say the same definition there as well. It is intended to hold downstream entities that control downstream operating entities, and to aggregate, as its title may indicate. And I've seen this before many times in corporate structures. The entity is named applicably according to its role in the process. In this case, it might be to aggregate, as it says in the name, the different operating entities, or it's more than just the entity, it's the structure of the entity that it invests in.
So what is it? What is the, in this proposed transaction, Saturn Utilities Aggregator LP? What is that aggregator aggregating?
My impression would be other operating companies that are affiliate operating companies, I think we can call post-close, in order to pull their financial condition and or maybe their financial reporting together into one entity, one corporate entity.
Based on your review of the transaction, why is it structured the way it's structured? That is to say, to be more specific, if I may rephrase my question, why is there an aggregator that is upstream of a topco that is upstream of a holdco?
Again, I would emphasize that what I've seen here and what I've seen in my experience is that there are different corporate entities that can be legally formed. That was one of my concerns, was legally formed entities that have different tax considerations or different investment considerations or different corporate considerations that are utilized to provide that special purpose entity, is what they're called, or some type of reporting structure. In order to, and I would say that it was to take advantage of legal, tax, and operating allowances within each particular corporate entity.
So within your review and analysis of this transaction, what are the legal, tax, and operating allowances? Let me rephrase. In your review of this transaction, what are the legal, tax, and operating allowances that each particular corporate entity is taking advantage of?
Well, so that might be is beyond the scope of my testimony here, but it's not beyond the scope of my experience. What I have seen in the past in corporate structures very similar to this, and I would say that this is not an extremely burdensome corporate structure. It is a normalized corporate structure from my seat. As an example, the different form of legal entities, legal corporate entities, starts with something as simple as a sole proprietorship for a one person business, all the way up to a C Corp, which is a corporate structure that we're all familiar with, a Microsoft or a General Electric corporate entity. And then there's all these intermediary type companies that are in between them. There's limited liability companies, as an example, which is a membership organization. Then you have a general partnership or a limited partnership, each one of them a different specific legal entity done for protection of shareholders, members, maybe the corporation itself, technically. And each one of them has a different tax reporting requirement. As an example, if I'm not mistaken, limited liability companies have pass-through income where the individual shareholders are taxed themselves as opposed to taxed at that corporate entity level. It passes to the membership. Limited partnerships as opposed to general partnerships, as an example, are typically done, and they have to be done together. Every limited partner has to have a general partner, and every general partner has to have at least one limited partner. That is corporate tax structure law, if I'm not mistaken. So what's done here is, because each corporate entity has different requirements, different laws, different tax considerations, the overall structure, or the way the corporate hierarchy is structured, utilizes each of those differing requirements within each different corporate entity. And I would say the ultimate reason for this is beyond the scope of my testimony, like I mentioned, but not beyond the scope of my experience.
And what was the scope of your testimony?
I reviewed the gas company entity itself, because I think that's what's most important in preserving the financial health, or that's my main concern, is the financial health of the gas company, as well as the parent above it.
And how are you certain that upstream changes or upstream financial challenges will not affect TECO, New Mexico Gas Intermediate, or New Mexico Gas Company?
Yes, sir. Specifically, the ring fencing provisions that have been provided, I believe, protect upstream and downstream. So anything further upstream is going to be irrelevant, and anything downstream is going to be protected, specifically because of the ring fencing provisions that are included in this transaction.
And what is a ring fencing provision?
So a strict definition of a ring fencing provision is a protection of one entity from another. And when I say protection, that means operational protection, financial protection, any of the influences that a parent company can have over an operating company. There are provisions that are agreed to. In my experience, of course, which was in an unregulated, open public market, they were contractual. In this case, because it's a regulated industry and a regulated entity, they are prescribed by commission order.
So are you saying there's no contractual ring fencing between TECO and the Saturn Utilities Holdco LLC?
I'm unsure if there's contractual agreements between the entities. Something tells me it makes sense that they would, but I can't say that I saw that in the evidence, or as I think through it, I just can't recall. But I do know that the commission has overriding authority to ensure that those ring fencing provisions are strict and held to. There's no way around them.
Well, could you describe what would happen in the case of an insolvency of the upstream owner of TICO?
Yes, sir. I have pondered that exceptionally in this case. In my experience, in an open public market, there would be certainly recourse down to the operating company. In this regulated environment, however, I don't believe there is any way a court could attach anything, because of the ring fencing, could attach anything to the holding company nor the operating company. And in my experience, I'm sorry, sir.
Go ahead.
In my experience, the vast majority of investors would never walk away after writing a $700 million check. They would figure it out and they would get reorganized if they had to. Insolvency is typically the first step towards bankruptcy. They would figure it out so that they do not abandon their initial investment. That is a bad investment choice, and there are remedies to it. In this case, though, however, the gas company and the holding company could not be affected.
What is the amount of debt that Saturn Utilities Holdco is taking on in this proposed transaction, or proposing to take on in order to affect this transaction?
Yes, sir. I believe it was 240 million.
It's 250.
Okay. Yes, I agree.
And how are you sure that those lenders would not try to seek recovery from TICO Gas Intermediate or New Mexico Gas Company?
Yes, sir. So every
default.
Yes, sir.
I'm sorry, Judge.
I said in the case of a default.
Yes, sir. Every credit indenture is held together by a credit agreement, a business agreement, something that documents the loan. I believe it to be a law somewhere in the corporate world to document the remedies that are included in that indenture. The guarantors, as an example, the terms of the loan, the events of default, they're outlined in a credit indenture. Whoever the lender is for that 250 million has got to know that there's no recourse or guarantee down the chain of command or down the chain of the corporate structure. Thus, what those lenders are doing is lending to the acquiring entity based on non-recourse, and it'll be spelled out in the loan indenture, to any of the out-of-reach entities is what I would call them, because they are not going to be party to the agreement. As an example,
if I understand you correctly, then it's not just a question, non-recourse is not just a question of a proposal of a joint applicant. It's also something in the abstract, in general terms, that would be part of a loan agreement. Is that what you're saying?
Yes, sir.
Okay.
Any good lender would document the loan and perfect their positions, because lenders typically look for more than one source of repayment. How is this loan going to be repaid, and where is it coming from? Collateral is typically one of those sources of repayment, but in this case, there is no collateral other than what has been provided upstream. Again, out of reach, from my perspective, of PRC jurisdiction, and out of reach of New Mexico Gas Company and the holdco.
Are you aware that TICO will be changing its capital structure and distributions under the proposed transaction?
Am I aware of that? I would say yes, I am.
And how will that affect New Mexico Gas Company?
Financially, I don't believe it will.
And why not?
I don't believe the hold company is subject to PRC jurisdiction. So capital structure, ring fencing provisions. I'm curious as to whether ring fencing provisions. Strike that. I don't believe there to be ring fencing provisions between the holdco and the operating company, so there's not going to be anything there. The holdco is going to be subject to PRC jurisdiction, capital requirements, or capital structure requirements. And I think that is protective to both of those entities.
Based on your experience and expertise, Mr. Tupor, what is your understanding of the concept of moral hazard?
Moral hazard?
Moral hazard, yes.
Yeah, interesting term. I can't say I've heard it too often, but I do know of it. I think it's maybe the lesser of two evils. Is that maybe a way to say that? I don't know a strict definition. I'm sorry.
What dynamics are at play here in this proposed corporate and capital structure from the holdco up to BCP Infrastructure Fund 2 GPLP? What dynamics are at work vis-a-vis the TECO Gas Intermediate and Gas Company that are not present in its current structure?
Well, let me understand what you mean by dynamics. There's funding, or there's capital structuring within each of the entities. I don't believe it is much different than what is currently in place. And I don't think the structure as presented and as is currently is abnormal. I think it's very in line with corporate entity structuring across the business environment.
And by not abnormal, you mean normal?
Yes, sir.
And by normal, do you mean good?
Well, when it involves legal or tax or operational matters, I don't believe that they can be characterized necessarily as good or bad. Well, I don't know. Maybe I should restate that. There can be advantageous structuring or financing. There can be disadvantaged structuring as well. I hope that answers your question. I don't look at it as a matter of good or bad. I look at it as utilizing the corporate entities and each of their specific requirements and differentiating factors. This is why we have so many different entities. Each one of them is slightly different from another to take maximum advantage of legal and tax and operational benefits. And those benefits go up and downstream from my experience.
And describe that. How do they flow downstream?
Well, as an example, and keep in mind, please, my experience is in the open public markets. So there could be more advantageous financial arrangements between the entities. As an example, a requirement of more debt or a requirement of more equity. Banks love to see as much equity in a proposed transaction as possible. What's different in our regulated environment is that capital structure, the debt and the equity amounts, are prescribed by commission order. So we don't have to consider what advantages flow downstream because they are part of the building blocks of a regulatory compact.
Okay, so what you're saying then is that this proposed corporate and capital structure really has no downstream benefits to the customers.
Downstream benefit to the customers. I don't believe there's a benefit nor a detriment. It's a capital structure that is prescribed. So the benefits that are part of that prescription by default flow to customers.
This proposed corporate and capital structure, in your view, Mr. Tupler, is in what way not in the public interest?
Not in the public interest is the question.
To what extent, in your view, is this corporate and capital structure not in the public interest?
I don't see it as a detriment to the public interest. If anything, I would turn that around and say that not interfering with the transaction of two parties is in the public interest. It's upholding standard traditional business transactions and agreements between two willing and capable parties that have done their own due diligence on each other to complete a transaction.
So merely allowing one company to acquire the other is per se in the public interest.
As soon as the $700 million check clears, I would say yes.
Okay. In what way does this transaction benefit New Mexico Gas customers?
Well, one of the things that I've seen in my experience is that when a willing seller finds a willing buyer, that is a good thing. It's a meeting of the minds by very capable parties to transact. I would say that limiting or restricting that transaction is the biggest risk I see.
Mr. Tupler, you testified earlier that this proposed corporate and capital structure is not abnormal. Is that correct?
Yes, sir.
You would say that this proposed corporate and capital structure is normal. Is that correct?
Yes, sir.
And how did you determine that it's a normal corporate and capital structure?
Well, in my prior life, I've seen it 100 times.
So you have great familiarity with this type of proposed corporate and capital structure?
Yes, sir. I would say both of those are very strong backgrounds that I have.
And what problems arise in your experience with these kinds of corporate and capital structures?
Well, when they're done properly, they do flow very efficiently and importantly, I guess, is what I would say there as well. Issues that can come up, of course, will be related to legal breaches. Bankruptcy is always a concern of a banker, for certain. Even with the best underwriting, there are companies that maybe don't manage their debt properly and have cash flow issues and solvency issues and ultimately bankruptcy issues. Corporate structures like this, even though they're normal, can tend to hide things if they're not properly structured. Each one of these entities that we're discussing, from what I understand from the testimony, are legally and duly formed entities and registered. So that means that they're registered, I believe, maybe Secretary of State, something like that, but they are publicly registered to transact business according to their corporate bylaws or member agreement, whatever incorporating documentation they use. That outlines all the terms of the corporate entity and the relationship that it forms with other entities, other parties. If it's not duly registered, I would have grave concern. If there were overseas or non-domestic entities, I would certainly be concerned. If there were other red flags that just come up in the structure of these particular entities, it would be a concern of mine.
Mr. Tupler, I'd like to draw your attention to your testimony, page 19.
I'll get there.
No rush.
Page 19, sir?
Yes. The line 5.
19, line 5. Yes, sir, I'm there.
Am I correct in stating that the question you posed to yourself reads, how did the BCP applicants intend to fund the future capital requirements of New Mexico Gas Company?
Yes, sir.
Is it your understanding that the BCP applicants will be funding New Mexico Gas Company?
My understanding is that they will be funding the intermediary companies that will then provide further financing down the chain, ultimately to New Mexico Gas Company.
So New Mexico Gas Company, in your understanding, will be a debtor to upstream intermediate corporations in the proposed corporate structure.
There's something strange about the way that sounds. I don't believe they will be debtors because I believe the contributions are intended as equity. I don't believe our ring fencing provisions allow for debt financing to the operating company, the gas company, the New Mexico Gas Company. I don't believe that's allowed based on the ring fencing provisions that further staff witnesses will be discussing.
Yes, I'd like to draw your attention to your answer on page 19, starting at line 7. And am I correct in reading your answer as saying that, as reported in the revised application, the sources of funding available for the BCP related transactions will be a blend of debt and equity consistent with the NMPRC approved capital structure currently in place? Is that correct?
Yes, sir.
How does that relate to the question of BCP applicants intending to fund the future capital requirements of New Mexico Gas Company?
I may have overstated with that debt inclusion there. The debt that is being incurred in the transaction is going to be something still doesn't sound right about that. Let me think through that.
Well, that's fine. You can think. Let me ask you another question, just to go back to your prior answer.
Right.
You were saying that upstream BCP applicants will be providing equity to New Mexico Gas Company. Is that your testimony?
Yes, sir.
Okay. So have you reviewed in your experience here with the commission or previously the six-factor test taken into consideration when reviewing such proposed acquisitions?
Yes, sir.
And how does this corporate and proposed corporate and capital structure provide a new benefit to New Mexico Gas customers?
Well, because of the similarity of the corporate structure and the prescribed capital structure, I don't believe there's any benefit nor detriment at that strict level. I think the benefit derives further up the chain of a transaction between willing parties. If we can find a benefit there, and maybe that's an overall public good as opposed to specifically a ratepayer good, or benefit, if that's the more proper term, I would believe allowing a reasonable transaction to occur is in the public interest. How does that funnel down to a ratepayer benefit? I don't know if it does. There's nothing in this transaction that is a detriment from my seat, and conversely, outside of the willing transaction that is taking place at the top level, there's no benefit, there's no detriment from my seat.
Mr. Tupor, earlier you said that a lot of your experience has been with capital markets. Is that correct?
Yes, sir.
Public capital markets.
Yes, sir.
Now, what reporting that New Mexico Gas Company and Emera, with respect to New Mexico Gas Company, what reporting will no longer be available under the proposed corporate and capital structure?
I believe it's the commission's authority to require any reporting there is, period. There won't be any SEC filings. Obviously, Emera is a publicly traded Canadian company, if I'm not mistaken. So there's certain requirements that are at that level, but there's nothing extraordinary about that reporting. It's the same type of things that any investor would want to see. And as a publicly traded company, you have an obligation to report quarterly, which I've always thought was a little disingenuous. Quarterly reports are not an authority from my seat. Annual reporting tells a story. One, because they're typically audited reporting statements as well, which gives a little bit more a lot more reliance, I would say, as compared to quarterly filings, which are typically preliminary, they're not audited, and there's a lot of adjustments that are made at year end, which again gives you more credibility to the annual reporting cadence. That being said, I go back to my original statement that I believe the commission has the ability to request any type of reporting of the entities that it has jurisdiction over. And that gives me comfort that any compliance requirement or ring fencing requirement or any requirement prescribed by the commission could be reviewed and determined to be in or out of compliance.
Is there any non-financial reporting that Emera and New Mexico Gas Company currently have to provide under federal law or federal regulation that the companies under the proposed transaction would not have to provide?
I'm trying to think my way through an annual report, a publicly traded annual report. There's usually a letter from the CEO describing all the good things and maybe even bad things that happen throughout the year. Then there are operational or entity descriptions. Then there are financial statements. The financial statements are the most important from my seat. That gives you the results of the company's operations, the company's financing. And then there's a whole bunch of pages of niceties. So I don't know if the niceties are required. I think they may be there to give investors, publicly traded company investors, a better understanding of what their investment looks like. I don't believe they're required, though, from a securities SEC perspective. So I don't think that they'd necessarily need to include some of those niceties in their reporting to the PRC. But again, they're niceties to have, and in my opinion, a very good business best practice. You want your investors to know how well things are going, or alert them to potential dangers or, upcoming matters, litigation as an example, or, a changing market, or, whatever could affect the going concern of the entity reporting. I hope that answers your question. I haven't seen an annual report in front of me for a while now, so I'm just trying to think through what is required versus what is reported versus what they would differentiate under our jurisdiction.
Are there any risks that are currently reported as required by federal law or regulation that would not be reported under the proposed corporate and capital structure?
Under the accounting principle of full disclosure, I've got to think that as long as the statements are audited, they would include any pertinent or foreseeable risk. I don't know.
Will the financial statements of these intermediate companies and upstream companies be required to be audited?
Well, they don't have any operations, so I would think that they wouldn't. Although there is a prescribed accounting treatment of intermediary special purpose interest companies, corporate entities. I just don't know how they would apply here. My concern would be for the holding company and the operating company.
But the upstream companies will not have to have an independent audit as if they were publicly traded. Is that your understanding?
Well, I don't know what as an example, the limited partnership agreements with the further upstream investors, again, BCP applicants in this discussion are top level for us, but they have reporting requirements to their investors, the pension funds, the insurance companies, the mutual funds, whoever, the institutional investors that will be above BCP have a right to understand certain financial conditions that are agreed to. I haven't reviewed the partnership agreements that go above BCP, but in good practice, good investors, institutional investors, will protect their interests in any type of large investment. I would guess that every institutional investor that the BCP Partners works with is a large, well-qualified institutional investor.
But just to ask for certainty here, the upstream owners of New Mexico Gas Company would not have to produce independent audits like the current owner or like a publicly traded company would have to. Is that correct?
I don't know that answer.
Okay, I'll ask another. Is the lack of an independent audit a risk?
I don't believe so. At the upstream levels, I don't believe so.
Okay.
again, they are not, there's no operations, there's no employees, there's really nothing to report except the financial transactions that are coming through that particular corporate entity. So there'd almost be nothing to report.
Thank you, Mr. Tupper. Those are all my questions.
Thank you, sir.
Thank you, Hearing Examiner Schaefer. Mr. Tupler, I have a few questions for you.
Yes, ma'am.
When you refer to on page 14, line 13, to
Page
an
14.
SPE, what are you referring to?
So an SPE is an acronym for a special purpose entity. I think I described a bit of it with Mr. Schaefer's questioning. I'm happy to explain it again, though, if needed.
Just wanted to clarify for the record, sir.
Yes, ma'am.
We go on to page 15 of your testimony at line 4, the question posed, what is staff's evaluation of the financial health of the BCP entities? And basically you indicate in your testimony that because they were just formed within the last 12 months, you conclude at line 9, there's no financial capacity to evaluate them. That's your testimony, sir?
Yes, ma'am.
Does that bother you at all that you can't evaluate them?
No, ma'am, it doesn't. They are formed specifically for this transaction. If the transaction goes away, those entities dissolve, is my perception at this point. They are intended to be pass-through entities, as I described before.
Well, BCP Infrastructure Fund isn't a pass-through, is it?
Well, I believe it is. But I believe it's also at a higher level that is outside of our jurisdiction. So it would be nice to see it. I've always been interested in financial statements. There's no question about that. But I don't think it impacts. If I think this through, I don't believe it impacts the holding company.
Well, isn't BCP Infrastructure Funds who are actually funding the transaction?
I would say that it's one of the entities that is passing through the dollars that are funding this transaction.
Okay. Well, in response to Hearing Examiner Schaefer's question, you keep referring to companies or entities who are upstream. So do you believe that there is some other entity in the proposed structure that we've been given that is actually funding the transaction?
Let me make sure I understand that question. Are there other entities involved?
Other than the specific infrastructure funds that we've been given information in this case that are providing the funding. If you don't think it's the specific infrastructure funds that are funding the transaction, who do you believe is actually doing the funding?
Okay, I think I understand the question. Let's start at the very top of the equation here. There are big pension funds, insurance companies, etc., that are funding the BCP entities that are then taking those investable dollars and pushing them down to their different investments through the different corporate structures that they have for each of the different investment theme arms of their corporate entity is what I would describe it sitting here. So the ultimate funding is coming from the investors at the highest level, down through the BCP entities, into the infrastructure funds, into the holding company, and then ultimately to the operating company. I know that sounds cumbersome as I describe it here, but I've seen this happen very many times in my experience as part of the investment process through these SPEs, special purpose entities.
Sir, on page 15, line 11, you pose the question, what financial impact do the BCP entities have related to gas company? And basically you conclude that they have no contractual relationship with gas company. Is that correct?
Madam Hearing Examiner, I believe you might be cutting out a bit. Could I get that question again, please?
Yes. The question posed at line 11, what financial impact do the BCP entities have related to New Mexico Gas Company? And then your answer at lines 11 through 15 seems to indicate that it's your opinion that the infrastructure funds outside of Saturn companies have no contractual relationship with gas company. Is that correct?
Yes, ma'am.
So my question is, if gas company needed funding, where would they go to get funding? If Holdco is just a pass-through, and if they have no other relationship with BCP infrastructure funds, then where would gas company get any funding from?
Yes, I understand the question. If the Holdco, from my position here, if the Holdco needed money, it would make requests further upstream for those funds.
To whom?
To the remaining corporate entities that are in the hierarchy, all the way up to the ultimate BCP partners, and further, if needed, to their investors. And then it would trickle down just like I described it up the chain. I would presume in this case, I don't see any other way around that. It would trickle down as well.
Did you listen to Mr. Baudier's testimony?
Yes, ma'am.
And have you heard some of the concerns of the interveners as to the potential lack of capitalization being a potential problem in this case?
Yes, ma'am. I've heard that.
Therefore, based upon that testimony, wouldn't it appear, and based on Mr. Baudier's testimony, that gas company would have no contractual relationship with the BCP partners, but could only, who have, as testimony has indicated, have the higher or deeper pocket as opposed to the 2 billion that would only be available under the infrastructure fund scenario. Isn't that right?
I would agree with that, yes.
So then how, if they don't have a relationship with BCP Partners, how are they going to get money from BCP Partners?
Well, the holdco and infrastructure entities at this point, I would say, are neck deep in the transaction. They've committed the funds to make this transaction happen. And in my experience at that level, there's very few investors that would walk away, because what they'd be doing is giving up all of their equity in the gas company. I don't see that as even remotely possible, or I see that as a possibility, but not a probability, not even remotely probable, because that's a big investment to walk away from. If the BCP partners still resisted equity contributions, my guess is that the commission could somehow order or adjust the capital structure to make it a mandate. In an unregulated market, if capital or if equity contributions are not requested, capital contributions are not made, the company has to make operating adjustments or asset sales or something that would make up those funds somehow, some way. In a regulated market, however, I believe the commission has authority to mandate additional equity in keeping with their prescribed capital structure.
Let me go to a different topic, Mr. Tupler. And looking at page 24 of your testimony, the question posed at lines 13 and 14, what other measures have joint applicants committed to in order to protect gas company from undue upstream debt or financial influence? And you begin your testimony at line 15 on that topic. And I believe I understand that testimony. And you're referring to paying excessive dividends or distributions, correct?
Yes, ma'am.
Aren't there other ways that the joint applicants could get revenue from gas company other than a dividend or distribution?
So I have to start my answer with, they'd have to go through the board of directors, is my initial impression. The gas company board of directors is the only entity that declares and pays the dividend. They're the only entity that would allow sale of assets. They're the only group that would change operations somehow to formulate, if you will, a larger payable dividend. I don't think I see any other way for the BCP partners to influence that. They will have representation.
Go ahead, sir.
They will have representation on the board of directors in the minority, 2 out of the 9, if I'm not mistaken. It's in my testimony, I could review it. But off the top of my head, they have 2 representatives that are advocating not only for the gas company's interest, but for their ownership interest. But any board of director action requires a majority. Some decisions require a supermajority. So it's more than 50% plus 1. A supermajority is typically 2/3. It's all prescribed in the bylaws or the operating agreement of the board of directors. That's the only way I could see additional funds being pulled out of the company. Board of director action is what I would call it.
So if I understand your answer, sir, the response to my question is they could allow for the sale of assets.
The board of directors could, yes.
Okay. Sir, your testimony on, you're continuing on page 25 to respond to that answer. And beginning at line 4, you say the books and records of gas company will be kept separate from those of non-regulated businesses and gas companies' affiliates in accordance with the uniform system of accounts. Is that correct?
Yes, ma'am.
Then you testify further, the joint applicants have stated that the commission and its staff will have access to the books, records, accounts, or documents of gas company affiliates, corporate subsidiaries or holding companies pursuant to NMSA 1978, section 62.617 and 62.619, and that gas company will continue to abide by all applicable NMPRC rules, regulations, orders, including compliance with all Class 1 transaction requirements. That's your testimony, sir?
Yes, ma'am.
Realizing the importance of access and reporting, what specific reports does staff believe should be filed and by whom and in what frequency to comply with this obligation?
Okay, I touched on that a bit in an earlier discussion. I think annual reporting of standardized financial statements at a minimum. So that would include a income statement to see how operations turned out, a balance sheet to see how they're capitalized, maybe a statement of cash flows just to verify there are no ancillary unknown transactions, if I can call it that. I'm certain there are other prescribed customer service reporting elements that are critical. Right in front of me, I don't have their reporting requirements as is, but I wouldn't want to change anything in this transaction. If anything, I would want to somehow reserve the right to, under the commission's ability to request any reporting, I would almost want to preserve the right to add additional reporting requirements for measuring purposes and compliance purposes. Beyond that, I don't believe there would be anything beneficial any further upstream.
Well, like I say, the commission's asking you, what does staff need to see, on what frequency, and by whom?
Right. I want to be able to address, because that's what my testimony supported, was the financial reporting requirements. I described the income statement the balance sheet, a statement of cash flows, any other metrics related reporting.
And who would provide that?
The gas company and the holdco, I would say, are the two entities I would be concerned with.
What about a Fitch credit report?
Yes, ma'am. That's something that is publicly available. So I think one of the ring fencing mechanisms is to require credit reporting to continue. So as soon as that is released by the Fitch entity, the Fitch Credit Reporting Agency or above, because there's two others as well, S&P and Moody's, as soon as that's available for public distribution, I could support having the gas company supply that. It's publicly available, but they still have duty to report.
And the income statement, the balance sheet, the cash flow, and other credit metrics, excuse me, that would be on an annual basis or quarterly or what?
Well, as I mentioned a little bit earlier, I don't, in my entire career in investing and banking, I didn't rely on quarterly reports with much assurance. They are not as informative as an audited annual report. As you
So
might
your
know,
answer is annual?
Yes, ma'am.
Any type of FERC form? From
If one is
any of the
produced,
entities?
yes, ma'am. If one is produced, I would say let's take it. It should correspond, if I'm not mistaken, with the actual accounting statements. I believe that's what is transferred to a FERC form. I just don't have enough familiarity with the FERC form to know what else is reported there. Everyone that I've seen, of course, I go to the financial section and chop it out. It's a long form. If it's available, it couldn't hurt to submit it. I don't know how we would review it necessarily because FERC does that review. And I'm uncertain if FERC provides any type of feedback, but I'd certainly be curious as to any reporting from FERC after a submission of the annual FERC form. I would want to see that.
Any other reporting that staff recommends to the commission? Other than what you've testified to?
Outside of the financial reporting that we've discussed here, I'm certain there's other operational metrics or customer service metrics that are smart. I don't want to speak to them because I don't have that knowledge right here, right now. If it's an existing compliance or reporting requirement, I would certainly suggest that they continue. Unless a report has become burdensome or provides no material information, there's no reason to report just to report from my seat. There's got to be something materially beneficial to the report. But I don't have the experience as to what else is reported outside of the financial capacity that I've discussed here.
Well, let me ask you this. Did you review any of the intervener testimonies?
Yes, ma'am, all of them.
Did you review Mr. Sabukel's testimony?
I'm certain I did, but I can't recall the elements of it right here, right now, without it in front of me. But I can talk about it.
All right, I'd refer you to pages 54 through 56 of his testimony, where he's talking about specific recommendations for what he calls good governance and transparency. And his first recommendation, beginning at line 11 on page 54, is that the commission require gas company, to the extent practical, to comply with the rules applicable to a registrant under the New York Stock Exchange corporate governance standard. And then he goes on to talk about what would be included in that type of report through lines 23 on page 54 through lines 8 of page 55. Did you review that testimony?
I believe I did, yes.
Do you concur with Mr. Sabuco that something like that should be required of gas company?
My experience has been that SEC reporting is burdensome at a certain level, above and beyond the required and standardized accounting and metrics requirements. That's why we have multi-hundred page SEC filings or compliance filings. And I go back to my
So is your
description.
answer no?
I don't have his requirements right in front of me here. If I could have the moment to review them, I can give a much clearer answer.
Go ahead.
Okay, let me, I'm going to attempt to get to his testimony. Or if,
have you provided that, Mr. Rossi, to your witness?
He has it access. He can access it, yes, via our Teams folder, and then the submitted exhibits folder. I have it open if you would like me to share my screen, Madam Hearing Examiner.
Have you got it, Mr. Tupler?
I was just scrolling through the list. If Mr. Rossi has it available, I was going to ask to please put it up.
WRA exhibit number 2, so it will be at the bottom of the list alphabetically, or if I can.
I see. Okay, so I am almost there if I'm not mistaken. My screen doesn't show the names entirely, so I have to hover over it, but I'm getting there. Okay, I believe I've got it.
Page 54.
It's opening up. Okay, it's downloading. Page 54. I've got to do a better way of accessing this. There's a number of pages. Okay, 54. It's not coming up. It's in front of me, but it's stuck at a certain page here, and it's not allowing me to do much, but it is moving along here again. So bear with me, and I will go directly to 54. It's coming up. And I do have it in front of me now, Madam Hearing Examiner. What line numbers am I looking at? 23, starting at 23?
The answers or the references to the New York Stock Exchange requirements begin on page 54, line 17.
Yes, ma'am. I am now there.
And I'm asking you
Okay.
whether or not you agree. And so far, what I've heard from you is it's very burdensome.
Well, let me explain that. So I see some bullet points here starting at line 19. Annual report, mandatory. Interim financial statements, burdensome. Independent directors, mandatory. Director executive sessions. I don't know exactly what that would encompass, but I would imagine that that is somehow maybe board of director minutes. I don't know how I feel about that. There could be confidential material there that would certainly not serve the public interest. But if it's already required, it might be, I would support it to continue. I don't see how minutes of the board of directors, though, can be reported.
Okay, let's move on to the next ones. You said you've
Mhm.
read this testimony, so I assume you previously considered this. Are there
Yes, ma'am.
any other on the next page, F through M, that you think the commission ought to consider?
So F through M, I would say, are all standard reporting requirements.
Okay, let's move on. He's also recommended that the commission mirror relevant SEC financial reporting requirements, and he's listed 3 things. Do you believe the commission should require those things? And if not, why? Or if so, why?
Sure. So again, my experience with SEC financial reporting has led me to believe that while there are certain mandatory reporting elements, certain requirements can be burdensome. I don't know what a Section 13A disclosure is. If I'm not mistaken, it reminds me of something in the line of
Don't speculate,
shareholder.
sir, if you don't know what it is.
I do not.
Very well.
Indenture covenants, disclosure requirements. So those are loan terms and agreements. I don't know if that's something that is necessarily in the public interest.
Okay. Very well, sir.
Right.
So that's all the questions I had for you. Thank you. Mr.
Thank
Rossi,
you.
are you going to have any redirect for Mr. Tupler?
Not a lot of it, but I do have a couple of questions for him. Yes, I
Very
probably
well.
in the 5-minute range.
Okay, I just instruct you, this is not cross-examination, so leading questions are not appropriate.
Thank you for the reminder, Madam
Go
Mayor.
ahead, sir.
You were talking a bit with both hearing examiners about ring fencing provisions. Do you remember that?
Yes, sir.
Can you explain the idea of piercing the corporate veil?
So my understanding of piercing of the corporate veil is a judicial right in the event a court of proper jurisdiction orders it. Beyond that, it must be a prescribed or a ring-fenced prohibition. The reason we have the different corporate entity structures is to protect and to isolate a corporate entity. So a piercing of the corporate veil, from my perspective, I guess it can be done incidentally, which would be against a corporate requirement. But I see it as something, and my experience has been, it is only done from a judicial order.
Can you explain how, when we have multiple levels, how that interacts with that idea of piercing the corporate veil or being prevented from it?
Well, each corporate level, each corporate entity is its own specific entity that has all the protections of the incorporating document, which is very standardized across the board in order to duly form, to legally form the entity. It becomes its own, I can use the word entity 100 times here, but it becomes its own corporate person, if I can describe it as that, with all the protections and provisions of that form of corporate entity prescribed by law.
I'd like to direct you to your exhibit MAT1, which is on the PDF page of 40 of your testimony.
Page 40. Okay, I'm getting there, scrolling to. Okay, tell me again what I'm looking for.
The diagram, the double diagram, is that the page you're on?
Yes, staff exhibit MAT1.
Yes.
I'm there.
Within the pre-closing structure, the old Amera structure, New Mexico Gas is at the very bottom. Is that correct?
Yes, sir.
Okay. And then within the new structure, it's also very similar. When it comes to the ring fencing provisions of this new pre-closing structure, if someone was suing New Mexico Gas and wanted to try to extract money from BCP infrastructure way at the top, would they be able to? Can you walk us through what protections are there?
Hold on, you just referenced the pre-closing structure, correct?
Actually, I meant to discuss the post.
Thank you.
Okay, Mr. Rossi, one more time, just so that I'm answering the question, please.
What sort of ring fencing provisions exist to prevent piercing the corporate veil going through all of these different levels?
So you're asking what type of ring fencing provisions would prevent that?
Yes.
If you know, sir.
Yeah, I kind of feel that might be outside the scope of my testimony. However, it's not outside the scope of my experience. However, further, I would say that that's going to require some type of legal conclusion, which I should not step into.
Let me try to re-ask that.
He's already answered it. Why don't you move on?
Okay. How many different levels of Saturn holdco or utilities are there?
So I show on that corporate hierarchy 6 Saturn described entities.
And are they slightly different from each other?
They're all slightly different and independent of, maybe not independent. They are slightly different and in scope and purpose, I would say. from each other. Intentionally.
Are some limited partnerships versus some limited liability corporations?
Correct.
Okay. And is this a structure that you're familiar with in your years of experience?
Yes, sir.
Okay. You were asked a little bit about the dividend distributions versus it was also called either dividends or distributions. Do you recall that conversation?
Yes, sir.
In order for NM Gas to pass on a dividend under Emera, who would have to do that?
There's only one entity that can declare and pay a dividend, and that is the board of directors of the gas company.
Under Emera's board of directors, how many people on the board are there?
I don't know that answer. I don't know Emera's board composition.
Okay. Under BCP's, the proposed board composition, how many board of directors are there?
Again, I don't know that answer.
Okay. Does the dividend or distribution process change between these two boards?
It certainly can. However, my concern was only with the New Mexico Gas Company board composition. Further upstream, I believe to be outside of our jurisdiction, and I didn't review anything at that level, board of director related.
Is it still a majority vote is what's required to issue a dividend?
Can't say I've ever seen anything to the contrary, but again, there's a governing document for every properly structured board of directors that would outline how board decisions are affirmed. I can't say I've ever seen anything that's not at a minimum majority.
Okay. I have no further questions for this witness. Thank you.
Thank you, Mr. Rossi. Any recross by seems like there was a couple of questions. I'm sorry, I don't remember. No recross?
Your Honor, this is Will Dubois.
Mr. Dubois,
I do have recross, Your Honor.
go ahead.
Madam Attorney General, I also have some recross.
Okay. All right. Well, in order, Mr. Dome.
Thank you, Madam Attorney General. Mr. Tupper, I just have a few questions for you about a couple of areas. The first one is, does New Mexico Gas Company file annual reports with you, with the staff?
Yes, sir, I believe they do.
And do you know what those reports consist of?
I don't.
Do you review the annual reports that the gas company files with staff?
I believe that any compliance document that would come in would be reviewed at some level. And then, of course, a corresponding internal memo, maybe, to describe the filing in a high-level direction. I would tell you, though, that I have not been involved in that. As you know, staff is a collective, so there are other people that have probably done that. However, their review would be documented and then sent further up the chain.
Do you know who? Can you point to a specific person or staff position who has the responsibility for reviewing reporting with the commission?
I don't think I can, Madam Hearing Examiner. I just don't know.
Very well. Go ahead, Mr. Domi.
So, Mr. Tupper, I'm looking at New Mexico Gas Company's annual filing in April of 25. And the first document that was filed was New Mexico Jurisdictional Customers Information Form number 1, submitted pursuant to 17.3.610.14. Do you know if staff received that document, and did staff review that document?
I do not know.
I don't want to belabor this, but the additional 4 documents that are on this report, Form number 2, the Class 2 transactional report, the Class 1 transactional report, and the annual informational finance filing report. Do you know who at staff reviewed those reports?
Objection asked and answered. He's already stated he doesn't know.
I'm going to overrule it for the specific documents in case they might have been filed separately. Answer if you know, sir.
Madam Hearing Examiner, I do not know the staff assignment on that filing.
Okay.
Mr. Rossi, consider it a bench request. I want to know who at staff is responsible for compliance and or review of the annual report for gas company, generally, utilities specifically, and the 4 documents that have been identified as comprising the annual report. Secondly, I want to know who at staff specifically is required to review any other type of filing and report. As an example, for gas company, it's PGAC reports. Any report that gets filed, I'd like to know who on staff has the responsibility to review it.
Mr. Rossi, I would also add to that who reviews any reports submitted pursuant to federal law or regulation.
So 3 things on that request. Annual report, all other reporting, number 3, specifically the federal reporting. Any questions on what we're looking for, sir? Mr. Rossi?
No, I think I understand.
Very well.
And Madam Hearing Examiner, just for a point of clarification, in the document I was reading from, in your bench request, you said there were 4 documents. There are actually 5 documents. They're all
5.
spelled out in the annual filing, not just 4.
Okay, very well. I stand corrected. Anything further, Mr. Domi?
Just a couple brief questions, and then I'll let Mr. Dubois go. On the pre-closing structure that you referred to a while ago, Mr. Tupler, how far up in that pre-closing structure do you think the PRC's jurisdiction goes?
Let me take a look again. My impression sitting here would be that it goes up to and including the TECO Energy entities.
Okay. Thank you, Mr. Tupler. That's all I have, Madam Hearing Examiner.
How far do you think it goes on the post-closing?
Let me get back there. I just closed it, darn it. Post-closing, my impression is that it goes up again to the TICO entity.
So you
I
don't
believe
think
the
it
TICO
extends to Saturn Utilities Holdco?
Yeah, that's the image I'm picturing in my mind. I'm
So your answer
examining it.
stays the same? If you know, sir.
I don't know sitting here right this moment.
Thank you, sir. Mr. Domi, anything further?
Madam, I just have, I looked at my notes. I have one more brief area that I'd like to talk about. Mr. Tupper, have you reviewed the ring fencing provisions with regard to the dividending proposed in this transaction?
Yes, sir.
Are you comfortable with the ring fencing provisions as controlling the dividending if this transaction is approved?
I believe I addressed that in my testimony, but my answer is yes.
Do you have anything you want to add to what you said in your testimony?
If I didn't say that it was a standard dividend distribution process, I would say it here.
Okay. That's all I have, Madam Examiner.
Thank you, Mr. Domi. Mr. Dubois?
Thank you, Your Honor. Hello, Mr. Tupler. My name is Will Dubois, and I have some represent the BCP applicants. I have some questions for you.
Yes, sir.
Regarding the discussion you had with hearing examiner Schaefer regarding asset sales and transfers, do you recall having such a discussion?
I do.
And under New Mexico statutes annotated section 62-6-12A4, a public utility may not sell, lease, rent, purchase, or acquire any public utility plant or property constituting an operating unit or system or any substantial part thereof outside of the ordinary course of business, correct?
I do understand that.
And the joint applicant's commitments include numerous commitments prohibiting the sale or transfer of assets to affiliates or the pledge of such assets for affiliates, correct?
I believe that to be true.
And you had I think you had multiple discussions about piercing the corporate veil. Do you recall that?
I do.
And in order to pierce the corporate veil requires both there being a substantial commingling of assets between the entities as to which the veil is to be pierced, and a lack of a maintenance of separate identities as to those entities, correct?
I like that characterization, yes.
And there are numerous commitments that require substantial separation, in fact, complete separation of the assets of New Mexico Gas Company compared to any other affiliate, correct?
Yes.
And there are numerous commitments that ensure that separate identities of New Mexico Gas Company and each of its affiliates are maintained, correct?
Yes, sir.
Regarding the potential, do you recall being asked by hearing examiner Schaefer regarding the potential for adverse impacts to New Mexico Gas Company from various of the BCP applicants, particularly what have been referred to as the intermediate companies?
The question is, do I recall that conversation?
Yes, sir.
I do.
And in fact, the joint applicants have committed, quote, the financial health or operations of New Mexico Gas Company will not be adversely impacted by the existence of the intermediate companies post-closing, correct?
Yes.
And does that provide some further reassurance on top of what you had discussed with hearing examiner Schaefer?
So if there's a commitment to not do so and a ring fencing provision to prevent it, I would say that's twice as much assurance.
And do you recall discussing with hearing examiner Hurst a joint applicant's commitment that, quote, the commission and its staff will have access to the books, records, accounts, or documents of NMGC's affiliates, corporate subsidiaries, or holding companies pursuant to New Mexico statutes annotated 1978, sections 62-6-17 and 62-6-19?
The question is, do I recall the conversation? Again, I'm sorry.
Yes, sir.
I do recall the conversation.
Okay. And do you recall that in addition to that language being in that commitment, the general diversification plan also clarifies that, quote, the BCP applicants agree to the jurisdiction of NMPRC for the purpose of providing the books and records of each and providing access to testimony of officers and directors for the purpose of NMPRC oversight and regulation of NMGC?
Yes, sir, I do recall that.
And that would be very clear that the commission can go all the way up to the BCP, all of the entities that are BCP applicants in this matter, correct?
If you're describing that as a commitment, then I would agree with it.
Regarding or do you recall having a discussion with hearing examiner Schaefer regarding auditing and other matters related to what I think we commonly call Saturn Holdco or Saturn Utilities Holdco?
Yes, sir.
Do you have well, I'll ask it this way first. Do you recall that one of the joint applicants' commitments is that, quote, going forward, both Saturn Holdco and NMGC will have their credit ratings performed by one or more nationally recognized credit rating agencies, so their credit metrics will be independently ascertained?
I do remember that testimony or those provisions. Sitting here now without the file in front of me, I didn't know that it would go as high as you've described it. But certainly more credit reviews are a smart business practice and certainly would be a welcome commitment.
And if you have the joint applicants' commitments in front of you, it would be number 44, but I think I can ask an additional question or two without needing that in front of you. It's up to you whether you would like to pull that up, so please let me know.
Let me just preface this by saying that I didn't address these in my testimony, so I want to be careful about crossing my duty lines here.
Well, I recognize as to your written testimony, and I didn't cross-examine you on these as to your written testimony. I'm asking you about questions and answers that took place in your discussions with the hearing examiners. Do you understand that?
I see. I understand.
Okay.
Why don't we try the question here and I'll answer it as best I can. If I can't, I will refer specifically to what you're addressing.
Okay. If Saturn Holdco will have its credit rating performed by a nationally recognized credit rating agency, that would require that it be independently audited, correct?
Yes, sir.
Do you recall having some discussion regarding legal obligations as to the provision of equity to New Mexico Gas Company by affiliates?
Okay, so by the affiliates catches my attention. I believe it to be equity contributions by New Mexico Gas Company, higher level corporate entities, not necessarily affiliates. Can I describe it that way as my understanding?
For our mutual understanding, would you accept for the purposes of my question that affiliates would include each upstream parent company of New Mexico
Okay.
Gas Company?
Understood.
Okay. Today, no upstream parent company, nor any other kind of affiliate of New Mexico Gas Company, has any legal obligation, including no contractual requirement, to provide any funds to New Mexico Gas Company, correct?
As we sit here today, pre-close,
Yes, sir.
I agree with that.
Are you aware that during Emera's ownership of New Mexico Gas Company, as recently as last summer, not only did New Mexico Gas Company's upstream parent, Emera, have debt, but also New Mexico Gas Intermediate had debt, correct?
I don't know if I necessarily understood it or knew of that specifically. I could surmise that, but I've not reviewed any of those financial statements to give a definitive answer.
Understood. You are aware, correct, that Emera's assets per its annual report are leveraged to the extent that it has less than 33% equity in its capital structure, correct?
I could agree with that, yes.
I thought you said, Mr. Tupler, that you didn't review the annual report.
I didn't. However, I would tell you in my experience as a banker, leverage is considerably lower in the unregulated environment.
I think you're
And
treading outside the scope, Mr. Dubois.
Back on the subject of, oops. Sorry, one moment, please. Make sure I stay. Back on the subject of the potential for New Mexico Gas Company to be impacted by any bankruptcy of any upstream parent. Do you recall having that discussion with hearing examiner Schaefer?
Yes, I do.
And are you aware that subsequent to your direct testimony and in response to other witnesses, the joint applicants committed that the BCP applicants and New Mexico Gas Company would obtain a non-consolidation bankruptcy remoteness opinion subsequent to closing?
I can't say that I heard that, but I like it.
If there were to be such a commitment, would that provide you further reassurance that New Mexico Gas Company would not be impacted by any such bankruptcy, even if one were to happen?
I don't know the terms and conditions of the document that you're describing. But like I mentioned, it does seem to be a very protective agreement and covenant. There may be some type of legal conclusion to make there as well that I don't feel I have the knowledge to form an opinion on. But it does seem like an additional bankruptcy protection provision. How a court would interpret that, I am not qualified to say.
Those are my questions. Thank you, Mr. Tupler. Thank you, Your Honor.
Thank you, Mr.
Yes, sir.
Dubois. Ms. Beatles, you've raised your hand.
Yes, I do have one question based on questions that you and Mr. Schaefer asked, if you don't mind.
Please.
Thank you. Mr. Tupler, good afternoon.
Good afternoon. Yes, indeed.
By any chance, did you review the order approving formation of a holding company in case, and this will tell you how old it is, 3137, when PNM got its first holding company?
Ms. Beatles, I can't say that I reviewed that, but I certainly will take note of it and review it.
I was just going to ask if it informed your work in this case, but I guess it didn't, because either because it's old and it's old and forgotten, but I guess your answer is no. Is that correct?
The answer is no, though I do have a strong interest in reading it.
All right. Thank you. That's all.
Thank you, Ms. Beatles. Mr. Tupler, excuse me. Thank you for your time, sir. You are excused.
Thank you,
I
Madam Hearing
believe
Examiner.
that at this point, we should take our lunch break. I'd like to see us, if we can. Mr. Lee, can we take 45 minutes?
Yes, Your Honor.
I've got 12:55. So let's come back at 1:40. And we'll hear from Dr. Blank, I believe is your next witness, Mr. Rossi.
That is correct. Thank you.
Okay, thank you. Remember, the YouTube will stay on. And we are recessed until 1:40.
Good afternoon, Mr. Lee. Are you with us?
I am.
Is this a good time to go back on the record?
I'm ready when you are.
Great. Thank you, Mr. Lee. Good afternoon, everybody. Go ahead.
But get a drink of water.
No rush.
Okay, go ahead.
Thank you. Well, good afternoon, everybody, and welcome to the last several hours of our hearings in this proceeding. We have 3 more witnesses to attend to this afternoon, so I think we will try to do that with as much efficiency as possible. Hearing examiner Hurst will be with us momentarily. In the meantime, I think we can go ahead and get started. Staff, I believe that you have your next witness ready to call. Is that correct?
That's correct. Staff will call Larry Blank, although I do note it is 1:38. So I'm not certain that everyone's back.
I thought we said 45 minutes. Is that right?
I thought we said 1:40.
Okay.
But it looks like Mr. Blank is back.
All good. We're being early is on time, right, Mr. Rossi?
I agree.
I'm just trying to. Oh, good. There's Mr. Blank. Excellent. Excellent. Okay. Well, we'll wait till 1:40. Just everybody can take a nice breath, and we'll get started then.
When you're ready, Judge.
Thank you, Mr. Lee. Okay, it is now 1:40. Mr. Rossi, would you like to call your next witness?
Thank you, Mr. Hearing Examiner. Staff will call Larry or Dr. Larry Blank.
Mr. Lee, would you like to swear the witness in?
Dr. Blank, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you.
Go ahead, Mr. Rossi.
Thank you, sir. Good afternoon, Dr. Blank.
Good
Could you
afternoon.
please, I'm sorry, could you please state your name for the record?
Larry Blank.
How are you employed?
I am principal of Tahoe Economics. I'm
Did
also.
you say Tahoe, sir?
Yes, Mr. Lee. TAHOECONOMICS. Tahoe Economics.
And did you prepare testimony for this proceeding?
Yes.
Do you have a copy of Staff Exhibit? I apologize, I accidentally minimized that window. Staff Exhibit 3, the corrected, prepared direct testimony of Larry Blank.
Yes.
Is there an attachment to your testimony?
Yes.
So we'll talk about that in a minute, but let's talk about the testimony first. Is this your sworn testimony in this matter?
Yes.
Is the testimony in Staff Exhibit 3 prepared by you?
Yes.
If I asked you the same questions today, would your answers be the same?
They would, but counsel, I do have one correction.
Oh, thank you. Go ahead.
On page 15 of staff exhibit 3. So page 15, line 6, the word asset should be changed to liability.
Thank you for that correction. Are there any other corrections?
No.
Are your answers true and accurate to the best of your knowledge?
Yes, sir.
Now let's talk about your exhibit. Is your exhibit the reason for the corrected testimony?
It is. I have an attachment labeled Exhibit LB1, which is my resume. That exhibit was inadvertently not attached to the testimony that was filed. And it is referenced within my written testimony.
And then the corrected version includes your resume as well. Is that correct?
That's correct. That's the only correction other than the one word correction I just gave.
Okay. With that, I moved to admit Staff Exhibit 3, the corrected direct testimony of Dr. Larry Blank.
Mr. Rossi, just for certainty of the record here, in the Dropbox, the PDF that I just opened does not have that attached. Is CV attached?
There should very likely the next item down should be labeled corrected. So it'll be Staff Exhibit 3 hyphenated capital letters corrected. You do not see that?
I don't. I see a corrected for Staff Exhibit 2 corrected, Staff Exhibit 5 second corrected, Staff Exhibit 5 third corrected, and Staff Exhibit 6 corrected.
I uploaded that yesterday and then also emailed the joint applicants to make sure they would have it. I'm checking the Dropbox myself. I would say, Mr. Hearing Examiner, try refreshing your browser on the Dropbox link, or have you downloaded them or said copy to Dropbox? When I look at Dropbox now, it does show a Staff Exhibit 3 with a date of yesterday.
Mr. Lee, do you see this on your end?
I do not have that screen up, but I can check if we can go off the record.
Yeah, let's go off the record for a second. Again, Mr. Rossi, I just refreshed again and don't see it.
I will be happy to email it to the hearing examiners if that will expedite this.
Yes, let's just go ahead and do that and email it to Mr. Lee as well. But before we do that, I just want to ask if there are any objections to admitting. Well, we have to go back on the record, so I'll wait till Mr. Lee.
I'm ready, Judge.
Okay, thank you, Mr. Lee. Back on the record. So are there any objections to entering Staff Exhibit 3 as corrected into the record? Hearing none, it is admitted. Mr. Rossi?
I have no further questions for this witness. He is available for cross-examination.
Mr. Dome, are you going first with this witness?
Mr. Hearing Examiner, this is Brian Haverly. I will be conducting the cross-examination of Dr. Blank on behalf of Amera, TICO, and NMGC.
Excellent. And Mr. Haverly, just to remind us all, how much time have you reserved for this witness?
I believe I have 40 minutes.
Thank you. You may proceed.
Thank you. Good afternoon, Dr. Blank. Would you please turn to page 4 of your direct testimony? Let me know when you get there.
Yes, I'm there.
There's a question posed at the very bottom of that page where the question is posed saying, please summarize your analysis and recommendations. Is that
Sorry,
correct?
sir. Start this quote again, please, and slow down.
Sorry about that, Mr. Lee. The question posed is, please summarize your analysis and recommendations. Is that correct?
Yes.
And on the following page, you have an answer, which is page 5, starting on line 1. Is that correct?
Yes.
Would you please read the answer starting from line 2 to the end of the sentence on line 9.
First, the acquisition premium or goodwill to be paid out of the purchase price of this transaction provides a market valuation of the intangible assets of the acquired firm, which in the case of NMGC is mostly derived from the government-created monopoly. This value was not created by the current owners of NMGC. It was created by the government with customers subjected to a government-protected monopoly. And an amount equal to the goodwill paid to the sellers at closing of this transaction should be booked as a regulatory liability to customers. Parenthetical, less any benefit amounts designated by the commission for specific purposes in this case.
Thank you, Dr. Blank, and that is still your testimony today, correct?
Yes.
Would you please turn to page 6 of your direct testimony?
Yes, I'm there.
On line starting 7, you have testimony that says there's value in gaining ownership control of a government-created and government-protected monopoly utility company with captive customers. Period. This value was not created by the utility company nor by the owners of the utility company. Period. Instead, the monopoly value was created by the government and granted to the owners by the PRC. Period. Did I read your testimony correctly, sir?
Yes.
And that's still your testimony today, sir?
Yes.
Line 7, page 7, sorry. Let me know when you get there.
Page 7?
Yes, sir.
Okay, I'm on page 7.
Question on line 14, there's a question. Does NMGC have an identifiable tangible assets? Answer, yes. The primary intangible asset of NMGC is the captured customers of the government-created and government-protected monopoly held by the regulated utility. Did I read that correctly, sir?
Yes.
And that is your testimony still today, correct?
Yes.
Would you please turn to page 8?
Yes, I'm there.
Line 12, there's a question. How should the goodwill be used in deciding this case? On line 13, there's an answer. The value of the goodwill in this case is the value of the intangible asset created by a government-protected monopoly and the captive customers of NMGC. Did I read that correctly, Dr. Blank?
Yes.
And that is still your testimony today, is that correct?
Yes.
And Dr. Blank, you understand that in New Mexico, in order to provide public utility service, a company must first be issued a certificate of public convenience and necessity by the NMPRC. Is that correct?
Yes.
And if I use the term CCN for certificate of public convenience and necessity, will you understand what I'm talking about?
Yes.
Excellent. And when you're talking about the government-controlled monopoly, we're talking about the CCN that the utility has been granted by the PRC to provide utility service. Is that correct?
Yes, I think that's fair to use it synonymously. Yes.
Dr. Blank, it's been a long day and I apologize. Dr. Blank, you are aware that before August of 2024, so as recently as July of 2024, NMGC's goodwill was valued at over $400 million on its books. Is that correct?
Yes.
And you're aware that after Emera announced the sale of NMGC to the BCP applicants, NMGC's goodwill was impaired by approximately $200 million. Is that correct?
That's correct, yes.
And you're aware that in August of 2025, NMGC's goodwill was impaired by an additional approximately $50 million. Is that correct?
Yes.
And you're aware that the BC applicants have estimated that at closing, if the commission approves the transaction, NMGC's goodwill will likely be between 130 million and 185 million. Is that correct?
Yes, that's the current estimate provided by the, well, NMGC or the joint applicants, yes.
And you agree, Dr. Blank, that the customers of NMGC should not have to pay anything for the decrease in value of that goodwill from 400 million approximately to somewhere between 130 and 185 million. Is that correct?
The decrease in value does not necessarily constitute a loss in this investment for the current owners. And so, yes, I agree with, my answer is yes, but that loss is not indicative of a loss on this sale.
Dr. Blank, are you aware of whether companies that do not have a monopoly granted by the government record goodwill on their balance sheets?
It's my understanding, yes.
So for a company that does not have a monopoly status, what is goodwill made up of?
Again, it's a valuation of the intangible assets that are not recorded specifically on the books of the company. Those intangible assets could include such things as brand recognition, market share, customer loyalty, overall competitive of the company, since we're now talking about a non-regulated competitive, presumably competitive market environment. So there's a variety of intangible assets that would be valued and find themselves booked as goodwill at the time of a transaction, such as what's being considered here.
Could goodwill include the value of an experienced management team?
It could be, yes.
Could goodwill also include the value of a experienced and stable, well-trained workforce?
Yes, it could be, yes.
Dr. Blank, have you reviewed any of NMGC's financial statements, either in this case or in any aspect in the past?
Not recently and not in preparation for this case.
Are you aware of whether NMGC reports a value pegged to the CCN or the monopoly as value as you have kind of described it in your testimony? Are you aware of that's reported as a numeric value anywhere in NMGC's financial statements?
No, it would not be. The only thing that is on the balance sheet would be the goodwill. Or the only thing that would be accounted for is the goodwill.
And you're aware that New Mexico Gas Company currently does not have a regulatory liability related to goodwill or acquisition premium. Is that correct?
Yes, that's correct.
And you're aware that MGC's current rates do not account for a regulatory liability related to goodwill then. Is that correct?
That's correct.
Are you aware of any investor-owned public utility operating in the state of New Mexico that currently has a regulatory liability recorded in relation to goodwill?
No, but let's clarify what my recommendation and the source of my recommendation. I'm only using the goodwill to place a value on the CCN or monopoly franchise. And so the liability that I've recommended is to capture customer benefits or benefits in general for the state of New Mexico.
Dr. Blank, in preparing your testimony, did you review the case number 19-00234, more commonly known as the El Paso Electric Company acquisition?
I reviewed the certification of stipulation only insofar as it pertained to the ring fencing and other commitments that were specified within the stipulation.
In your review of that certification stipulation, did you notice that the acquisition premium that resulted in that case was $1.63 billion, Dr. Blank?
I may have, but I don't specifically recall.
Are you aware of an acquisition premium related or goodwill related regulatory liability on El Paso Electric's books currently?
No, there's no special accounting pertaining other than the goodwill itself.
Do you think the commission should have ordered a regulatory liability to be booked in the El Paso Electric case?
I think the commission should have valued the intangible asset, which is the CCN as we're using it here, and use that valuation, which is tied to goodwill paid at the time of closing, and they should have used that to guide the decision making as to the magnitude of the customer benefits and benefits in general for the state of New Mexico.
So is it your opinion that the customers should have gotten a portion of the $1.63 billion acquisition premium?
No, the customer benefits and other benefits to the state of New Mexico should have been guided by the magnitude of that goodwill.
Since it's since it received its grant of a CCN, New Mexico Gas Company has only been able to charge customers the tariffed rates approved by the commission. Isn't that correct?
That's correct.
And you're not aware of any instance where New Mexico Gas Company included in the tariffed rates it charges to customers any amounts related to goodwill or acquisition premiums. Isn't that correct, Dr. Blank?
That's correct, not explicitly, but the anticipation when a buyer buys out a utility company, they have an expectation of earnings that will go toward the recovery of that goodwill paid. They're not going to make such an investment without an expected return of that investment.
Can you point to any place where New Mexico Gas Company's prior parents or its current parent has recovered the goodwill from customers, Dr. Blank?
It would be embedded in the earnings. Okay, so it would be embedded in the earnings, and so you cannot segment that out. You cannot separately identify that.
New Mexico Gas Company's earnings are from the charges that they charge to with their customers. Isn't that true, Dr. Blank?
Primarily, yes.
What other amounts do they receive, Dr. Blank?
I believe we've heard testimony in this case related to the AMA, for example.
Oh.
So there's other sources of revenue. But primarily, yes, it's from the regulated rates charged to New Mexico customers.
Okay. Is it your opinion that the AMA or storage agreements somehow have something to do with goodwill or acquisition premiums, Dr. Blank?
No.
Thank you. Are you aware of any New Mexico investor-owned utility ever recovering goodwill or acquisition premium amounts from customers via rates, Dr. Blank?
Again, that's not my recommendation. So the answer to your question is no, and that's not my recommendation. I'm not recommending sharing or recovery from, or a taking of the goodwill on behalf of the customers.
Dr. Blank, do you cite any regulatory body in the United States in your testimony that supports your recommendation in this case that a regulatory liability be booked in relation to the goodwill amounts or acquisition premium amounts?
No, however, commissions have either approved through a stipulation or ordered certain customer benefits to be transferred at the close of the transaction. And that is the primary focus of my testimony.
But the specific recommendation that you make in return in terms of a regulatory liability, you're not aware, are you, Dr. Blank, of any regulatory body that has approved such a recommendation?
Objection, asked and answered.
That objection is sustained.
I'm sorry, may I be heard on that beforehand, sir?
Go ahead, Mr. Haverly.
My first question was related to, did he cite anything in the testimony? And his answer was no. My second question was he was not aware of any at all, period, regardless of whether he cited it in testimony or not, Mr. Hearing Examiner. Different questions.
That was asked and answered. So that objection is sustained, Mr. Haverly. You may continue.
Thank you, sir. Dr. Blank, you understand that NMGC was created when it purchased the gas assets of PNM in 2009. Is that correct?
I believe the answer is yes. So could you restate the question just so I make sure I heard it? I heard NMGC was originally created at that point in time. Is that the question?
Apologies, I'll rephrase my question. Are you aware that New Mexico Gas Company became a utility by purchasing the gas assets of PNM and then obtaining a CCN from the PRC?
Yes.
And are you aware that in 2009, in relation to the sale of its gas assets, PNM asked the commission for permission to abandon its gas utility service obligations?
Yes.
And are you aware that in 2009, New Mexico Gas Company, or 2008, I should say, New Mexico Gas Company applied for and was eventually granted a certificate of convenience or a CCN from the commission to provide natural gas utility service in the state of New Mexico?
I have not seen that, but yes, that would be required.
Dr. Blank, are you aware that from 2009 to 2014, New Mexico Gas Company carried $146 million of goodwill on its books?
That's my understanding. Yes.
And are you aware that, well, let me ask you differently. I'm going to strike my prior question. Let me ask you this question. Is there a fee that the state of New Mexico requires companies to pay when they're granted a CCN?
No, there is not. Which is why we're having this discussion. Yes.
Okay, so we agree that PNM abandoned its gas utility service obligations with the commission's approval. Is that correct?
Well, they sold the assets and thereby also received approval to abandon their control of those assets, is my understanding.
Okay. And we agree that the Mexico Gas Company was issued a new CCN to provide utility service in New Mexico. Is that correct?
Yes, that's my understanding.
And we've established that beginning in 2009, New Mexico Gas Company had $146 million of goodwill on its books. Is that correct?
Yes, I believe that was part of the purchase price made by Continental or Continental Energy, perhaps.
So, Dr. Blank, isn't it true that from its back in 2009, the goodwill that New Mexico Gas Company had on its books had nothing to do with the value of the monopoly?
Oh, it's certainly the same arguments I make here in this case had to do with the value of the monopoly. When that ownership was transferred.
But you agree that the actual monopoly, the CCN, was not transferred from PNM to NMGC, isn't that correct?
But the effect is the same, just the name on the CCN changed hands. And so the instrument, the CCN instrument, which is granted by the PRC, it's the same instrument. So it's just a changing of ownership hands.
So is it your opinion that a utility can sell its CCN?
No, they don't. They're not authorized to sell the CCN. They're authorized to sell the company or the assets in that case.
Thank you, Dr. Blank. I don't have any additional questions.
Thank you.
Is there any cross-examination for this witness anymore? Mr. Dome? Mr. Dubois? I believe you have 75 minutes. Is that correct?
That is what I have as well, Your Honor.
Thank you, Mr. Dubois. You may proceed.
Thank you. Hello, Dr. Blank. I'm Will Dubois, representing the BCP applicants in this matter. Hello.
Hello.
You are familiar with a term, quote, control premium, correct?
Yes, I have seen that term used, yes.
Okay. And would you please define control premium?
Well, I've seen it defined as, let me first define acquisition premium as has been used in this case. So in this case, acquisition premium has been the difference between the acquisition price and the book value of NMGC. The control premium, one way to compute the control premium would be the difference between the acquisition price and the market price of NMGC. I've seen it defined in that way as control premium. So control premium is a portion of what has been described as acquisition premium in this case.
What is the market price of New Mexico Gas Company?
Well, that's a good question. Since as far as I know, New Mexico Gas Company is not publicly traded, so we don't have a market price.
You do not believe that the value of New Mexico Gas Company, consisting of its book value and the goodwill on the books, representing the additional value over the book value, represents an estimate of the market price?
I think the acquisition price that's been offered in this case is one point estimate of the overall market value, including the intangible assets.
Now, it is your testimony that in your opinion, the monopoly is the, quote, primary intangible asset of NMGC, correct?
Yes, I do say that.
What percentage, then, of the goodwill is the value of the monopoly, in your opinion?
In my opinion, it would be the majority, because other examples of intangible assets, for example, brand loyalty, brand recognition, customer loyalty, brand recognition, those examples that are commonly used are derived from the monopoly created by the government. And so, of course, in my questioning from Mr. Haverly, we discussed skilled labor, skilled management. Might there be an intangible asset there? That's certainly possible. Although one could build a labor force by hiring others, although there are some continuity value in maintaining current management up to some level, as well as the workforce. And so it's possible that there are some intangible assets that are not derived from that have value that are not derived from the monopoly.
But your proposal, despite that, is to take an amount equal to the entirety of goodwill for a regulatory liability, correct?
No, as I've explained in my testimony, the actual purchase price is under the control of the buyer and seller. And the actual goodwill will not be known until closing of the transaction. And so such a directive from the commission, as I've explained in my testimony, may lead to some renegotiation of the acquisition price, unless the acquisition price does not include the full value of the intangible assets.
Could I direct your attention, Dr. Blank, to page 10 of your testimony?
Yes.
And you see the question beginning at line 14?
Yes.
And there you ask yourself the question, quote, if the commission were to follow your recommendation to create a regulatory liability equal to the value of the goodwill, would this possibly trigger the need for a renegotiation between the buyer and seller of the purchase price? Do you see that?
Yes.
Do you disagree with the premise of the question that your recommendation is to create a regulatory liability equal to the value of the goodwill?
That is my recommendation, but the outcome of that recommendation, I believe, is in the control of the buyer and seller.
Would your recommendation change as the amount of the goodwill changes?
No. So
Okay.
if there was a renegotiated price, or if the book value, which could be increasing at this time as we speak, if the book value were to squeeze that good value of goodwill down to zero, my recommendation still stands. Or if the purchase price were to come down to squeeze out that goodwill, I would not change my recommendation.
Would you agree that the premise of what is known as the regulatory compact includes that in exchange for a monopoly franchise, a company will also accept rate regulation of its services?
Yes.
And New Mexico Gas Company is rate regulated, correct?
Yes.
And to take a hypothetical New Mexico Gas Company for a moment, are you with me on a hypothetical question, Dr. Blank?
That's fine.
Okay. Let's say a hypothetical New Mexico gas utility has a monopoly franchise and is rate regulated. Are you with me?
Yes.
Now let's say the next day it ceases to be rate regulated and can charge customers any amount it so chooses. Do you understand?
Yes.
The loss of rate regulation would increase the value of that company, correct?
Absolutely, yes.
And so the principle there applied to New Mexico Gas Company means that regulation of New Mexico Gas Company as a monopoly is depressing the value of New Mexico Gas Company, correct?
Yes, and depressing the value of the goodwill. Yes.
Should customers reimburse the owner of New Mexico Gas Company for regulations depression of the value of their asset?
No, because those rates are set in accordance to, case law and such, in a manner that is required to be just and reasonable. And so what that means is the investors are have the opportunity to earn their expected return and possibly more. And when a buyer willingly pays goodwill, they have an expectation that their expected returns will actually exceed the minimum that their investors are willing to accept.
Turning back to the distinction between acquisition premium and control premium, did I understand you correctly to say that the control premium is a subset of the acquisition premium, in your opinion?
Yes, I've heard it defined that way, yes.
Okay. And again, do I understand correctly that it is your opinion that the acquisition premium consisting of two things, the first would be the unaffected market price over book value, and then above that would be the amount that is the control premium, which would be any purchase price that is above and beyond the market price. Do you agree with that?
Yes, I think that's consistent with how I defined it.
Okay. And while you did not cite any case or any legal support for your theory in this case as to the treatment of goodwill or an acquisition premium, you did cite a article on the subject, correct?
I cited an article and a book.
Right. You cited, I believe, a chapter of that book and then separately a page within that chapter, correct?
Could you help me out, counsel? Which page, so I can double check the footnote?
Certainly. One is footnote 2 on page 7 of your testimony.
Yeah, so within footnote 2, I actually have 2 references embedded in footnote 2. So one is to an Energy Law Journal article authored by Scott Hempling.
I'm sorry, authored by?
Scott Hempling, Hempling.
Thank you.
And the other is a and that does include 2-page references from that article. And then the other is a book also written by Scott Hempling entitled Regulating Mergers and Acquisitions of U.S. Electric Utilities, Industry Concentration, and Corporate Complication.
I see. My apologies. It's 2 articles, but both by the same author, Mr. Hempling, on the same subject.
2 separate publications, and I probably should have separated those footnotes.
No.
I apologize also, counsel.
And separately on page 14 of your testimony, footnote 3.
Yes.
You cite that second item from Mr. Hempling that you were already discussing, correct?
Yes, that's correct.
Okay. Now, in Mr. Hempling's view, the only portion of the acquisition premium that he argues should be considered for sharing between the seller and customers is the control premium portion of the acquisition premium, correct?
That's correct.
And even as to that, Mr. Hempling believes that a reason for that control premium portion not to be shared would be if the target's operational performance for customers is so good that the acquirer will pay a premium to own the company responsible for that good performance, correct?
I don't recall those words. You'd have to show me what you're reading.
You don't recall one way or the other?
Well, I'd like to see the document.
Do you have access to Joint Applicants Exhibit number 39, please?
Yes, I have it.
And if you could, well, first, you do recognize this as being the chapter that you cite, authored by Mr. Hempling in both footnote 2 and footnote 3.
Well, first,
you do recognize this as being.
Sorry, go ahead.
Did you catch my question, Dr. Blank, or should I?
Yes, I recognize this chapter from that book that I cited. Yeah.
Okay. And if you could please go to page 109 of the article, of the chapter.
Okay.
I'm sorry. And do you see the heading 5.3.1 there?
Yes, the section 5.3.
And just above that 5.3.1 heading, there is a continuation paragraph. And in that paragraph, the last two sentences are, quote, a final reason for paying the control premium is the target's operational performance for customers, dash, performance so good that the acquirer will pay a premium to own the company responsible for it. Period. After analyzing these possibilities, the section concludes that only this last reason, performance merit, is a logical basis for allocating the control premium to the target shareholders, end quote. Correct?
Yes, that's what it says.
And does that refresh your recollection that the article on which you're relying indicates that even the control premium portion of the acquisition premium would not be appropriate to share if it is attributable to operational performance or to the extent it's attributable to operational performance?
That's Mr. Hempling's opinion at the time of writing this.
And do you disagree with that, Dr. Blank?
I don't necessarily disagree or agree. I think I'd have to give it a little more thought, and I have given this some thought, but I'm not quite following Mr. Hempling's logic here. My approach has been a little different than Mr. Hempling's, where I have approached this more as a bottoms-up analysis, recognizing the intangible assets and the valuation of those intangible assets, trying to identify intangible assets. Perhaps this may be one of those intangible assets, but it's fairly well established in finance theory that goodwill is paid to cover those intangible assets that are not found on the books of the company. So I'm approaching this a little different than Mr. Hempling.
So you are citing to Mr. Hempling as support for your arguments, but you disagree with Mr. Hempling on both the point one, that the portion that would be appropriate for sharing of an acquisition premium is only the portion above the market price. And second, you're not sure whether or not you agree with whether the subset that is over the market price that is attributable to quality of operation should be shared.
Objection, compound question. It's actually a triple.
It's
Mr. Dubois.
Your Honor, that is one unitary, cohesive thought and question. There's no way to separate those out. I can ask one, then the other, and then ask them together, I think. But I think it is one question.
Well, there's, you ask, but you disagree with Mr. Hempling on both the point one, and then you ask, and second, you're not sure whether or not you agree. So maybe just ask that question in two questions, Mr. Dubois.
Thank you, Your Honor.
Simplicity. Thank you.
So, Dr. Blank, while you are relying on Mr. Hempling, first, you have disagreed with him insofar as while Mr. Hempling asserts that only the portion of the acquisition premium that would be over the market price should be shared with customers. That is your first point of disagreement, correct?
Well, and I thought that was his argument, but the specific words that we just read, it says allocating the control premium to the target shareholders. So now I'm not quite sure what Mr. Hamlin's suggestion is here, but let me clarify. On his economic analysis, I do not necessarily agree with Mr. Hamlin. Okay, but on his concept that there is value in the government created monopoly, what he calls a franchise, what we've been referring to here as a CCM, on that analysis, I do agree.
Elsewhere in this chapter on which you rely, Mr. Hempling is quite clear in distinguishing and defining control premium versus acquisition premium as the control premium being the subset of the acquisition premium that is above the market price of the utility, correct?
Yes, that's correct. And it is my understanding that his argument here is that the extra value, the so-called control premium, is derived mostly from the market position protected by the government, or the monopoly position protected by the government.
And so applying Mr. Hempling's principles here, there would be no sharing because there is no control premium above the market price of New Mexico Gas Company available to be shared, correct?
No, that's not correct. What we are lacking is a market price. There's no market price. And so if one wants to agree with Mr. Hempling's economics, you would have to bifurcate the total goodwill that is paid. You'd have to bifurcate that into two components, and we're simply not able to do that. However, as I said, my economics is approaching this somewhat differently. From a valuation, recognizing established economic and finance theory that goodwill is paid for intangible assets for which we don't have on the books of the company.
So to be clear, you disagree with Mr. Hempling on this, correct?
Only on this control premium discussion. Much of what he has included here, I do agree with, including that there is a value of the government created monopoly. That value is embedded within the goodwill paid. And on those points, I do agree. As I said earlier, I do not necessarily agree with Mr. Hempling's economics or economic analysis.
There is therefore no case, law, treatise, or other text on which you rely or that you cite in support for, that was a compound question. I'll start that one over.
Mr. Dubois, okay, I may have froze up.
That's okay. I was asking a question that probably would have been objected to.
Mr. Dubois froze up.
Dr. Blank, you're coming in loud and clear and in full video, so there's no problem on my end.
Okay, Mr. Hearing Examiner, you hear me okay?
Yes, I can. I believe we all can.
Okay. Could you state your question again, please?
Dr. Blank, therefore, you do not have any citation in your testimony in support of your opinion to any case, treatise, or other document in support of your theory on which that actually agrees with your theory, correct?
The only treatise I have is Mr. Hampling's treatise that I've provided. Yes. I don't have specific case law. I don't have specific legal citations. That's correct.
Could you please pull up what has been marked for identification as joint applicants exhibit number 37?
Yes, I have it.
Okay. And I'll try not to reach reverse territory you and Mr. Haverly already covered, but I do want to make sure that we are on the same page going into some questions. So just to start out, for the
objection
column,
is 37 in the Dropbox. I do not see it.
I just downloaded it from there myself.
When was it added to the Dropbox?
I would have to check with others, but I think Monday.
Mr. Dubois, no, I don't have it either. I think there may be some anomalies with the Dropbox. That is not to say that you did not have it uploaded on Monday, but it doesn't appear for me here.
Okay, I will try to ask my questions without using it then. It was just intended to simplify, keeping us on the same page on what names and numbers we were using. But thank you, Your Honor.
Well, whatever suits you best. I want to make sure we have a good record. So if you need to, we can make arrangements. But if you feel comfortable proceeding, you can do that as well.
Thank you. So, Dr. Blank, let's try to walk through some history to make sure we're on the same page as the premise for some additional questions, please. And I apologize to the extent I may retread some of the ground you had with Mr. Haverly, but I want to make sure that we're clear. Okay?
Yes.
So in 2009, Continental and owned by the private equity firm Lindsay Goldberg bought what is New Mexico Gas Company from PNM, and a goodwill amount of $146 million was booked at that time, correct?
Yes.
And then in 2014, TECO bought New Mexico Gas Company from Continental, and the goodwill value booked in association with that purchase was $408 million, correct?
Yes.
And that was an increase of $262 million, correct?
Yes.
And then in 2015, Emera, to be specific, Emera US Holdings, Inc. purchased New Mexico, well, I'm sorry, start that over, be correct. Emera US Holdings, Inc. purchased TECO from TECO's shareholders, correct?
Yes.
And the amount of goodwill remained $408 million, correct?
Yes.
And then last summer, in conjunction with the purchase and sale agreement being signed between Emera US Holdings, Inc. and Saturn Utilities Holdco, New Mexico Gas Company revalued its goodwill and decreased it to $212.4 million, correct?
Correct.
And that was a decrease of $195.6 million, correct?
Correct.
And then you discussed that further reduction that took place in August with Mr. Haverly that left the goodwill at $156 million, correct?
Correct.
And that $156 million is in aggregate a $252 million reduction relative to the goodwill that was on the books as of the time prior to the signing of the purchase and sale agreement between Saturn Utilities Holdco and Emera US Holdings, Inc., correct?
Mr. Dubois, maybe it's on my end. I don't know. You froze up again, but it might, I don't know if it's on my end. Could you finish your last, I think there was a question you were stating.
Would you like me to read it again, Mr. Dubois?
Well, what I was going to ask to check, Your Honor, would be whether I'm freezing up for you and others as well.
Then it must be on my end, Mr. Hearing Examiner. Hopefully it'll stabilize.
Thank you, Your Honor, but I can re-ask the question.
Okay, go ahead, Mr. Dubois.
So Dr. Blank, in aggregate, the reduction from $408 million of goodwill prior to the purchase and sale agreement to $156 million now was a decrease of $252 million, correct?
Yes, and there's an explanation for that, and it does not necessarily constitute a loss associated with this sale.
So in the instance of the establishment of the $146 million goodwill from the Continental purchase, is it your opinion that there should have been a $146 million regulatory liability established at that time?
No, because that would have to come in a ruling, and you would have to afford the buyer and seller some time to think about whether they were willing to accept that ruling or the possibility of renegotiating the purchase price. So it would not have been 146 million under the recommendation that I'm stating here.
Is your opinion as to the $408 million goodwill amount in the 2014 TECO Continental transaction the same, that would not necessarily have been the amount for a regulatory liability?
Correct. We don't know what it would have been if the commission had rendered a decision that included my recommendation. And I remind the hearing examiners, the commissioners, that I also made an alternative recommendation, but yeah, the same answer applies here.
Let's say hypothetically, there had been a $408 million regulatory liability established. Are you with me?
Yes.
What would the offsetting accounting entry have been for that $408 million regulatory liability?
I'm pausing. First of all, to be clear, I'm not an accountant. Okay, so I'm giving it a little thought here. I don't know. And again, I'd have to research that a little more because I'm not an accountant.
Let's say hypothetically, someone figured out the accounting for that and did book a $408 million regulatory liability. And at a subsequent date, while that regulatory liability was still the round number of $400 million. New Mexico Gas Company had taken a $100 million goodwill impairment for whatever reason. Are you with me?
Yes.
Would the regulatory liability have been reduced by $100 million in your theory at that point?
No, because again, the 408 is not likely to have been the amount. And so the answer is no.
Are you aware of the amount? Let's start over. As to the $146 million goodwill value in 2009, are you aware of what ratio there was between the amount of goodwill and the value of rate credits and other financial benefits provided to customers of New Mexico Gas Company?
No, I'm not familiar with any commitments made by Continental. So I don't know.
And as between customers and, sorry, let me start over. As to the TECO Continental transaction and the $408 million goodwill amount there, are you aware of the ratio between that amount of goodwill and the direct financial benefits provided to customers?
No, I'm not. But this is a good point to clarify my recommendation. If there are other benefits, they would be reduced from what I'm recommending as a regulatory liability. So, but no, I don't know. I don't know what the benefits to customers or the state of New Mexico were as part of that transaction.
And is your answer the same as to the 2015 transaction between TECO shareholders and Emera US Holdings, Inc.?
Yes.
In your opinion, does the $252 million decrease in the amount of goodwill on New Mexico Gas Company's books reflect a $252 million decrease in the value of having a franchise to serve New Mexico Gas Company customers?
Well, the 156 million from which the 252 is derived is the current valuation by the buyers as to the appropriate purchase price. I mean, it's tied to the purchase price, right? And so the let's start there. The 156 million is, if that's what the goodwill ends up being, is the is what the sellers are able to get. The $252 million decrease is, one might ask, why would a seller be willing to give up $252 of their own money that they put into this company in the form of goodwill? And the reason for that is when goodwill is paid, there's an expectation of a return of that goodwill. Even though it's not explicitly included in the rates that are set by the PRC, there are earnings that are generated that help to buy down that goodwill. But unlike plant, which is depreciated, and other assets that might be amortized, in the goodwill is not amortized. And so, and we're also not able to dissect the earnings that have been generated by New Mexico Gas for their investors. But to say that the investors have lost $252 million is not necessarily true, because they've had 10 years to recoup that goodwill through earnings.
They have also increased their investment in New Mexico Gas Company since they purchased it, correct?
That's correct, and that has added to the book value of the company. That's equity that they have put back into the company, absolutely. And that also goes to pay back that goodwill.
And you yourself have not calculated whether, in your opinion, there's actually been any gain or loss, or would be any gain or loss associated with this transaction, correct?
I've given thought to what you're asking me. I believe a study could potentially be completed. It would only be an estimate. I'm not sure. I mean, one could try to estimate that, but the level of accuracy would be probably questionable. So the answer is no. I don't have that calculation as to how much of the earnings has served to repay Emera for that goodwill.
Your Honor, may I have 1 minute to try to make sure I'm not about to re-ask questions that have already been asked by Mr. Haverly?
Of course. Take your
Thank
time.
you. Do you believe it's, Dr. Blank, do you believe it's possible for your estimate of the value of the franchise to vary substantially from year to year?
Yes, the value of that franchise and other intangible assets can vary. Absolutely.
Dr. Blank, as to, I'm sorry, let's go to page 4 of your testimony, please. We can put this exhibit aside.
Yes, I'm there.
On lines 17 to 18, you state that you provide analyses and recommendations regarding the magnitude of customer benefits resulting from this sale, among other things, correct?
Yes.
Okay. Was that assessment of the magnitude of customer benefits left to your discretion as to what approach you would use to assess that magnitude? Or did you receive guidance as to what methods to apply?
Oh, I received no guidance from staff as to what methods to apply. So my methodology, evaluating intangible assets, evaluating the monopoly value, or CCN, the meaning of goodwill and how that is a valuation of intangible assets. All of that I derived on my own without direction from staff. again, for the purpose of guiding the decision making as to the order of magnitude of benefits to the state of New Mexico or NMGC customers specifically.
Thank you, Dr. Blank. Thank you, Your Honor. Those were my questions.
Thank you, sir.
Thank you, Mr. Dubois. I believe that Mr. Rossi, do you have any redirect?
I do have a redirect. Would you like to, or would you like me to go first, or would you like to go first?
I don't have any questions
Okay.
for the witness.
Do. Good afternoon, Dr. Blank.
Good afternoon, hearing examiner Hurst.
I think I generally understand your testimony, but I did have a couple of questions. In response to, and I don't remember if it was Mr. Haverly or Mr. Dubois, you testified that, and I think the question had to do with Ms. Hutt's characterization that the because of the impairment to the goodwill or acquisition premium, that Emera was actually going to categorize the transaction as a loss. Do you remember those questions?
Yes, ma'am, I do.
And I think your testimony was a loss isn't indicative of a loss on the sale. Was that your testimony?
Yes, to represent that as a loss on the sale is highly misleading. And
well, can you tell me what it means to you?
Yeah, so if you go back to Ms. Hutt's testimony when you are reviewing the record, you'll see that she was very careful to specify accounting entries. So she treated these as, accounting entries. Yes, there's been a negative adjustment in the goodwill as an accounting entry. Where I feel she went too far is the suggestion that this is indicative of a loss, that Emera is taking a loss on this sale. And the reason is because the recovery of goodwill does not only come at the time of sale of the company. They have had approximately 10 years to recover that goodwill through earnings. And so what I'm explaining is the write down, the 252 write down of goodwill that we've seen in the last year or so is not an indicative that they're taking a loss on this sale. And that's again because of earnings that have been generated. Some of those earnings have been invested into the book value of New Mexico Gas, and some of them have been paid out as dividends. And so to suggest that the investors are willing to give up an asset with a $250 million loss is highly misleading, and I find very difficult to believe.
Do you think they actually would, if they were going to have a $250 million loss, that they would have gone ahead and sold New Mexico Gas?
I don't think so. I don't think so, especially the pushback that I have seen against even my alternative suggestion of $100 million in benefits, which actually is pretty close to Mr. Boudier's total estimate of the monetary benefits to New Mexico. I think he was at about $80 million, but they pushed back hard on that. I don't think they'd be willing to accept a $252 million loss. So again, to represent it it as a loss on this transaction is very misleading.
And that was the next thing that I was going to ask you about is you testified that you were only using goodwill to place a value on the CCN to capture customer benefits or benefits for the state of New Mexico. Do you recall that testimony?
Yeah, so the regulatory liability that I've recommended, I've made clear that the that would be adjusted downward for any decisions that come from the commission specifying benefits. You know, we have this table in Mr. Boudier's testimony, which has listed out benefits. I don't know if that would be helpful, but yeah, so the regulatory liability that I've recommended is just a parking place for the benefits that either could be decided in this case, and if they are, such as rate credits. So if there's a decision that there will be $20 million in rate credits, that would be deducted from the regulatory liability that I'm suggesting.
So then in essence, what I'm understanding your testimony to be, when you say you're only placing a value, you are using the regulatory liability and what you saw as the value of the regulatory liability as a methodology to quantify the amount of benefits that you thought that the customers should receive in the transaction?
Yes, to guide the decision making, to guide the decision making as to what the benefit should be coming out of this transaction. Yes, ma'am.
And is there any other way to, other than using the goodwill or the acquisition premium, is there any other way to quantify a level of benefits?
Perhaps there are. You know, when we look at merger or acquisition cases, some of these things have been offers from the buyers, right? And so those offers are accepted, but they're somewhat arbitrary in nature as to the amounts. What I was trying to do was to quantify based on, you know, using well-established finance theory, which indicates that goodwill paid is that buyer's valuation of the intangible assets, not on the books of the company. And one of those intangible assets, which I believe is a large component of that, is the monopoly protection afforded it through its CCM.
So you just had indicated in answer to the question that you believe that your evaluation was actually close to Mr. Baudier's valuation of benefits?
Yes, ma'am. Let me try to identify that page number. It was discussed, I think, within the last couple of days. There was a table in Mr. Boudier's. Oh, you know, it's in his, I'm sorry, ma'am, it's in his rebuttal. It's in his rebuttal. Yes, so his rebuttal testimony, and I forget what exhibit number this is.
3.
Okay, so joint applicants,
I think.
Exhibit 3, page 48. It is JA table JMB-2, revised application rebuttal.
And so in that particular table, which is entitled Comparison of Enhanced Monetary Benefits, there's a total of between around 77 million and 87 million.
Yes, ma'am. And so if I take that as a firm commitment and the joint applicants seem to feel strongly that's a true monetary transfer away from the buyers of NMGC to these various benefits. And my recommendation, my alternative recommendation was 100 million, which actually would maybe be a little lower now that we have an estimated goodwill at 156 million, because what I was doing was taking the 212 million, dividing by 2, and then to make it a little conservatively low, I came up with 100 million target. But here we see a monetary benefit commitment from the joint applicants, which is approximately half of that amount. And so that's consistent with my recommendation. The only thing is I would caution that as we have heard from some of the parties, not all the parties agree with these calculations. Cash.
What about you?
Cash is king. So I'm sorry to use that, but it really is. If this is a true commitment from the joint applicants, then let's make those commitments to those that are tangible commitments. And some of these that are very speculative, such as the rate case delay amounts, let's convert that into you could put it into a regulatory liability. Staff has recommended a severe weather fund, or you could hold it in a regulatory liability for disposition at a later time.
So by saying cash is king, you seem to be implying that the commission ought to hold them to what they have projected is the value of that benefit.
That would be my suggestion. Rather than quibbling about the calculation, allow them to file a rate case tomorrow. They can file a rate case anytime they want. Thank you for the offer. Yes. And my testimony helps to support that, in that I've come up with a valuation of total possible, benefit for consideration, and it's within that range.
Since you seem to be perhaps amending your recommendation based on a lower value of the acquisition premium, which you used to put a monetary value of 100, and you think this potentially comes close to that, does that change or alter your testimony such that you would be supportive with these numbers to recommend to the commission that in conjunction with the rest of staff's testimony, that the acquisition be approved?
So yeah, so let me clarify. I made a primary recommendation which was the creation of a regulatory liability equal to goodwill at closing. Subtract out any commitments that are adopted by the commission, such as rate case, or I'm sorry, such as customer rate credits. Deduct that out of there. My alternative recommendation was $100 million. Same process, deduct out any specific monetary commitments that are adopted by the commission in this case, and hold the remainder in a regulatory liability for disposition at a later time. Now the estimate of goodwill has come down to 156 million. Now, a word of caution, I have not seen any work papers related to that calculation of 156 million, so I cannot confirm how good that estimate is. If they've been provided, I've not seen them. I think that estimate came in not too long ago, but if we hold that estimate as being a good estimate, then we divide that in half, because that's the effective result of my primary recommendation. If we were to allow the buyer and seller to renegotiate the purchase price, I expect they would end up somewhere in the middle, and goodwill would be reduced by approximately 50%, which I think is a fair and reasonable outcome in this case. That 50% of that goes to Emera and 50% goes, and again, that would be decided between the buyer and seller, because you cannot direct goodwill. All of that goodwill goes to the seller, goes to Emera. But I'm sorry to be so long-winded on that, but yes, it's interesting that my revised alternative recommendation is very close to Mr. Boudier's total monetary calculations. However, I do not agree with all of these recommended commitments, especially the rate case delay. They believe that's true, and that's a monetary impact on New Mexico Gas. Well, let's convert it into some other purpose.
So I don't think I heard the ultimate answer there. I think you quantified exactly what you were saying. But if the commission were to adopt your recommendation, and from your perspective on the staff team, would you be recommending approval of the acquisition?
So there are other staff witnesses who have already testified to staff's recommendation. I think that a verifiable, quantifiable benefit on the order that we see in Mr. Boudier's table, real money going to real benefits I suspect that would rise to the level of satisfying staff to be supportive of this transaction.
And staff includes you?
Well, I'm a consultant, so I can't speak for staff. I can only give my own opinions, my own expert opinions, but I have a suspicion that probably would rise to the level of satisfying staff, but I can't speak for them.
Right. But would it rise to the level of you supporting it?
Yes.
Thank you. I don't believe I have any other questions for you, Dr. Blank. Did you indicate, Mr. Rossi, that you have some redirect for Dr. Blank?
Yes, I do. Thank you.
I'm sorry, hearing examiner Schaefer.
Oh, go ahead.
I finished my question, so
this is a team effort.
please go ahead.
Yes, please proceed, Mr. Rossi.
Thank you very much, both of you. Dr. Blank, do you recall the hypothetical that Mr. Dubois was asking you about?
Yes, if you could refresh my memory, please.
We'll go through it again because I wanted to go through it and then I'm at a step. So we have a hypothetical natural gas company that suddenly, all of a sudden, rate regulation ceases. What happens to the value of that company?
Objection, Your Honor. Bill Dubois.
Go ahead, Mr. Dubois.
Asked and answered.
I'm merely resetting up the foundation to go on to a one variable continuation of his hypothetical. I think it's reasonable to go through it very quickly.
Maybe you could just ask the witness if he remembers the specific hypothetical you're trying to set up.
I started with that and he said, could you remind me, or something like that. It's now scrolled off the Zoom backup.
Okay, well, just try to ascertain from the witness if he remembers the hypothetical that you're trying to ask about as quickly as possible.
May I have permission to do this as a cross question?
No, let's just proceed on direct examination, Mr. Rossi.
Do you recall this hypothetical that we're discussing?
Yes.
And to set out the hypothetical, what happened when rate regulation disappears?
When rate regulation disappears, the company now is free to charge excessive rates, monopoly profit maximizing rates. That's going to draw excess returns, excess earnings, monopoly level earnings in excess. And by excess, let me clarify, by excess above the expected returns expected by the investors. And I would expect those to be substantially above the expected returns of the investors. And for that reason, the valuation of this company is going to go up considerably.
And then what happens to the goodwill value?
The goodwill value, I would expect to go up as well. Given, initially, this is still a monopoly gas distribution company under the hypothetical. And so that the total goodwill is likely to I think it's likely to increase. But with time would probably decrease as depending on what happens on the competition side, because I'm assuming in the hypothetical, we're also opening the market to competition.
Not yet in the Haverly that you were asked about. So what happens to goodwill without competition?
Well, the value of the company definitely goes up. So if the book value of the assets remains the same, then goodwill goes up.
Now let's add competition. What happens to the value of the company?
Well, competition would tend to erode the value of the company and would erode the level of the goodwill.
So once competition is added, goodwill falls considerably. Would you agree with that?
Objection, Brian Haverly.
Haverly.
Question on redirect, Mr. Hearing Examiner.
Mr. Rossi.
I withdrawn and I can rephrase.
Thank you.
Once competition is added, how much, you've mentioned goodwill falls. How much does it fall?
It depends on the rate of development of competition. And so I can't quantify it. It's depends on how quickly competition develops, what types of competitive alternatives arrive. It could take some time, but I would expect it to fall.
Okay. Do you recall the conversation with Mr. Haverly about originally back, I guess it's roughly 2014, the gas company had $400 million or so of goodwill on its books left over?
Yes.
And then after that, it's fallen. Can you walk us through what do you believe caused that fall?
So actually, there's two steps there where the goodwill remained unchanged. So you had a transfer of ownership to TICO, in which the goodwill was 408 million. Approximately a year later, there was another transfer where the goodwill remained the same, which is at 408 million, which does not surprise me because not enough time has elapsed for any meaningful recovery of that goodwill through earnings. So then now we have approximately a 10-year period. We have a seller in Mara willing to sell at a purchase price that, given the current book value of the company, the implied goodwill is now less. And that is why we have seen an impairment according to accounting rules, maybe Securities and Exchange Commission rules. But the accountants know what they're doing. And so they had to write down an impairment from that based off of that purchase price. I believe, as I've testified, the reason for the willingness of Emera to sell at a purchase price that includes less goodwill is because they've had 10-year opportunity to recover some of that goodwill or a portion of that goodwill through earnings. Some of those earnings could have been put back into New Mexico Gas, which increases the book value of New Mexico Gas Company, and some paid out in the form of dividends.
When EPE, or you had a discussion about the EPE case as well as the goodwill values in there. Actually, scratch that. I'm going to ask a different question. Goodwill, when it comes to a sale, we have a good way of, I guess I shouldn't use good twice in there. We have a way of measuring the goodwill during a sale. Do I understand that correctly?
So during a pending sale, is that the question?
Yes.
So that's what New Mexico Gas Company has done, starting with the purchase price over a year ago and the impairment that was written down. And so they've got their calculations for that. The second impairment that occurred in August, I believe, like I said earlier, I don't have any information as to what caused that, or I've seen no work papers or description of that. Maybe it exists in the record, but I'm not aware of it. And so, yes, I mean, there's a way in which the accountants, maybe with some assistance, can identify changes in or expected changes in the goodwill. And the reason for that impairment, as I understand it, is that investors need to be put on notice that that asset is likely to, well, is expected to decrease.
you've started to answer my second question, actually, and that is when there's not a sale, how do you calculate what the goodwill is?
Well,
Objection, Brian Haverly.
Mr. Haverly?
Foundation, Mr. Hearing Examiner, we are getting into very complex accounting principles, and there's been no demonstration that Dr. Blank has the foundational expertise to offer opinions on how you value goodwill in accounting terms pending a transaction.
We've been discussing goodwill for the last 2 hours. I think a high-level explanation is reasonable.
I think a very high-level explanation, I believe Mr. Blank has described in cross-examination how goodwill has been determined. So I think he can answer the question if he knows. So please proceed, Mr. Rossi.
Could you please restate the question?
When there's not a sale pending, how do they calculate goodwill to see if it's still accurate or to see within the accounting?
It would have to be something expected to cause an impairment, and I don't know. I don't have an example of that.
Okay. I'd like to move on to the discussion that you were having with Mr. Dubois about the Hempling text a bit and his control premium. How does control premium work in a regulated market?
In a regulated market or unregulated market?
Well, in a regulated market like this.
So again, his concept of control premium is the difference between the purchase price and the market value. For publicly traded companies, that's relatively easy to calculate because it'd be based off of the unaffected stock price prior to the announcement of the acquisition agreement. And it's not something, I mean, that calculation is the same whether it's a regulated company or an unregulated company.
How do we get that market price when it's not a publicly traded company?
Very difficult to do that.
And because it's difficult to do that, does using Hempling's control premium exactly as Mr. Dubois was trying to do, does that work? Can you tell us about that?
In this case, no.
And is that where your difference in how you're proposing your ideas here, is that how it differs from Hempling's?
It goes beyond that. I was not motivated necessarily by the fact that we do not have a publicly traded company in question here. I was motivated by the economics. I don't necessarily agree that the valuation of the intangible asset that's been discussed, which is the monopoly, is limited to the what's been defined as control premium. There's other reasons why a control premium is paid, to have majority ownership in the company. Okay. I can do that either through 51% of the shares of stock if there are publicly traded shares, or other shares, not publicly traded shares, or I can buy the entire company, and that gives me control of management as well, board of directors, etc. So I don't necessarily agree with, again, Mr. Hempling, all of Mr. Hempling's economics. Just the core, the core fundamental concepts that he has put forward in these publications regarding the value of the government-created monopoly.
And then finally, when you were speaking with Mr. Haverly, he was talking about the not the transfer of the CCN, the abandonment, the sale, and the creation of a new CCN. Do you recall that conversation?
Yes.
What happens to the monopoly throughout that whole process?
The monopoly continues to operate. There's no interference with service. It continues to operate, and the customers are unaware that these financial transactions are ongoing or have been completed.
So even though PNM had an abandonment, New Mexico gas was created, the monopoly still moves through is a sale from one company to the other. Do you agree with that?
Yes, the title of ownership changed, but the monopoly itself and those assets remain the same.
I have no further questions for this witness. Thank you.
Thank you, Mr. Rossi. For recross, Mr. Haverly, do you have any further questions for the witness?
I do. 1 second, please. Can you hear me, Mr. Hearing Examiner?
Yes, sir. Loud and clear.
Thank you, sir. Dr. Blank, you said that when you're talking with Hearing Examiner Hurst that recovery of goodwill was possible through earnings. Do you recall that?
Yes.
What adjustments to goodwill are being made when earnings are realized at NMGC?
They're not, because goodwill is not amortized, it's not depreciated. So it's very different than other assets on the balance sheet, such as plant and service, which is depreciated, and other types of assets that might be amortized. In the case of goodwill, it's not amortized. So there's no debit entry to the goodwill.
Okay, so I think what I heard you say was there aren't any adjustments made to goodwill when there are earnings realized at NMGC. Is that what you said?
On the books, there are not. That's correct. The investors know what they've paid, and they know what they need to get out of the assets that they have invested in.
And you understand that the accounting of goodwill is governed by the generally accepted accounting principles?
Yes.
And there is no provision in those rules for adjusting goodwill based on earnings. Is that correct?
That's my understanding. That's my testimony, and based on my understanding, yes.
And you understand that as part of Emera's family of companies, New Mexico Gas Company's financials have been audited for the last decade?
Yes.
And the auditors have, until this acquisition, have not made any adjustments to that goodwill amount. Is that correct?
Objection beyond the scope.
Mr. Haverly?
I'm asking about how goodwill is accounted for and how it's adjusted, which was the focus of the discussion with Hearing Examiner Hurst. And then Mr. Rossi asked quite a few questions about goodwill and how it's counted. So I'm going down that path and asking recross on that.
This is about the accounting history. That's beyond the accounting and auditing. That's beyond the scope of the calculations of it.
Let's not go too far, Mr. Haverly. I'm going to overrule the objection and allow Mr. Haverly to make this question, but let's keep it close to the scope of the prior testimony. Go ahead, Mr. Haverly.
Thank you, Mr. Hearing Examiner. Dr. Blake, do you recall my question?
I do. You are correct. There's been no reason to write down an impairment. I'm not an expert on everything that rises to that level to require an impairment in the accounting. Clearly, when the acquisition price was specified, In this case, that was a clear indication requiring the need for impairment. And there's been no need to do so in between during that 10 years prior to that, or 9 years.
Dr. Blank, you said that you would find it hard to believe that Emera would sell New Mexico Gas Company at a loss when you were talking with hearing examiner Hurst. Do you recall that?
Yes.
If Emera's public accountants performed their accounting function to determine that there was a loss on that investment, would you still find that hard to believe?
Oh, I've already said from an accounting point of view that with this impairment, we're now expecting $250 million reduction in the goodwill from the balance sheet. And so from an accounting point of view, that's correct.
What other view is there other than the accounting view when you're determining a gain or a loss, Dr. Blank?
The view of the investors and the amount of money that they have earned and recovered against this investment they made, which included goodwill. That's what matters, is keeping the investors happy. And the investors also have the authority to determine whether to sell. And they've chosen to sell with an accounting loss, as has been described, of 252, maybe 252 million. And,
so
and my testimony was that I find it hard, I would find it hard to believe that they would sell at a real loss of $252 million, which I believe is over 20% of the book value of the company.
Are you recommending that the commission disregard the accounting rules in determining whether there was a loss on the sale, Dr. Blank?
Absolutely not. What I don't want, what I'm suggesting is the commission not put much weight on that when it's considering on customer benefits and the magnitude of those benefits. They should not put weight on that accounting exercise.
So the commission should feel free to put weight or not put weight on various accounting principles as it suits them. Is that what you're saying?
The accounting principles are, as you've stated in your earlier question, adhere to very strict accounting rules. What I'm suggesting is that the valuation of this company at the time Emera bought it and the evaluation today and their agreement to sell this asset, what I'm suggesting is over that 10-year period of time, they have recouped their investment.
Are you aware that the public accounting standards are to help inform investors of the performance of the companies? Dr. Blank?
Objection. This has been asked and answered.
Haverly?
I did not ask that question.
I don't recall that question having been asked either. I will overrule the objection and allow Mr. Haverly to ask the question.
The accounting standards are mostly important to properly inform as to the current status of the company. They're not trying to track down earnings. They're not trying to track down 10 years worth of earnings, that some of which went to repay the goodwill that was paid by the investors. As far as I know, they're not tracking earnings in that way. So
the accounting standards aren't tracking earnings, Dr. Blank. Is that what you're saying?
They're not breaking it down into goodwill versus other. It's earnings are one amount. Either they're retained and reinvested into the company, which is clearly accounted for, or they're paid out in dividends, which is clearly accounted for. As I said earlier, we do not amortize goodwill. So we don't know exactly how much they have been that they have recovered from that goodwill amount.
Mr. Hearing Examiner, I appreciate the opportunity to ask those questions. I have no further recross.
Thank you very much, Mr. Haverly. Mr. Dubois, do you have any further questions for this witness?
I do, Your Honor. Thank you.
Go ahead.
Dr. Blank, I would like to ask you some questions.
Excuse me, sorry, Mr. Dubois, just one, we're about 2 hours, and I'm just cognizant of Mr. Lee's diligence and efforts. Do you know maybe how much time you'll need, just so I can decide if we should take a break now or just continue with your questions? Mr. Lee, how do you feel?
I feel good, Judge.
Okay.
I would estimate 10 minutes, perhaps, Your Honor.
Okay, and no rush, just for situational awareness and expectations. Go ahead, Mr. Dubois. Thank you.
Thank you, Your Honor. Dr. Blank, I'd like to pick up on your opinion as to what Emera would do with respect to selling or not selling at a loss, with my questions being framed as your analysis of loss independent of accounting measures. Okay?
Yes.
Okay. And as a general matter, are you saying that it is your belief that an investor such as Emera would not sell an investment such as NMGC at a loss?
I'm not saying that it's impossible for that to happen. What I'm suggesting is let's be careful describing the accounting of this as a loss of the original investments made by Emera. It's very well established in finance theory that when goodwill is paid, there's an expectation to earn that back. Even if the goodwill, as I believe Ms. Hutt specified, remain the same for the next 100 years. During that course of 100 years or the past 10 years, the investors have had the opportunity to recoup some of that goodwill.
Let us consider a generic entity, a generic investor that holds 10 investments. Are you with me?
Yes.
And we'll assume it has limited additional cash on hand. Okay?
Okay.
Now, let's say it wants to substantially increase its investments in 9 of the things that it owns, with limited ability to borrow money to make those investments. Are you with me?
Yes.
Wouldn't a rational thing for that investor to do be to sell the 10th asset it does not want to invest in order to raise funds to invest in the other 9?
Well, certainly they could do that. They could liquidate that 10th asset and use that cash for an alternative investment. I would need more information to know whether that was rational. I don't know if you said this, but the implication was they're selling that 10th at a loss, but they're taking the proceeds and investing it elsewhere. We'd have to look at expected returns from all of those assets. So it's a complex calculation, but those circumstances, I agree, could arise.
And you are familiar, are you not, with the principle of the sunk cost fallacy?
I'm familiar with sunk cost. Maybe I'm forgetting what the fallacy part refers to.
Do you believe it is rational to hold an investment simply because it is sitting at a loss?
Well, again, we're working with a hypothetical. The hypothetical does not describe New Mexico Gas Company. It implies that they have been incurring annual losses, which to my knowledge, they have not. But the only thing that gave rise to this purported loss, which is an accounting entry loss on goodwill, the only thing that caused that was the offered acquisition price and the agreement by Emera to sell. So I don't know. Your hypothetical seems to be getting a little bit far out there, and there's too many data points required to adequately answer it.
Are you aware, Dr. Blank, that Emera has said that the reason it wants to sell New Mexico Gas Company is to raise money to pay down debt and make investments in its other assets?
I would expect that to be the use of those monies. Yes, that's common to when you sell any asset.
If you yourself were making a recommendation to an investor in the hypothetical scenario of holding 10 assets, wanting to invest in 9, not wanting to invest in the 10th, would you advise not to sell the 10th on the basis that that sale might be at a loss?
Again, I would have to compute, right? If indeed it was a sale at a loss, I would have to compute the expected return on the monies that would be reinvested. It's done internally, right? And so
you told Mr. Rossi that goodwill would be decreased when the value of the asset of the company, quote, is expected to decrease, end quote. Do you recall that?
Yes.
That's incorrect, though, correct?
I'm sorry. Maybe you should ask him. I'm not following your question.
Goodwill is actually adjusted when the value has decreased, not when there's an expectation for it to decrease, correct?
My response to Mr. Rossi's question was in the context of a future sale. So under the hypothetical, as I remember it, which was allowing competition or removing rate regulation, we would only know the value of goodwill at the time of a transaction. However, internally and externally, potential investors in that company can assess the goodwill. And so even though there's no change in the accounting records, goodwill is assessed by financial experts commonly.
Goodwill is used to represent or to account for the difference in value between the best estimate of the market value of the company and the book value of its assets, correct?
Yes, it's a valuation of the intangible assets. So you can either go top down, which is the approach you're suggesting, or bottoms up. You could take the book value and add in the value of the intangible assets.
Now, you told Mr. Rossi that if, say, New Mexico Gas Company ceased to be rate regulated, its value would increase, which would be accounted for by a write-up of the amount of goodwill, correct?
No. What I was referring to was market value. The market value would go up. And so the implication is the goodwill as assessed by the market would go up, not as an accounting entry. The accounting entry would only occur if you sold the company.
Wouldn't it be violating generally accepted accounting principles for a business to refuse to revalue its goodwill if it knows there has been a change in the value?
I don't know if they can mark up the goodwill without a market determination, which occurs at the time of a sale of the asset. But I don't know, I guess. Your hypothetical is, again, I'm speaking from a market valuation approach and not from an accounting approach. And your question seems to be coming from an accounting approach.
And you just don't know how the accounting for goodwill works in that scenario?
For an increase in goodwill, it would occur after the sale and the higher goodwill, just like we had when Tico purchased NMGC from Continental, and now the goodwill on the books of NMGC went up considerably. There you go. That was, I'm assuming that followed proper accounting.
What was the offsetting accounting entry?
Objection beyond the scope and whether this is relevant at this point.
Mr. Dubois?
Your Honor, Dr. Blank has now given a series of answers stating his opinion of how the accounting for goodwill would work. And he is providing partial responses. And this question is to ask him the other part of the accounting entry. There can't be one accounting entry without an offsetting entry.
I think the more we pursue detail, accounting detail with the questioning, I think the further we get away from the redirect. So I think I'm going to sustain the objection and ask you to proceed if you have any other questions.
Thank you, Your Honor. I think that would take care of the rest of my questions then. Thank you again, Dr. Blank. Thank you again, Your Honor.
Thank you, sir.
Thank you, Mr. Dubois. I believe we have reached the point where we can excuse the witness. I will say before we do that, that Dr. Blank, I believe I forgot your proper salutation earlier, so please forgive me. And also, Mr. Haverly, please forgive me on the original first objection. I had some coffee at lunch to get through this afternoon and was just very eager. So I ask your forgiveness. Unless there's any, is there anything else, or may we excuse the witness?
I have no further questions for this witness. Thank you, Dr. Blank.
Thank you, Dr. Blank.
Yeah, thank you, hearing examiners. Have a good evening.
Thank you so much. Okay, it is 3:55 in the afternoon, and we have two witnesses left. I think if we move with clarity of mind and take a deep breath, we'll take a break here and get through the rest of the afternoon. Mr. Lee, is a 10-minute break acceptable to you?
Yes, Your Honor.
Okay, everybody, let's take a 10-minute break.
Hearing Examiner Schaefer.
And Ms. Hurst, go ahead.
If I might, excuse me, I just wanted to let parties know that I've had an opportunity to review the 5 offers of proof that were submitted in the Dropbox, and they are non-conforming. So I will try for the 3rd time to put on the record exactly what I ordered the first 2 times. With regard to 1.2.2 35M offers of proof. An offer of proof for the record may be made and shall consist of a statement of the substance of the evidence to which objection has been sustained. The Commissioner presiding officer may require offers of proof be submitted in writing in question and answer format. That is what I ordered the first 2 times. Question and answer format. I guess, for example, if a particular attachment was denied entry into evidence, the question would be, the attachment X was offered and was denied. The answer format would be, we believe it should have been admitted because. Again, the 5 offers of proof submitted in the Dropbox by NM Area and NEE are not compliant. Therefore, if you can't make them compliant before the end of this hearing, then you're just going to have to file them and ask that they be added to the record. Again, I think I've been pretty clear about exactly what my rulings were. Okay, thank you. And I believe, thank you, Hearing Examiner Schaefer.
Yes, see you back here at 4:10, everybody.
Madam Hearing Examiner, may I say, this is Peter Gould.
Does this need to be on the record, Mr. Gould?
Yes, it does.
All right, go ahead.
Madam Hearing Examiner, we apologize. We had thought that the evidence that had not been admitted, that was the matter that needed to be in question and answer format, and the 3 exhibits that we had asked for, not asked for, but offered in offer of proof, were in question and answer format. So clearly we misunderstood that instruction. Say, for instance, the first was, of course, the corrected direct testimony of Mr. Walters. But we'll go back in and do our best to comply by the end of the day with that specific instruction. So it was not an intentional disregard for your order. We had understood the testimony itself that was the contentious testimony, or the denied testimony, needed to be in question and answer form. Similarly, the 2 depositions were clearly in question and answer form. So that I instructed our office assistant to prepare it that way, and I apologize that I misunderstood your instructions, and we'll take care of it.
Mr. Gould, if I may, I don't believe it's a misunderstanding of the instruction. M states that an offer of proof for the record may be made and shall consist of a statement, the substance of the evidence to which the objection has been sustained. The commissioner or presiding officer may require offers of proof to be submitted in writing in question and answer form. So I think the hearing examiners were clear on that point.
If I may, this is Marilyn Nassi. I just want to say that the other times that there's been offers of proof in the record, especially when there has been, it's about testimony and the testimony itself is the question and answer form, then all we had to do, the last time this happened, to be honest, it was not on Zoom, it was in person, and we literally just handed them the document, and that was sufficient if the document itself was in question and answer form, and all we had to say on as a cover, we didn't even have to say a cover, we just wrote offer of proof on it, and that's all we did before. So I know that this has been the experience of, that's what Mr. Gould has done before in person at the PRC, and that's what I have done. So I'm sorry, what I want you to know is that this wasn't some intentional disobeyance of your order.
No, I don't think that was, I don't think that we thought that it was intentional.
Okay, thank you very much. Just wanted to make that statement for the record. And it is late in the day, but we'll do our best to comply. Thank you.
Thank you.
Okay, we're in recess till 4:10, everybody. Thank you so much.
We've got 2 witnesses left in 50 minutes to get it done, so. If you wanted to like get, I guess, Osborne or something, yeah, do that. I know. They were pregnant on my ass, they were all just coming in. Yeah, but I finished back, I think it up for probably, come on. Out here, but now it gets here, it's cold, man. Fuck you.
That's not, no. May first, November, I just have to pay what's $15 a paycheck. And then from November 2026 to until it was 18 months, I can pay a Cobra Beach.
I can hear somebody talking in the background. So just in case, you might want to mute.
Miss Beatles, are you there?
Okay, everybody, it's 4:10. Let's go back on the record. Mr. Rossi, I believe you have a witness to call. Is that correct?
Yes, thank you, Mr. Hearing Examiner. Staff will call Naomi Velasquez.
Hello.
Hi, Naomi. Ms. Velasquez, excuse me, sorry.
That's okay.
Mr. Lee, when you're ready to swear the witness.
Miss Velasquez, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, ma'am.
Thank you.
Good afternoon, Ms. Velasquez. Can you please state your name for the record?
Naomi Velasquez.
How are you employed?
I'm employed with the New Mexico Public Regulation Commission as a senior public utilities economist.
Did you prepare testimony for this proceeding?
I did.
Do you have a copy of Staff Exhibit 5, the third corrected prepared direct testimony of Naomi Velasquez?
I do.
Are there attachments in this exhibit?
Yes, there are 5 attachments.
Okay, we'll get them and get to them in a moment. Let's talk about your testimony first.
Okay.
Is this your sworn testimony in this matter?
Yes, it is.
Is the testimony in Staff Exhibit 5 prepared by you?
Yes, it was.
If I asked you the same questions today, would your answers be the same?
Yes, they are.
Are the answers true and accurate to the best of your knowledge?
Yes.
Now let's talk about the attachments. Are these attachments, well, first, as this is the third corrected, was there an accidental mistake that happened in the original filing back on September 27th?
Yeah. Would you like me to touch on the second filing or the current one?
Well, I wanted to cover a little bit about what happened now that we're on the third.
Okay, so the exhibits didn't have the affirmation and we corrected that. In addition, I think my exhibits, they didn't change, they just were inadvertently included. But they are correct now.
They are correct now.
Yes.
At any time, did your testimony ever change?
No.
Okay. And you were talking about at one point we had a version that accidentally left out the interrogatory questions of a couple of them and then the affirmations on a couple of them. Is that correct?
Yes, you are correct.
Okay. And so this version, the exhibits 1 through 5, does it include all of the affirmations of the witness that sponsored the exhibit?
Yes.
Okay. At this time, staff moves to admit staff exhibit number 5, the third corrected direct testimony of Naomi Velasquez.
Thank you, Mr. Rossi. Are there any objections to admitting staff exhibit into the record? Hearing none. Staff exhibit number 5, the prepared direct testimony of Naomi Velasquez, is admitted. Thank you, Mr. Rossi.
Thank you. I have no further questions for this witness. She is available for cross-examination.
I believe that joint applicants were the gas company in order of, in following our order. Mr. Haverly, Mr. Dome, do you have any questions for this witness?
Mr. Hearing Examiner, this is Brian Haverly, and on behalf of Amera and NMGC, I have a very few number of questions for this witness.
Please proceed, Mr. Haverly.
Good afternoon, Ms. Velasquez. How are you doing today?
Good afternoon. Good, and you?
Oh, I'm doing okay. Thank you for asking. Would you please turn to page 10 of your direct testimony?
Yes.
And let me know when you get there, please.
Okay, I'm there.
You have a table halfway through that page. That's table NAV-2. Do you see that table?
I do.
Could you explain to me what that table is?
Sure. It's an average forecast of historical data that was provided in NAV Exhibit 1 of shared services that are currently provided to New Mexico Gas.
Okay, I'm sorry. I thought you said historical, but I'm looking at, it says 25, 26, 27.
Oh, my apologies. So I thought you wanted me to explain how I came out with it's a forecast. So it's an average forecast of the historical data that was provided in NAV Exhibit 1 in a discovery request.
And then if you would go to your exhibit N, this is part of your exhibit NAV-2, page 2 of 3. And I have it as PDF page 35.
Okay, I'm there.
And could you please explain to me what this information is?
Yes, this is the New Mexico Gas forecasted of what their shared services are meant to be, and it looks like they have their budget already set for 2025 through 2029.
And those numbers are different in that exhibit than what you have in your table NAV-2. Is that correct?
I'm sorry, Mr. Haverly, could you start your question again, please?
I'm just a little tired. Yes, sir. The numbers in this staff exhibit NAV-2, page 2 of 3 are different than what are contained in the direct testimony, page 10, table NAV-2. Is that correct?
That's correct. But I didn't base it. Well, yes, you're correct.
Would you please go to page 19 of your testimony, Ms. Velasquez?
Okay, I'm there.
Line 14. Yeah, line 14, page 19. Starts off with, importantly, comma, these issues have led staff to believe that this transaction is, comma, at best, comma, one denoted by status quo, dash, relative to the existing relationship with Emera, dash, with benefits to NMGC and its ratepayers being nebulous under the most optimistic of scenarios, period. Did I read that correctly?
Yes.
And is that your testimony still today?
Yes.
Okay.
Well, no, apologies. I felt some things have changed within the application where some of staff's recommendations have been accepted, I believe, in rebuttal testimony and bench requests. So I think if there were some things that were accepted in this application, that would change.
Okay, so is it that now staff believes that there is some benefit and it's not just a status quo?
Some items have changed that staff do see beneficial.
Mr. Hearing Examiner, I have no more questions for this witness. Thank you very much, Ms. Velasquez. I appreciate your time.
Thank you.
Thank you, Mr. Haverly. And I believe that joint applicants have requested 20 minutes. Mr. Dubois, will you be leading this cross-exam?
Your Honor, Rick Alvidrez, and I'll be conducting the cross-examination of Ms. Velasquez.
Thank you, Mr. Alvidrez. Please proceed.
Thank you. Good afternoon, Ms. Velasquez.
I seem to not see you on camera, Mr. Alvidrez.
Couldn't see you either.
My apologies.
I think you just have to switch the mic to your computer, Mr. Alvidrez.
Thank you.
There you
go. So I don't know if this is any better now that you can see me, but good afternoon.
Good afternoon.
So, you're the second to the last witness, and, if we're efficient here, we can maybe finish up pretty soon. So I'll try and be efficient. I want to ask you to follow up a little bit on the table NAV2 on page 10 of your testimony. Mr. Haverly asked you a couple questions about it. Do you recall?
Let me get there. I'm sorry. But I do recall, but I'd like to get to my testimony so I can look at it. Yes.
And he asked you to contrast it with the estimates that Emera had provided in terms of the forecasted expenses for shared services on staff exhibit NAV1 page, NAV2 page 3. Do you recall that?
Yes.
And can you your estimates are considerably lower than their estimates, right?
Correct, but I'm assuming you're referring to the 12 million cap. When I looked at the 12 mil, or when I recommended the 12 million cap, I took both factors into consideration. It wasn't, my main focus wasn't just my forecast.
Okay, let me ask, you said you took both factors. What factors are you talking about?
I looked at New Mexico Gas's budgeted requests and also at my numbers. And that's when I came to my conclusion of the 12 million cap.
And how did you derive your numbers?
My numbers are derived by an average of historical data.
So am I correct that you looked at historical data and then added an inflation factor?
You'd be correct.
Okay, and the inflation factor was 2.7%?
It's 2.1 or 2.11.
2.11%, I'm sorry. And are the historical numbers that you looked at the ones that are on the table up above?
Let me get to my exhibit.
Okay.
So the historical data was based off of the data that was provided in Exhibit NEV1. Looks like it's 2 of 5, JA Exhibit NEE 25, page 1 of 1. In addition, I looked at the annual report. I pulled the annual report shared services that were submitted in 2024.
And your calculation is simply basing it on an inflation factor of 2.11%, correct?
That would be correct.
Okay. All right. Why do you not agree with the forecast that Emera provided?
I wouldn't say I don't agree with it. I just believe that with the transition, there should be cost savings and those should be recognized within the next rate case. It's not a disallowance, it's a safeguard.
Okay. So as I understand it, what you're proposing is a limit of $12 million until the next rate case. Is that correct?
A safeguard. That's correct.
Okay. So isn't it true, however, that there wouldn't be any either increase or decrease based on shared services until there's a rate adjustment after the next rate case?
With regards to rates are current. I believe they went into effect October of 2024. So you're correct in that, although there may be some cost savings that should be recognized as a long-term benefit to ratepayers.
And that would be done in the next rate case, correct?
That's correct.
Okay. So let me have you look at the recommendations that you have on page 24, beginning on page 24 of your testimony.
Okay, I'm there.
Okay, and you're aware that as part of the joint applicants' response to the third bench request, that they have committed in number 5 of the additional regulatory commitments to collaborate with staff to prepare a CAM within 6 months. Okay. Let me ask, does that satisfy your condition there?
Yes, and my condition is to submit a draft within 90 days after close and a final CAM, a cost allocation manual to the commission within 6 months. But you're correct in that.
All right, and if we move down on page, I'm sorry, same page, but line 13, it said staff recommends that in the next general rate case, NMGC provide testimony and supporting documents showing all 20 positions have been relocated to New Mexico. Did I read that correctly?
Yes.
And have you looked at the bench request 1, the response that the joint applicants filed, and specifically number 11?
I'm gonna pull that bench request up just so I can look at it. But I did see in rebuttal testimony that New Mexico Gas agreed to that.
Correct. And did that satisfy your proposed condition there?
Yes.
Okay. And moving down on that same page at line 22 and spilling over onto page 25 to lines 1 and 2. There you say staff recommends the commission deny the JA's request to establish a regulatory asset. Staff believes these actual costs should be recovered in the next upcoming rate case application. Did I read that correctly?
Yes.
And are you aware that the joint applicants have agreed to waive their request for a regulatory asset as requested?
Yes, that's my understanding.
And that's reflected in the joint applicant's response to the first bench request at item number 11, or item number 6.
Clearing that one up. Yes, you're correct.
All right. Thank you very much. Those are my questions, and thank you, hearing examiners.
Thank you.
Thank you so much, Mr. Alvidrez. Hearing examiner Hurst, do you have any questions for Ms. Velasquez?
I do. Thank you, hearing examiner Schaefer.
Thank you.
Good afternoon, Ms.
Good afternoon.
Velasquez. How are you?
I'm good, and you?
I am well, thank you. Appreciate you asking. Have you been listening?
Yes.
To the testimony of the other witnesses?
Yes, hearing officer.
And I guess I just wanted to ask, just to follow up, Mr. Alvidrez was just showing you some items that joint applicants had responded to in the first bench request. Had you seen that document before?
Yes.
And you had a chance to review it?
Yes.
And were some of the items that joint applicant now agreed to provide in joint applicant's response to the bench request, did they address some of the concerns that you had?
They did.
And if we look at your testimony, I know specifically you have on page 24 of your testimony, your conclusions.
That's correct.
And can we say that your first recommendation has been complied with?
Yes. In regards to the CAM?
Yes.
That's fair to say. Yes.
And your fifth recommendation regarding a regulatory liability? No, that's a different regulatory. The sixth bullet.
Yes.
Has that concern been assuaged now? It's my understanding from the testimony that they've offered to withdraw that.
Yes, that's my understanding.
So that concern would be assuaged?
Yes, that's fair to say.
Okay. But what about any of the other four of your six?
Well, I believe the supporting document with the 12 positions, I believe that was in bench request, or it was in rebuttal testimony that they agreed to that.
The 20 positions?
Yes. And that was just asking for additional supporting documentation to ensure that those 20 positions do come to place, and that's in the next rate case. The 12 million cap, no,
I supported Dr. Bryce Adelis's recommendation of a severe weather fund, a regulatory asset or regulatory liability in case of potential tax savings. And that would be it.
Is that typical? Is that required of the other public utilities?
I don't believe it was, but my thought or I analyzed it as what the benefits would be, and if there are any benefits, the commission should decide how to disperse those benefits.
And did you put a dollar, potential dollar?
I didn't. I'm not a tax accountant. I believe this would need to be reviewed by a tax accountant, and it can be complex. But I didn't put a dollar amount on that. You're correct.
How would staff review that? Is there anybody on staff that has the expertise of tax accounting?
No, but I do believe we may have some consultants who have been really helpful in assisting staff with that. I know we do have a CPA on board who may be helpful with that also. But staff could find the resources that they needed to bring a recommendation. Yeah.
Okay. So we still have three of the six that that, as far as you know, joint applicants haven't complied with, right?
Yes.
Of your recommendations. So does that mean that as far as your vote on the staff team, you're still recommending that the acquisition not be approved?
I believe we recommend, I recommended to be approved with those recommendations in place. It is a joint decision, though. It would be amongst all of our team members to discuss it to have a final decision on it. But with all of the items I recommended, those, as long as those were met, I would be okay with recommending it be approved.
Okay. And your area of expertise is accounting?
Yes, that's correct.
And I know in your testimony, you have indicated that one of the areas that you're testifying to has to do with the general diversification plan, correct?
Correct.
I wanted to, and that testimony begins on page 14 of your pre-filed direct, correct?
Correct.
And pursuant to the general diversification plan rule 17.6.450, also known as rule 450, correct?
Correct.
You indicate on page 16, beginning on line 10, there's 12 requirements under subsection 10, correct?
Correct.
How does staff assure that those 12 requirements are complied with?
Well, staff goes through the application and in each subsection reviews the GDP and ensures that they met the requirements.
And to the extent there are any subsequent filings with regard to a company's GDP, how does that occur?
I couldn't testify to that. I don't believe I looked into that.
Well, I'm just wondering if there's any class 2 transactions or class 1 transactions that occur, are are the utilities required to file those with the commission?
I couldn't say. I don't know.
Well, for example, in your testimony on page 21, when the question posed at line 11 and 12, does staff believe the joint application meets the requirements as defined in 17.6.450.10C? And you're saying yes, they've provided the testimony that they'll adhere to all the laws, including all relevant commission rules, regulations, and orders. The company will fulfill all reporting obligations related to Class 1 and Class 2, which will assist the commission in monitoring efforts. That's your testimony, Ms. Velasquez, right?
Yes, and I believe that's what was stated within the application under the GDP.
Right. Well, I'd like to know if they are saying that they will fulfill reporting obligations, then I'd like to know how that fulfillment would occur here at the commission. Whom do they file it with? Who looks at it? Do you know?
I don't know who looks at those reports.
I think that's all the questions I had. Thank you very much.
Thank you.
Thank you, Madam Hearing Examiner. Mr. Rossi, do you have any redirect for the witness?
I do not have any redirect questions. Thank you.
Thank you so much. Ms. Velasquez, thank you for all your time and effort in preparing for today and your participation, and you may be excused.
Thank you.
Thank you, Ms. Velasquez. Mr. Rossi, I believe you have the honor of bringing our last witness to our hearing. Is that correct?
You are correct. Staff will call Felicia Hohola.
Thank you. And I don't believe she's been admitted. I don't see her here in the waiting room, Mr. Rossi.
I'm sure she'll be logging in shortly.
Okay, thank you. Madam Hearing Examiner, do you have any alert that Ms. Hohola is in the waiting room?
No, I will check. I do not.
Okay, well, let's see if you can make contact with her, Mr. Rossi, and we'll give you a few minutes.
Thank you very much. Yes, it looks like she's misplacing the link. We're resending it.
Okay, thank you.
Oh, let's see. Mr. Rossi, while we're waiting, how soon do you think you're going to get the response to bench request 4?
I apologize. I do not know the answer. I have about 30 unread emails. Many of them include that. Other people have been working on it while I've been doing direct examinations.
Okay, thank you. Hearing
Thank you.
Examiner Schaefer.
Yes, I believe we have a staff witness with us at this point. Ms.
I'm
Hohola,
sorry, Judge, I can barely hear you. I believe we have staff witness.
with us at this point. Mr. Lee, when you're ready, would you please swear in the witness?
Ms. Hohola, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Please proceed, Mr. Rossi.
Thank you. Good evening, Ms. Holhola. Could you please state your name for the record?
Felicia Jojola.
How are you employed?
I am employed by the New Mexico Public Regulation Commission as a public utility economist.
Did you prepare testimony for this proceeding?
I did.
Do you have a copy of Staff Exhibit 6, the corrected prepared direct testimony of Felicia Holhola?
I do.
And is there an attachment to your testimony?
There is.
We'll get to that in a moment. Let's first talk about your testimony. Is this your sworn testimony in this matter?
It is.
Is the testimony in Staff Exhibit 6 prepared by you?
It is.
If I asked you the same questions today, would your answers be the same?
They would.
Are your answers true and accurate to the best of your knowledge?
Yes.
Now let's talk about Staff Exhibit FSJ-1. Is that the only attachment to your exhibit?
Yes, sir.
Okay. That attachment, it was previously corrected. Was the correction only the interrogatory and the affirmation attached to it, or verification?
Yes, sir.
Okay. Was there any correction to your testimony?
No, sir.
Okay. That attachment FSJ-1, is it the joint applicant's response to New Mexico DOJ third set of interrogatories? Specifically, it is very long, so I can't find the number, 3-14. Is that correct?
Yes, sir.
And it includes the affirmation of Mr. Baudier. Is that correct?
Yes, sir.
At this time, staff moves to admit Staff Exhibit number 6.
Thank you, Mr. Rossi. Are there any objections to admitting the corrected prepared direct testimony of Ms. Holhola into the record? Hearing none, it is admitted. Thank you, Mr. Rossi.
I have no further questions for this witness. She is available for cross. Thank you.
Excellent. I believe that New Mexico Gas has reserved 7 minutes, and if I'm not mistaken, I believe I saw Ms. Hopper come to the podium, so to speak.
You're correct. Good afternoon, Mr. Hearing Examiner. We have no questions for Ms. Holhola.
Thank you, Ms. Hopper. Next on the list is joint applicants who have reserved 10 minutes. Would the joint applicants like to ask this witness any questions?
Yes, Mr. Examiner, Dana Hardy. I just have a few questions for Ms. Holhola.
Thank you, Ms. Hardy. Please proceed.
Thank you. Good afternoon, Ms. Holhola.
Good afternoon.
I just have a couple of questions for you. With respect to staffing, you recommend that the joint applicants agree to maintain the current staffing level for 5 years, correct?
Yes, ma'am.
And the joint applicants have agreed to that, right?
Yes, ma'am.
And you also recommend that the joint applicants agree to maintain New Mexico Gas Company's headquarters in Albuquerque, correct?
Yes, ma'am.
And the joint applicants have agreed to that recommendation as well, right?
Yes.
And then at pages 11 and 12 of your direct testimony, you recommend several additional commitments to ensure that there is no recovery of the acquisition premium. Is that correct?
11 and 12. 11 is the acquisition premium. And 12, I believe, includes some wording for transition costs. Yes, ma'am.
Okay. And the joint applicants have agreed to your recommendation, correct?
Yes, ma'am.
And you agree that the commitments discussed in your testimony are beneficial to New Mexico customers, right?
The commitments are beneficial. They're also protections.
And you state in your testimony that the commitments will help keep rates fair, just, and reasonable, right?
As far as them not recovering the acquisition premium and transition cost not being recovered, yes, that will keep them from affecting rates.
Thank you. Those are all of my questions.
Thank you so much, Ms. Hardy. Madam Hearing Examiner, do you have any questions for this witness? I believe you're on mute.
On mute, Judge.
Thank you. Contrary to Mr. Rossi's salutation, I don't think it's evening quite yet, Ms. Ahola. So I'll say good afternoon.
Good afternoon.
How is it to go last?
It's rough. I'm nervous.
Okay. Well, I just have a few questions for you. And just to let you know, when the hearing examiners are asking you questions or the commissioners are asking you questions, it's not cross-examination. It's examination. We're just trying to find out information for the record. And also, whenever a witness testifies, if you don't know the answer, a lot of witnesses are afraid of saying, I don't know. And I've always found that I don't know is a fine answer, as opposed to someone either giving an answer they're not comfortable with or speculating. So I just give you that guidance to hopefully make you less nervous.
Thank you.
Your area of expertise, Ms. Wahola, is accounting, correct?
Yes, ma'am.
And your position here with the commission is as a utility economist, correct?
Yes, ma'am.
And so you indicate in your direct testimony that you have reviewed the purchase and sale agreement, and that also you are summarizing commitments by BCP applicants to ensure proper service at fair, just, and reasonable rates with respect to the acquisition premium, costs, transaction costs, annual reporting requirements, and Class 1 transaction requirements, correct?
Yes, correct.
So maybe you can shed some light on who and what, who files what, and who among staff looks at it. Okay. So if for example, and you're testifying with regard to the GDP which you reviewed, correct?
Yes, ma'am.
And there are certain reporting requirements under the GDP in Rule 450, aren't there?
Yes, ma'am.
And when those filings come in, whether they're Class 1 or Class 2, do they get filed with the commission proper with the records, or are they just sent to staff?
From my understanding, the Class 1 and Class 2 transaction reports are part of the annual report. So they're an attachment to the annual reporting that the utility files with the commission.
So you don't recall seeing any Class 1 or Class 2 notifications separate from the annual report?
No, ma'am.
And when that annual report comes in, it's filed with the commission?
Yes, ma'am.
And who looks at that?
That I don't know.
As part of your job duties, do you look at it?
I can't say that I mean, I think there would be times that we would look at it. I know that for filing my testimony, I did pull the annual report to familiarize myself with what was in the annual report.
Are there other times that you know of that that somebody on staff would look at it?
Not that I can think of offhand right now.
The requirement to file the annual report, all public utilities have that requirement?
I believe the annual reporting is covered.
Did you say under Rule 610?
I want to say 610, but I do also want to find it in my testimony. I know there are a few different ones that apply to different types of utilities. Yes, Rule 610 is for natural gas companies.
But you don't know that there's any designated person among staff that's their job to make sure that the utility filings that are required on a periodic basis, that those are actually made?
Not that I'm aware of, no, ma'am.
Or any person, let me shake off some dust and suggest to you that in times past, there have been staff members assigned to particular utilities, similar to the composition of what you have on your staff team now. So there was an accountant and an economist and an engineer and an attorney that were all assigned to a particular utility. And it wasn't necessarily case specific. In other words, they didn't actually have to have a pending case, but that was their area of responsibility. Is there anything like that now?
Not that I'm aware of, no, ma'am.
Okay, so you're not just assigned to New Mexico Gas Company as part of your job duties?
No, ma'am.
Okay. And further on your testimony, on page 13, you talk about reporting and the annual reporting, right?
Yes.
As couched in terms of Mr. Baudier's testimony and the joint applicant commitments, correct?
Yes, ma'am.
And further on your answer to that on page 14, again, the question posed on page 13, line 12, does gas company agree to annual reporting as part of this transaction? So annual reporting doesn't just mean the annual report, does it, Ms. Fajola? And by that, I mean, are there other kinds of reports that you know of or that you think are important for gas company and joint applicants to file that might not be included in an annual report?
I might miss the first half of that question. I believe my internet connection went unstable for a little bit. But my understanding of your question is if there are any other reports that I feel should be filed.
Right, or you can identify for the commission other than those reports that are filed in an annual filing, that you believe gas company and joint applicants should be required to file or continue to file.
From my understanding, the one report that will, if the transaction were approved, the one report that will no longer be filed is what is the Canadian version of the SEC 10K, since it won't be publicly traded. I did research that somewhat to see if there was any type of report similar that a private equity company would file, and I didn't find anything. So I would have to say no, there's really nothing that I can think of that I would recommend to be filed other than what I've already recommended in my testimony.
Did you hear my questions for Mr. Tupler regarding WRA witness Sabuco's recommendation for additional reporting requirements?
I did listen to that part, but I would need for you to remind me exactly what his recommendations were.
Did you review Mr. Sabuco's testimony?
I did, but again, I feel like I've seen so many different testimonies, I kind of need a refresh.
Well, did anything you hear today that when Mr. Tupler and I went through the requirements as set forth in Mr. Sabuco's testimony, was there anything, many of those factors that perhaps Mr. Tupler didn't think was important for his purpose that you thought, oh, that might be good for another purpose?
Nothing comes to mind that I took note of that I felt. I can't say that there isn't something out there that exists. I just don't have that knowledge.
Okay. So your recommendation at page 16 of your testimony, do the commitments made by joint applicants meet the requirements for Class 1 transactions? You indicate your answer at beginning at line 13, and you're saying, yes, they've agreed to provide access to their books and records, specifically as outlined in commitment number 41. The commission and its staff will have access to books, records, accounts, or documents of the affiliates, corporate subsidiaries, or holding companies pursuant to 62.6, 17, and 62.6, 19. What do you think would trigger the need for the commission and its staff to have access to the sources set forth in your testimony?
I'm sorry, again, that question was what would trigger my inclusion of their
Right.
acknowledgement?
Well, yeah, exactly. I mean, you're saying that this is an important commitment, right?
Yes, ma'am.
So I want to know why I mean, I know having access, they're saying, hey, if you ever want to look at these, you can look at them. So my question is, when would staff want to look at them?
I believe in the event that there was a class 1 transaction, and we maybe found costs to change significantly, I mean, that would be a time that maybe we would want to look at that.
Just trying to judge the importance of the commitment. I mean, I realize it's a requirement, but if staff isn't actually going to utilize it, I'm just wondering how important that commitment is. That's what I'm trying to gauge.
I think in relation to costs, anything related to cost is of importance, just to ensure that ratepayers aren't paying for things they shouldn't be.
And I don't necessarily see it in your testimony, but perhaps you can point it out to me. One of the requirements under Rule 450, I believe, has to do with a management audit, doesn't it?
That is not in my testimony. I did not cover that portion.
Do you know whether or not that's a requirement under Rule 450?
I do not know.
Well, from the accounting perspective, are you familiar that early in the case there was a request for a management audit that was declined?
I do recall that early on.
From an accounting perspective, do you know what things might be of value to the commission? If the acquisition was approved and at some point the commission wanted to have the company conduct a management audit?
I don't see why that wouldn't be beneficial. I mean, I think just the reassurance, but in all honesty, I don't know if it's a regular requirement in this type of case. So I really don't feel like I could answer that.
Okay, and just so the record's clear, 17.6.450.10, Class 2 transactions, approval of GDP plan. Item C, says the commission shall approve the general diversification plan if it contains the above information in detail acceptable to the commission, and if the commission finds that such approval is in the public interest. Approval is in the public interest if the commission finds that the level of investment appears reasonable and that it appears that the utility's ability to provide reasonable and proper utility service at fair, just, and reasonable rates will not be adversely and materially affected by Class 2 transactions and their resulting effect. comma, and if the utility represents and the commission, comma, based upon such representation, comma, finds that. And then there's a list of 8 factors. And in those 8 factors, in addition to the books and records being kept separate and the commission having access to books and records, and item 3, the supervision and regulation of the utility pursuant to the Public Utility Act won't be hindered, diminished, impaired, or unduly complicated. Then it goes on, not paying excessive dividends. And then the requirements that the public utility not without approval of the commission regarding loans, purchase debt instruments. 6 is all comply with all rules, regulations, etc. 7 is when required by the commission, the utility will have an allocation study, parenthetical, which will not be charged to ratepayers, in parenthetical, performed by a consulting firm chosen by and under the direction of the commission. And number 8, when required by the commission, the utility will have a management audit, again in parentheses, which will not be charged to the ratepayers, in parentheses, performed by a consulting firm chosen and under the direction of the commission to determine whether there are any adverse effects of Class 2 transactions upon the utility. So that's where the management audit comes in, Ms. Hohola. Did you look at that section at all?
I believe I did read over that section, although it wasn't something that I covered in my testimony.
Well, again, based on your knowledge and expertise in accounting, I'll just ask you again, what do you think might be important to be included in this kind of management audit, and to be provided to the commission?
I don't really have any recommendations on what I just really didn't look into that, so I just don't feel comfortable coming up with something off of the top of my head.
Okay, and that's fine. Do any of the other do you recall whether or not any of the other staff witnesses testified with regard to factor 8, the management audit?
To the best of my knowledge, I do not know. No, ma'am.
Oh, okay. I thank you very much. Those are the questions I had for you.
Thank you.
Hearing Examiner Schaefer.
Thank you, Hearing Examiner Hurst. Thank you, Ms. Velasquez. Mr. Rossi, do you have any redirect for this witness?
Ms. Hohola.
Sorry, Ms. Hohola, it is 5:11. Sorry about that, Ms. Hohola. Mr. Rossi, do you have any redirect for Ms. Hohola?
I do not have any redirect. Thank you.
Thank you, Mr. Rossi. Well, if there's no redirect, there's no recross, right? So I think that will do it. Thank you again, Ms. Hohola, for all your time and energy in this case, and for your patience in waiting to be heard today. You may be excused.
Thank you.
Thank you so much.
Very well. I believe that concludes the evidentiary presentation from staff. Is that correct?
That is correct. Staff has no further evidence to present. Thank you.
Very well. Thank you. Thank you, Hearing Examiner Schaefer. I think we just have a few cleanup items procedurally, that having had the opportunity to go back and review my notes, and with regard to the exhibits, I had a question for joint applicants. The joint applicant exhibit 1A, that's the confidential version of the application and exhibits. Did joint applicants exhibit 1A include the confidential version of bench request 3, 4, 6, 8, 14, 15, 16B, 16C, 16D, and 16H?
Madam Examiner, yes, Exhibit 1A. This
Ms.
is Dana Hardy.
Go ahead,
And
please.
thank you. Exhibit 1A is Mr. Baudier's confidential testimony, and it includes the responses to the bench request that were confidential.
All of them.
Correct.
Yay. Okay, so that was my question on that. And this may be premature, but I'll go ahead and ask it. Parties know that I issued bench request 4 to staff regarding staff responsibility for review and structure of how of how those filings are reviewed and by whom generally. And hearing examiner Schaefer added the federal filing component to that. When that comes in, parties will be advised of that. And I'm wondering if parties are willing to stipulate that, as the other bench requests have been, that those is there going to be an objection to those being admitted in the record? Are people, so that's kind of where I am. Mr. Friedman, are you going to talk to me about this?
Yes, Madam Hearing Examiner. I just want to let you know we are finalizing our response to that bench request as we speak, and we plan on getting it to you this evening.
Okay.
Hopefully shortly.
Okay. Very well. And I realize that you may not want to waive your opportunity to look at it, and I don't, that's fine if if parties are gonna want to wait for that. So that was the second thing that I wanted to talk about. And then the other thing I wanted to talk about was briefing. And as Ms. Nanasi, you want to talk about briefing?
No, I want to
Okay.
talk about something else.
Okay. You want to talk about something else?
Yes.
Okay.
I can barely hear you, Miss Nancy.
I'm sorry. I said I want to talk about something else. Thank you.
Okay. Anybody have any suggestions on briefing times that they think are appropriate? Does anybody want to volunteer that, or should hearing examiner Schaefer and I just issue the order? Mr. Domi?
Madam Hearing Examiner, we have exchanged a few emails about this, and I don't think we have agreement. But
Okay.
we have been consulting, and some dates have been thrown around.
Next week?
No. We've been talking about something. Well, I don't want to speak because we haven't reached the agreement, ma'am.
All right. Well, then what I guess I should I don't know. What do you want to do, hearing examiner Schaefer?
Well,
let people email us on Monday.
yes, I'm personally, and I think it's just a good thing for the commission and any tribunal for the parties to come to their best agreement possible, and to stipulate. And so I think maybe Monday or Tuesday, if depending on your preference, Madam Hearing Examiner, for the parties to send us whatever they can agree to, and then we can take it under advisement.
Okay. Why don't we say close of business on Monday? Parties can email each other and, and then send something jointly, or parties can send an email separately saying, there's no way I can agree to that, and here's what I propose.
We
Okay.
can do that, Madam Hearing Examiner.
Very well. I mean, I can tell you that, and obviously we'll issue an order, a briefing order. And, similar to, we're gonna have some specific things. And I think we're probably gonna put a page limit on it too. Just because,
Madam Hearing Examiner.
hundreds of pages of briefing, considering the voluminous record that we have. I think the parties have made their points in the evidentiary record, and so I'll just leave it at that. Mr. Domi, you wanted to say something else before I go to Ms. Nanasi?
We have been discussing a little bit about a page limit today, and we've also been talking about how many briefs would come from each side, whether the parties would file one brief per side or not. So we've been thinking about all those things, Madam Examiner.
Okay. I appreciate that. Ms. Nanasi, what would you like to talk about?
Just to be fair, I think Mr. Alvidrez might have something to say about these topics, because I had a different topic.
Okay. Mr. Alvidrez, are you on the same topic?
I'm on the briefing topic, or at least it's related to the briefing schedule.
Okay.
As you know, under the rules, we have deadlines to submit proposed corrections to the record, and we've been getting daily transcripts from Mr. Lee, who does an excellent job. But what we often do in larger cases, in my history with the commission, is that we set the deadline with the opening brief.
Yes,
That way the parties have been through it and it gives people time to look at.
yes, and I actually found that in a briefing order. And was going to include that in the briefing order, but it's good for you to let the other parties know that. Okay. Mr. Friedman, are you going to talk to me about briefing?
No, I was going to ask you a question about the bench request, so I can wait.
Okay. What do you want to know about the bench request?
So I was curious because now that we're after hours and PRC staff probably aren't available to file it formally, if you and hearing examiner Schaefer would like us to informally send it to you and the parties and then formally file it on Monday with records.
I would like for you to send it to everyone, and I would like for you to put it in the Dropbox.
No problem. Thank you.
And you can file it and you can file it either, I don't know if you send it in after hours or if you can just file it on Monday. But no, I'd like parties to get it as soon as they can. Okay, thank you.
I'll do that.
Okay. Mr. Yard, do you have a briefing question?
Yes, ma'am, I do.
Okay.
I just heard the exchange between you and Mr. Alvider as regarding the corrections. I just didn't understand how that practically worked, and I wanted just some clarification on that.
Well, basically, what I had seen in prior briefing orders and what he was alluding to was that the corrections, you know, when parties file their corrections to the transcripts, that they usually, the deadline to do that is usually included, or has, I won't say usually, has been included in the briefing order, and it is made concurrent with the day the brief is filed. So I think it gives you an extension of time to file corrections to the transcript.
Madam Hearing Examiner, and maybe I'm just not following this. If the corrections are on the date that the briefs are due, how can I rely on the citations to the transcripts if I'm filing it on the same day? That's the concern I had.
Yeah, that you make a good point. Well, because the corrections, I guess the corrections don't actually get admitted until the recommended decision is made.
And I'll take a look at the rules, but my understanding was the corrections could be substantive, they could be just typographical, but they don't get certified until Your Honor makes that decision, correct?
Under 17.1.2.34, C, corrections. Suggested corrections to the transcript or record must be offered within 13 days after the transcript is filed, except for good cause shown. Such suggestions shall be in writing and served upon each party, staff, the official reporter, and the presiding officer. Failure to timely file suggested corrections without good cause constitutes a waiver. 1, objections to the suggested corrections shall be made within 13 days from the filing of the suggestions. The commissioner presiding officer shall, with or without public hearing, determine what changes, if any, shall be made to the record. 2, if no objection is made to the suggested corrections, the presiding officer may, in their discretion, direct that the corrections be made in the manner of taking them. D, citation form. When referring to the record in briefs or other documents, staff and the parties shall cite to the transcript using pagination. Dun, 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 dun. So there's a process for making corrections, Mr. Yar. And basically, I think back to my prior explanation, this may give the parties a few extra days. If briefs are going to be longer than 2 weeks from now, then it's going to give you more time. But as you can see, there's a process when suggested corrections are made.
Understood, Madam Hearing Examiner. I just wanted to make sure I was clear on that we would get the corrections and that would be all resolved and final, and then we would have the time to write our brief.
Nope, that's not the process.
So, and not to belabor the point, and I'm not trying to stretch this out, Madam Hearing Examiner, if there's a substantive, just for examples, if there's a substantive issue that we find with the corrections, we have 13 days to log our objection. At that point, you would take it under advisement and make the final decision. I don't know how that works if everything's going to be done on the day the briefs are due. And I don't know what the objections are going to be until I see the transcripts and see what the joint applicants have identified as being something that needs to be corrected.
And I don't know that I would agree with your characterization of some substantive correction. Normally, corrections to the transcript are pretty de minimis, Mr. Yar.
Okay.
They are references to, page numbers, or I can't say I've ever seen a substantive one, except when the corrections offered are trying to change the testimony that the witness actually made at the time, which I've never allowed.
Okay.
Okay.
I'm glad I asked. I didn't understand it. Thank you for the clarification, ma'am.
Mr. Dome, are we still on briefing?
No, ma'am.
Okay, I thought you were going to volunteer next week again.
No, ma'am.
No. Okay, Ms. Nanasi. What procedural matter shall we talk about?
I filed an emergency motion to file an interlocutory appeal. And so I'm wondering if in it, I asked for you to hold the record open. It's clear that you're going to have to hold the record open at least till Monday, because the PRC's response to your bench request won't be actually filed till then. So I'm wondering if you, if you wanted to say anything about that, about holding the record open until that decision has been made about whether you would allow appeal or not.
I saw something had been filed, Ms. Nanasi, but I can't I can't tell you that I've read it and definitely not considered it.
I think you've been a little bit busy.
Yeah, I've been trying to make sure that we've forgotten some things. So no, I won't opine on this, other than to indicate to you that I did see that you had filed an emergency interlocutory appeal.
Okay.
Okay.
And the other thing is, I hope I complied with your request, and then I complied with the rule, and I did upload. You don't have to look at this now either if you don't want to, but I'm just telling you that
You did. Okay.
I did file a new offer of proof with a cover sheet in a question and answer form with the exhibits that I want, the actual proof, and COS to the records, but I didn't do a COS to Dropbox. So I just want to let you know.
Okay, no, as long as they're in there, thank you, for your expeditious, putting in Dropbox, thank NM area for its expeditious putting in the Dropbox. Anything further, Ms. Nanasi?
Nothing.
No. Okay. All right, any other? I don't know why I have that screen. Any other?
Madam Examiner? The only
Mr.
point-
Dome.
My question is, I doubt there's going to be an objection to bench request number 4, but just you brought that up, and I was wondering what time you're going to set on whether we object or not to bench request number 4, and how you want that provided to you.
Staff just put it in the Dropbox. So perhaps parties might be able to look at it over, maybe you can let me know by noon if you're going to file something on Monday, if parties could do that. I guess it's a little unfair to ask you to do it now. Or if you want to do it now, it is 4 pages, and basically has 1, 2, 3 parts.
Staff. Bench request, not staff.
I hear someone, and I would just like to hear the judge, please.
Yep, it's Mr. Yar.
Sorry.
Who from staff is specifically required to review any other type of filing and report? As an example, for New Mexico Gas Company, it's PGAC reports. Any report that gets filed. And then they answer that. Wait, what was 1? 1 was, what staff is responsible for compliance and or review of annual reports for gas company, generally, and utilities specifically, and the 5 documents comprise the annual report. And it's Mr. Martinez. And I already said 2, and then 3 is who from staff reviews any report submitted to federal regulations, and that is also Mr. Martinez. Okay. Okay. I suggest that staff's response to bench request, 4th bench request, be admitted into our evidentiary record. Is there any objection, or is there anyone who'd like more time to review this? Hearing nothing, staff response to 4th bench request is admitted. Thank you all. Thank you, staff, for getting that in, and thank you, parties, for reviewing it very expeditiously. Is there any other procedural matter that I have not brought up that parties believe I don't know what that echo was, but I just want to say thank you all very much. It's been a long 2 weeks. I'm pleased that we finished on time. Thank you, Mr. Lee. We couldn't do this without you, and we appreciate your efforts, as well as the efforts of the parties. Please thank your witnesses. your support staff, technical staff. I think ours couldn't get along without them and couldn't do what we need to do. And if no one has anything further, hearing examiner Schaefer, anything
Yes,
further,
thank you.
sir?
Yes, just a final recognition on behalf of the commission of everybody's engagement, patience, and professionalism. Certainly none of this can happen without that. So once again, please accept our gratitude for your participation in these hearings. Thank you so much.
And I thank you, hearing examiner Schaefer. It's not very often that I get somebody to work with, so appreciate you. And if we have nothing further, we are adjourned.
Thank
Have a
you.
good